the group whip is inappropriate. And it has been, and those are the quasi-judicial roles. Now, what the committee tried to do when it was formulating its recommendations was it tried to capture that. So it talked about the quasi-judicial committees, or where a committee is making evidence-based decisions, because at least one committee, the Standards Committee, has both a policy role and a quasi-judicial role. So it will consider policies and procedures at most of the time, but then on occasions it will be called on to hold a hearing where it is acting in a quasi-judicial manner and can only act on the basis of evidence. And the fact that they must act only on the basis of the evidence that they hear and see in front of them is the reason why whipping is not appropriate, because clearly that would be taking a predetermined stance before having heard the evidence. I suggested an amendment in an attempt to reach a compromise around this, to be clear that what we are talking about is committees when they are acting in a quasi-judicial manner, whether that is what they do all the time or not. Now, I understand that there are still objections, Chair, and I think those objections, certainly the first of them, are recorded in the name of the Flintshire People's Voice.
Thank you very much. So, presumably, some of FPV. Alistair, are you going to speak about your objections to this point? Please take the floor.
Thank you, Mr. Chairman. Put simply, we are utterly unconvinced that the changes proposed here are lawful. I'm going to speak first about human rights grounds. The right of freedom of speech is enshrined in UK law. Now, that includes the right not to speak as well. And the state can only compel speech or prohibit speech in specific circumstances. Now, as far as councillors goes, being a councillor goes, there are requirements that you must speak in certain circumstances, were prescribed by legislation. So, for example, if you have an interest that must be declared, that is defined in legislation, you must declare that. You don't have the option not to declare that legally. However, those are defined in law. Councils cannot require anybody, be it councillors or members of the public, to say things except where they are granted a specific power to do so. And there is no specific power for this. There is a power for overview and scrutiny committees, so it is right and proper that it is there. It is unclear if whipping declarations appear on other committees' agendas, regardless of how noble one might think the principle is. And I do not disagree with the monitoring officer one iota when he says that whipping is inappropriate in these circumstances. But the simple fact is, it is not at all clear that the council has the power to require somebody to declare that. There is then the issue that I mentioned right at the start of this meeting, if anybody can remember that long ago, where I said that some of the wording here is going to be important, because within the local government measure, there are procedures where somebody is acting under a party whip to remove their right to vote on a committee. Is it intended to extend that to these other committees? It's not clear from these papers. That's kind of the implication from putting it on the agenda, but it's not settled. Again, it is not at all clear that this council has the right to remove somebody's vote on a committee, which is de facto going against political balance in removing a group's representation for an issue without a specific statutory power to do so. So this is unlawful, quite simply. I mean, there's also questions about how this would be applied. Are we saying, for example, that any councillor who sits in this chamber, be they Labour, Liberal Democrat, Reform or Flintshire People's Voice, who stands on a manifesto that has policies on licensing, and I think about the Labour Party manifesto for the last general election, which made a number of commitments on pub licensing, about extending licensing hours, about placing a duty on councils to consider economic growth when assessing licence applications for public houses, and to prioritise public growth. That's the over residents' concerns about noise. That's the explicit position of the Labour Party. Because councillors represent that party, are we to take that manifesto as whipping instructions on pub licensing and remove all Labour members from being able to sit on those? It's not clear, because we don't have wording in front of us. We don't have the benefit of the Local Government Wales measure, which sets out the rules for whipping on OSCs. This is, as it stands, a mess that is liable to result in this council winding up at judicial review. It cannot be taken forward in its current format. It simply can't. And it is utterly unclear what problem there is an attempt to solve here. If anybody can point to a decision where they think that a party whip has influenced a member on licensing committee or standards committee or whatever, then they're welcome to point it out, but I'm not aware of any. And so what are we trying to solve here? And are we willing to risk breaking the law to do it? It would be foolish of us to press ahead with this in its current form. And I urge members incredibly strongly not to do so.
Thank you, Councillor Ibbotson. Anybody speaking for or against that particular comment or view? Councillor Coggins-Cogan.
Thank you, Chair. My group provided some feedback. We were content with the removal of the whether committees making evidence-based decisions, political policy aims should not be taken into account. We were content with the compromise as proposed by the monitoring officer. However, you know, I am somewhat convinced by what Councillor Ibbotson is saying, and perhaps it does need further scrutiny and further advice from the monitoring officer. So yeah, that's all I have to say at the moment. Thank you, Chair.
Thank you.
So, Chair, I understand the concerns about, with the best of intentions, perhaps straying into areas of unlawfulness. What I would say is, and you'll be very familiar with this as a magistrate, there are occasions where we require people to stand down. They are not just specified within the Code of Conduct. Those of you who are on the planning committee will be aware that that the lawyers who advise the planning committee have on occasions said to members, "You've pinned your colours to the mast on this one. You can't vote on it. You can speak, but you can't vote because you appear to have predetermined the issue." This is very much in the same vein. I mean, we don't have, you know, let's be honest, we don't have a statutory framework for doing that. We've got a long list of cases around predetermination that back up that stance and that behaviour and those actions, but we don't have anything explicit in statute in relation to it. Very much a matter for members, whether you wish to try and tackle it now, whether you want to revisit it. There, Chair. I mean, that's the situation as it stands. I think I don't think I can say any more.
Councillor Priest.
Can I propose that we defer this to the next meeting? Thank you.
Because Councillor Ibbotson was simply speaking against the proposal, nothing has been moved because he's just simply arguing. Well, actually, what we've got is the move from Councillor Bibby. What I mean is he hasn't moved an amendment or anything. Yeah, Councillor Priest is in order to move deferral. There's no procedural bar to that. So if there's anybody who supports that, Chair, and seconds it, then yeah.
So so therefore, there's now a vote to consider your deferral amendment. Now, do we wish to do this by? I know we said we're going to do this all by recorded vote. but to be quite frank, I'm really conscious of time, and so therefore I would suggest we do this particular one because it's a subset version by hand. So are we all clear on deferring this or not? So all in favour of deferring this off to another time where we can take further legal information, please vote.
1, 2, 3, 4, 5, 6, 7, 8, 10, 11, 12, 13, 9, 13 in the room, 14 to 15, 16, 17, 18, 19, 20. That's 20 in favour, Chair.
Right, so people against this?
Nine, 20, 21.
So 21 against. So therefore we have to be, therefore we'll continue on.
We carry on. Yeah.
We'll continue on with this. Councillor Ibbotson.
Thank you, Mr. Chairman. I rise to make a point of personal explanation. I fear the monitoring officer has misunderstood me when he gave his advice to the chamber. I would hasten to add that I don't disagree with his advice in relation to planning committee and legal officers giving advice to members that you appear to have predetermined yourself on this, you should not vote. That is advice to members. Officers do not have the right to remove a member's vote. Obviously, if a member chose to vote regardless and in spite of that advice, they may be liable under the code for failing to take appropriate account of an officer's advice. They may also give grounds to an appellant who wishes to appeal a refusal of a planning application, or indeed a judicial review from an opponent of a planning application who's been passed. But they do not have the power to remove that vote. What is being proposed here, it is unclear whether we are granting powers to remove members' votes. And without clarity on that, it would be negligent of us to vote on it. But, you know, if we're going to get clarity on that, then whichever way this falls is materially a different proposal from what's been put before us now. And we will need time to consider that. So deferral seems like a sensible option. There is no legal way in these other circumstances at the moment, which the monitoring officer has quite rightly highlighted, but we are comparing apples with oranges here. This is a different process that's being suggested, and it seems to me to be unlawful, both in terms of wider public law and how the balance on council committees is calculated, and specifically in relation to the Human Rights Act. We are wading into a minefield without any detailed written officer advice that I would have, that I would be comfortable seeing before we wade into this. I appreciate that monitoring officer has given verbal advice. I appreciate that members will want to consider that, but mature consideration requires time to think, time to ponder, ideally having it in writing. We haven't got that. And this is a legal minefield. And so I would ask the monitoring officer for his view on what is meant by this in terms of disapplying votes, whether he considers that that is part of the whipping declarations or not. And if it isn't, what the merit of whipping declarations is. You know, if somebody declares a whip, says, oh yes, I've been whipped to, you know, vote to do this person who's up before the standards committee. You know, this person sits in the administration and I'm an opposition councillor and my group leader has told me, yeah, it doesn't matter about the evidence, just vote to do him anyway. That's clearly a whip. If I declare that under whipping declarations, what happens then? Do I just get to vote anyway? I mean, this is unclear. And without this clarity, we cannot reasonably proceed today.
Thank you. Councillor Hughes would like to speak.
Thank you, Chair. We've listened to the legal advice from the officer. And for me, this is getting like Argentina. I don't like the results, so we'll have a bit of a go again. So I'm sorry, I've listened and take the advice of the chief officer. Thank you.
Thank you, councillor Yee.
Mr. Chair, it is.
David, councillor Coggins-Cogan, last speaker on this topic.
Thank you, Chair. Could I move an amendment which would be under 13.6A1, which is on page 40, the civil procedure rules, the council procedure rules, which would be to refer the matter to an appropriate body for consideration or reconsideration. I would suggest we refer it to the Constitution and Democratic Services Committee. I can declare that this is actively going against my own interests, increasing my workload on that committee, but I think that might be an appropriate way forward and would satisfy both sides of the debate. Thank you, Chair.
But that's your proposal. Is there a second for that? So seconded by councillor Ibbott. Any speakers on that particular amendment proposal? No, so we'll go to the vote for it then. So what we're voting for is to take this back to the Democratic Services Committee for further discussion, potentially with more legal debate or maybe legal input to it, and we'll do it then. So by show of hands, so I ask now for people in the room voting for deferral away to this committee. Referral, not deferral. Absolutely right. So people, anybody for this?
3, 4, 5, 6, 7, 8. Those online indicate again, please.
It says 19, so it's lost.
Potentially.
So with the vote being as it is 19 to 12, that particular proposal is lost, and we now go.
Taking the against it, Chair.
Sorry, my mistake. And now, can we take the against votes? Got ahead of myself. Told you.
21, 22.
Don't be so personal. Right. So, so that being the case, that proposal is lost. So I think what we need to do now, there is a proposal on the table in blue, and I think we need to vote for that or not. Is that clear? So by show of hands, are we voting for the proposal listed?
Well, that would be the recorded vote, wouldn't it, Chair?
Oh,
That's the point at which we step back into recorded vote.
We did indeed. So we need to go back. We need to go back to recorded votes, sadly. So that's what.
So for clarity, we're voting for the suggested amendment, which is that the whipping declarations would apply to overview and scrutiny committees or any committee when it is undertaking a quasi-judicial function.
Right. Over to you.
Recommendation number 6. Councillor Banks. Or Councillor Bibby. Or Councillor Bithell. Or Councillor Brockley.
Against.
Councillor Claydon.
O'Brien, for.
Councillor Coggins-Cogan.
Against.
Councillor Collett.
For.
Councillor Crease. For. Councillor Rob Davis.
For.
Councillor Ron Davis.
For.
Councillor Chris Dolphin. Councillor Rosetta Dolphin. She's left the meeting. Thank you. Councillor Eastwood.
For.
Councillor Ellis.
Against.
Councillor Evans.
For.
Thank you. Councillor G. Councillor Hadfield Jones. Councillor David Healy.
For.
Councillor Gladys Healy,
For.
Councillor Hodge,
Against.
Councillor David Hughes, Councillor Ibbotson,
Against.
Councillor Paul Johnson, Councillor Christine Jones, Councillor Richard Jones, Councillor Lister,
Against.
Councillor Lloyd, Councillor Mackey,
Against.
Councillor Madison,
For.
Councillor Marshall,
Obliged for.
Councillor Mullin,
For.
Councillor Owen, Councillor Palmer. Left the meeting. Councillor Pearce. Councillor Priest. Councillor Richardson.
Against.
Councillor Rose.
Against.
Councillor Solkeld. Councillor Swash.
Against.
Councillor Thomas. Councillor Turton.
Against.
Councillor Wakeham. Councillor Wren.
The third option, abstain.
Thank you. And Councillor Coppell.
For.
Okay, so that's 24 in favour, 17 against and 1 abstention.
So indeed, so what's been voted for is the recommendation as stated in the list.
Yep.
Thank you. So we'll move now to the next one, which is number 7. Is it number 7?
We've done number 7.
We've done 7.
So we clarified the wording of how we would express the whip.
So
So we've done
10.
number 7. So
Chair, could I ask a point of order, please?
yes, please. Thank you.
Thank you, Chair. Yeah, I was hoping that perhaps the monitoring officer might be able to clarify whether, if that decision, as has just been voted for, is challenged via judicial review after being enforced, who will be responsible for defending the council at judicial review, given that councillors have just voted to bring that policy into effect?
it would be the lawyers instructed on behalf of the council. So I would be instructing council, because it's a High Court matter and I can't act in the High Court. So I'd be instructing council to defend the case.
Thank you.
Well, recommendation 10 is one of the clues. I think actually recommendation 10 we agreed, didn't we, Chair?
We did.
We did. So we then go down and it is indeed number 13.
So we're going at pace now, as they say.
We've got to. Recommendation 13, Chair, is in relation to time limits for the council. It was suggested that there be a 5-hour time limit, excluding any meal or refreshment breaks. And let me see, I think the first group that sent in their objection to this proposal was the Flintshire People's Voice, Chair.
So, Councillor Ibbotson, no doubt you'd like to stand and speak on this part?
Yeah, I understood that Labour were going to go first on this one because they're first in the papers, but I'm happy to take their place. It is quite simply the case that members of this council should turn up prepared to discuss the issues that affect the people of Flintshire. We are elected to deal with the business of the people of Flintshire, and we should be prepared to do that. Where there is business to be discussed, we should be prepared to sit and discuss it. If this is passed, as is, we will have to have additional meetings. Additional meetings scheduled outside the usual calendar, potentially at short notice, as indeed we are gathered here today, which is, I think, inconvenient for most of us. So we can either do this the sensible way, or we can do it the hard way. Personally, I'm in favour of the sensible way, and that if a system ain't broke, as it isn't at the moment, we don't try it and fix it. I'm utterly baffled by what problem this is attempting to solve, given that at present we have a situation occurring pretty frequently when we get to the current scheduled end of meetings, where we have procedural motions seeking to extend the meeting. And we have some people who vote for those and some people who vote against these. We also often have closure motions seeking to end the meeting. And we have people who vote for these and people who vote against these. All that will change as a result of this is the wording of those procedural motions. We will still have them. We will still be voting to stay here until the business is transacted. And I am glad to say, and it is broadly to the credit of this council, that whereas when we first started having these, a good number of councillors and indeed a majority of councillors would consistently vote to end the meeting such that they might go home and possibly eat some food. We have now got to a point, I shan't say go home for their tea because I know it upsets members. We have now got to a point where most members do in fact vote to continue the business, which is to their credit, and is perhaps informed by the reaction of the public of Flintshire to members voting to go home before discussing vital items to the people of Flintshire. As I say, that is not going to change. So why would we change the rules to have no real effect? All that could reasonably change as a result of this proposal is that we'd have our votes to go home not at 5, but at 4:30 instead, which I think achieves the sum total of nothing. So I fail to see how passing things to constrict business on this council further does anything except damage the council's reputation in the immediate term, given that they will be observed, that they will be enforced more in the breach than the observation. I can't see an argument for this. I simply can't. I assume that we're going to hear in a moment from the Labour group, who've also opposed this on the basis of what is a reasonable time. And I assume we're also going to hear from the Liberal Democrats with an amendment. Personally, I'd be inclined to just say, let's scrap this discussion and move on, and perhaps save ourselves some time now, such that when we get to 5 o'clock on this meeting, because I am increasingly certain that we will, we have less before some members might be able to indeed go home for their tea.
Thank you. I'm going to ask Councillor Hughes now, because you were listed actually by error. You've spoken by mistake, but it's not your fault, of course. But you may have a comment on this point. So Councillor Johnson, sorry, my mistake. It's in the...
Thank you, Chair. Thank you, Councillor Ibbotson. Sometimes you've got to go back to basics. And the first basic is, what is the purpose of a full council? Well, I read it in the Constitution. Very, very simple. It's to transact the business of the council. So what's proposed down here, it's not a measure to restrict discussion, but to refocus the purpose of the full council meetings to those which are listed in the Constitution. Doesn't stop discussion, just make sure that that discussion is focused and specific. So these proposals still mean that there is plenty of time for debate and discussion, and contrary to the means of what other people are saying, what I get told, other members I know told me as well, that any reasonable person would actually agree the length of the time that we've actually allocated here is more than adequate to go through the business of council. Otherwise, the reputation of Flintshire, and I can assure you this reputation is now spreading quite widely across North Wales and beyond, is that we're a council that just likes to talk and talk and talk and talk. Just likes to make resolutions when we need to be seen to be taking action. And that's my point. Our council has to be taking action, not just talking. Further, I believe these proposals build on the resolution that was passed in March 2025. It's not about trying to walk away for anything. It's about recognising that we have staff here who are working these meetings. And you know, I'm looking at the chair across there, and some of us might wander and read the papers that you got here. Some of you might even quickly go and check your iPads or your iPhones or whatever. The chair of this meeting has always got to be there, as has the chief executive and has got the chief monitoring officer, as the team over there. They are working, focusing for 7 hours. 7 hours without really that kind of a break, a little focus. I don't think we're doing a service to them. We've got to think about the good people who work for this county and give so much to it. So let's cut out the flamboyant language, because we don't need to do it. Let's decide that where 5 minutes to go and give our spiel is far too much. And like myself, I'm going to finish now, because 2.5 minutes is as much as I feel I need to make my case. Thank you.
Thank you, Councillor Johnson. It's noted in the papers, in fact, that there is further update, as it's called, with a position from the EEL group and the Labour group. Do you intend to move that as an amendment? Do you have a proposer?
So,
and a seconder before we start?
Yep, it's down there. The update, if you've not got a further update, it's a meeting should continue to have a start and finish time. Each individual agenda item should allocate a time for discussion, which is agreed by the chair and the Democratic Services Manager. The Flintshire County Council meetings start at 10:30 a.m. and finish at 5 p.m. maximum. An extension beyond this time is subject to the chair's discretion, and that any unfinished member questions or notice of motions must be carried forward automatically and given priority at the next ordinary meeting. Such business will not be subject to any further ballot or selection process and will count towards any limits on items of business that might exist, such as those of notice of motions and questions. That's it. That's simple. Lots of time to talk.
Well, thank you very much, Councillor Johnson. So therefore, it's now time for people who would like to speak against, for, Councillor Coggins-Cogan.
Thank you, Chair. My group did put forward an alternative proposal on this. I think our concern is, it has been highlighted by Councillor Ibbotson, is that it's the wrong solution to the problem. Part of the problem, unfortunately, is a breakdown at group leaders. It used to be the case when I first started the council that decisions that were made at group leaders would continue in the meeting. So we could all be assured, essentially through back channels, this item of business is going to go through, this item of business will be contested. What's happening now is that we have a decision in group leaders to agree on something, and then by the time we get in the chamber, that agreement has broken down. I would suggest that is the reason why meetings are taking longer and longer and longer. Also, this proposal, unfortunately, will not change anything, or because there are mechanisms within the Constitution, as there have to be, to allow the meetings to carry on anyway. So it's sort of a bit of a waste of time, really, because all we're going to be doing in future is having votes on to abandon this procedure rule at future meetings. Then there'll be a recorded vote because, you know, one side will be trying to embarrass the other side and blah, 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 blah. I just don't see the point in it. I think it should just be abandoned. The chair already has discretion to end the meetings at a set time. I don't think, I just don't think this is, it's not worth the paper it's on, because it's going to be so easily defeated. And I think what it does, it will reinforce a perception, I'm not saying it's the reality, the perception in the public's mind that as soon as it turns around at 5, we're all clocking off and going home. That's not correct. And I fully appreciate that people do work harder, and the officers have my sympathy for being here listening to us. However, this is not the solution to the issue. The solution is better agreements before we get into this chamber, so that non-contentious business can be conducted quickly. Contentious business, we can have that full debate. This is not the way forward. Thank you, Chair.
Thank you very much. Councillor Richardson online. Thank you. And apologies for the delay.
Thank you, Chair. I'd just like to point out, we've just had the hottest 4 weeks we've probably ever had. and we're debating a 5-hour working day as such. Our street scene operators are on. It's not the shop floor; they're on the street 9 hours a day, I believe. I think they do their 36 hours over 4-day shift, so that equates to a 9-hour day. 10:30 for me. It's a lie in. Why are we starting at 10:30? Why can't we start at 9 or 8? I just don't get it. Why, as a council, we think a 5-hour day is the maximum we can do, when we've got, you know, ladies and men pounding the streets, collecting bins. They're getting a lot of stick because something isn't working properly, and I just find it a little bit of an insult to them that we can't manage more than 5 hours a day. Thank you.
Thank you. I'd now like Councillor Pearce, because you've been waiting for quite a while. Thank you.
Thank you, Chair. It's interesting to hear the debate. My first question is, well, who would propose 5 hours? Starting at 10:30 a.m. with 30 minutes lunch, that means the meeting ends at 4 o'clock. And that's probably around the same time that the schools are closing. We're here to do business, not to watch the clock. 5 hours every 6 weeks or so isn't arduous. If it is, I think you should perhaps go and do something else. Now, this is the public sector against the private sector, where I worked for quite a number of times. And I know there's people in the room that worked where I did at Airbus, and our day used to be 7:45 start. We sometimes would finish at 6 if the work needed to be done, and we just got on with it. Now, if we talk about the planning committee, I've sat on 7-hour planning committees to get the job done, and we've done it without any moaning. We just gone on and did it. I've been on environment scrutiny, where we've had 7-hour meetings. We've got on, we've done the business. And Councillor Johnson talks about talk. Well, are we here to debate things? Most of the talking does tend to come from the opposition, because we have a lot to say. Okay? And we have a debate and we talk to ensure we make sound decisions. And if Councillor Johnson is quite happy with his 2 minutes, 30 seconds, well, that's good enough for me, because, to be honest, you know, I've heard enough by then. So we're looking at the private sector versus the public sector. We do an 8-hour day. 9 till 5 is an 8-hour day. Councillor Richardson's right. Why can't we start at 9? Yeah, we did 9 till 5, and an hour for lunch. You've got your 7 hours. That's a normal day for the people in the outside world. We are here to represent them. They expect us to represent them, and that's what we are doing. So I don't agree with this, that there shouldn't be a limit of 5 hours. And even the amendment that's come through from Labour finishing at 5, that is still only a 6-hour day. It's not arduous. We're here to do a job. Thank you, Chair.
Thank you. I mean, I heard what you're saying. In terms of discussionary time, I'm obviously aware of the time. We've had debates about time limitations. We've had debates about the effects on families and home. We've had the debates on council offices. And it'd be interesting to note that actually most officers were here this morning, 6:30, 7 o'clock, just to note. So interestingly, I know there's more debate to be had about this, but I intend to call this to the vote now. So the papers are there to read. Have you got a point of order, Councillor Ibbotson?
Mr. Chairman, I've been indicating to speak for some time.
Absolutely right.
And I have not spoken on the amendment. And so I would be grateful, given that the amendment itself, particularly point 4, which is quite unclear, there are serious outstanding questions about how that works. Because I think there might be a typo in it even. So if we're voting to include things in the Constitution, I would be grateful for the chance to at least interrogate that.
No, I think we're going to carry on. I understand where you're coming from, but I'm just very conscious of time and proper process. Thank you very much indeed. So we now will go to the vote. So this will be, as we've discussed in the past, a recorded vote for the statement on the paper in item 13.
Okay, thank you, Chair. Yeah, it's the further update that was moved by Councillor Johnson. Councillor Banks.
Could I just clarify, Chair, that there's no mention of 5 hours in what we are accepting here?
There is no mention of 5 hours, Chair. That was the original proposal from the committee. What has been moved is the amendment by Councillor Johnson, which is that county council meetings should start at 10:30 and finish at 5, with all the rest of it.
Thank you, Chair. For
Councillor Bibby. Councillor Bithell. Councillor Brockley.
Against.
Councillor Claydon.
Blind. 4.
Councillor Coggins Cogan. Against. Councillor Collett.
4.
Councillor Crease.
4.
Councillor Rob Davis.
4.
Councillor Ron Davis.
4.
Councillor Chris Dolphin. Rosetta's gone. Councillor Eastwood.
4.
Councillor Ellis.
Against.
Councillor Evans.
4.
Councillor G. Councillor Hadfield Jones. Councillor David Healy.
4.
Councillor Gladys Healy.
4.
Councillor Hodge.
4.
Councillor David Hughes. Councillor Ibbotson.
Against.
Councillor Paul Johnson.
4.
Councillor Christine Jones.
4.
Councillor Richard Jones.
4.
Councillor Lister.
Against.
Councillor Lloyd. Councillor Mackey.
Against.
Councillor Madison.
4.
Councillor Marshall.
Blind. 4.
Councillor Mullin.
4.
Thank you. Councillor Owen. Councillor Owen. Councillor Palmer. You still got Ted? No, we've lost Ted, haven't we? Councillor Pearce. Councillor Priest. Councillor Richardson.
Against.
Councillor Rose.
Against.
Councillor Solke.
Against.
Wash.
Against.
Councillor Thomas. Councillor Turton.
Against.
Councillor Wakelam.
Against.
Councillor Wren.
4.
Councillor Coppell.
Against.
So that is 18 against and 24 in favour, Chair.
So that means that the... Please, you have the floor.
Mr. Chairman, I draw attention to Council Procedure Rule 21(2), which says any motion to add to, vary or revoke these council rules of procedure, which is what we have before us now on this item, unless required by law, which this change is not, or on the recommendation or recommended by committee, which this change that we've now got is not, because it's by the amendment here, will, when proposed and seconded, which it now is because it's part of the substantive, stand adjourned without discussion to the next meeting of the council. So by the reading of our own procedure rules, this item, as a result of this amendment, must now be adjourned to the next meeting. Those are the rules. They may not be practical. I might not like them. You might not like them. The officers may not like them. The cabinet may not like them. But Dems is the rules. So rather than have a vote on the substantive now that we have had a vote on the amendment, This part must be adjourned as the as the procedure will say, without discussion to the next meeting of the council.
Thank you, Councillor Ibbotson.
Chair, if that were correct, then the blue items that we've already agreed on and for which all councillors in the room voted would also have to stand adjourned. Chair, we would end up in a never-ending loop whereby this council could do nothing if it was not recommended to it by the Constitution Committee. That would remove any discretion or autonomy or sovereignty on the part of council, Chair, which as the senior body within the council is clearly would clearly be incorrect. The committee has made its recommendation. It's up to council whether it wishes to accept it. A number of people, Chair, and a number of groups have put forward suggested changes to this as part of the process of settling and agree or settling whether they agree with those recommendations or not. It would absolutely neuter the role of council if all it could do is rubber stamp something referred to it by the Constitution and Democratic Services Committee, Chair.
Steady. You have a second point of order?
The monitoring officer has given his advice, which of course I respect, but there are 2 points which I think deserve further exploration. The first of those is the idea that following this procedure rule would neuter the council. It wouldn't. It just means that we have to take time to consider it rather than have changes which are submitted late without members having proper time to scrutinise and then putting them into our constitution immediately. That's fine for every single motion except constitutional changes. And this is in here for a reason. It does not mean that we can't make these changes. It just means that we have to do them at the next meeting rather than at this one. The second thing is that even if one takes at face value the idea that this does neuter council, even if one agrees with the idea that it is unworkable, and I must admit I have a great amount of sympathy with the monitoring officer on that point, it is the rule. And we have to follow the rules. There's no doubt about that. If our rules are unworkable, then we need to change those rules perhaps, but the rules are the rules. And we must follow our procedure rule. If we don't follow our own procedure rules in doing this, then any decisions that we make in disregarding those rules of procedure will potentially be invalid and subject to judicial review. So, Mr. Chairman, I hold that you must adjourn this to the next meeting.
Thank you. I'll take advice on that from the monitoring officer.
I'm not sure what else I can say, Chair. All that's happened is the same point of order has been made again, Chair. I can repeat the advice that I gave to the previous point of order if you'd wish.
No, I mean, from a legalistic point of view and on an extensive, obviously equally extensive knowledge, as our colleague on the left-hand side has got of the Constitution, we're saying that this is a proper way to proceed. And if it's a proper way to proceed in your professional opinion, then that's how we will proceed. So a vote has been taken, a conclusion has been arrived at, and so I would ask you to reiterate what the solution to the answer to that vote was. Thank you.
So, Chair, we've had examples of this previously. Whenever a document comes to, and I appreciate we're talking about documents rather than changes to the procedure rules. We bring documents here. We bring things to council for council's opinion. It has been discussed. It has been discussed at length. And you have recommendations. It must surely be always possible for council to make those amendments. You can take the view that as soon as any amendment comes, you have to defer it off to another meeting, Chair. But Chair, I think that rule was intended for something that we will get to slightly later on. Which is a situation where something is moved de novo, slipping into the Latin, without any prior consideration. So we will have at some point, Chair, the proposal from the independent group around chairing committees and about the term of chair for committees. And I have indicated to councillors when I sent it round yesterday that this is something that's brand new. You're not just amending something that's been sent to you by Constitution Committee. This is brand new. That will need to be stood over. I think that was the circumstance for which that rule was intended, Chair.
Right. So, as we were speaking, a vote had been taken, a recorded vote has been taken on this subject matter, and the answers are now in public view. So we can now describe what the solution is to that vote on this particular amendment raised by Councillor Johnson.
So Councillor Johnson has moved the amendment. We're at the point where council needs to take a vote on whether to make it the substantive motion. That's the procedural point in the committee, Chair, where we're at.
So what are you going to say now? Point of order or something? No?
What are you going to say?
What are you going to say?
Mr. Chairman, I was rising to speak to the new substantive because a further amendment has been moved. I have not spoken to it, nor to the new substantive. As I say, I think there might well be a typographical error in there, which changes the meaning of it. I think we should be cautious before injecting those into the Constitution. With your discretion, Chair, I should like to proceed and speak to the item under discussion.
Please do.
Thank you, Mr. Chairman. I would note that the clock appears to be starting at 1:30 when I have 5 minutes. I would first encourage members to look at point 4 here. Any unfinished member questions or notices of motion must be carried forward automatically and given priority at the next ordinary meeting. Such business will not be subject to any further ballot or selection process and will count towards any limits on items of business that might exist, such as those on noms and questions. Now, this gets into late amendments proposed later on in this meeting. And so members will have to bear with me when I make reference to those that are yet to come. But the general thrust of this is there is an intention by the groups proposing this to restrict the number of questions and to restrict the number of motions that councillors may bring. And what this says is, if we haven't got to motions at the last meeting, no new motions can be put. And it's worth adding that what this means is that if a meeting closes before a motion, or indeed the limit of motions or the limit of questions has been put, those cannot be put in the new ones cannot be put in future. So say for the sake of argument that there are a full complement of questions in for one meeting and members vote to close that meeting before those questions are asked. So we get to questions and somebody moves a procedural motion and says, we're closing the meeting at this point. The meeting closes. No new questions can then be put for the next meeting. And so this could go on forever. No new motions can be brought. And so this could go on forever. There is an effective block through this on any motions or questions, which can be exercised by a majority administration in this council. That is fundamentally undemocratic. Now, I'm assuming, perhaps charitably, that the typographical error in here is around will count as opposed to will not count. Because to say that things are carried forward and then there is a block on proposing new things would seem to conflict with the whole subject to ballot bit in the sentence previously in the sentence. So which is it? If it's not subject to ballot, then presumably it's additional because the ballot will still take place. If it's not, then what's it getting priority over? So, as I say, this is very, very unclear. And obviously, it prejudges that we are going to vote to neuter the ability of members to bring business to this council, be it motions or questions that affect the people of Flintshire. But this, as I say, gives an effective block to an administration on the opposition challenging them, on the opposition asking them questions. And if an administration votes to ban themselves being asked questions by the opposition, what kind of administration is that? I think that this is frankly dangerous to a level that we haven't seen before. And I know that I get up and talk about how democratic standards are slipping in this council most meetings, but this is something else. I mean, I think that quite frankly, this is the most insane thing we have yet to see. So the question is is what they've written here what they mean, or is it the opposite of what they mean? We need to know this before we proceed. I mean, frankly, the idea that if questions are banned, given that motions could be requisitioned for, but questions can't, if questions are banned on this vote now, on the substantive, which we're about to have, when that is very arguably procedurally defected because of the earlier mentioned 21.2, this is going to be subject to judicial review. So take extreme care. It would be negligent of us to vote to pass this dog's breakfast of a proposal. And I hope that members will not be that negligent when it comes to the recorded vote in a minute. And if they are, their names will be recorded for posterity in passing what effectively amounts to an enabling act for Flintshire County Council.
Thank you, and just quiet in the room, please. Now, the next speaker is Councillor Coggins-Cogan, and then it'll be Mr. Crease, and then Mr. Dolphin.
Your Worship.
Thank you, Chair. I'd like to respectfully draw your attention to page 46 of the procedure rules, 21.2. Now, I know we've had the monitoring officer's advice. However, and with great respect, I do disagree with it because the original recommendation from the committee was to simply limit the meeting to 5 hours and preserve the chair's discretion to go beyond. That was the recommendation from the committee. It has now morphed into what we're discussing now, which is to have a start and a finish time, individual items to be allocated times, and then number 4, we're talking about member questions and noms being carried over. I think this is fundamentally a new proposal. I do not think under 13.6 it flows from the original recommendation. I would suggest on issues of the Constitution, we should take a narrow interpretation of what's in front of us, because it has such wide-ranging influence over how we conduct business in the future. So in the first instance, Chair, I would urge you to take account of 21.2, which says, add to, vary or revoke these council rules of procedure unless required by law or recommended by committee, will, when proposed and seconded, stand adjourned without discussion to the next meeting of the council. I disagree with the monitoring officer's interpretation that that would bind the council. It does not. It simply gives the council, I think, valuable and necessary breathing space upon which to reflect what's standing. We've got 4 to 6 weeks to review it, and then it comes back to the chamber and we can pass it. We've all, people's votes are unlikely to change, but I think that's what's in the Constitution and the council rules of procedure, and I do think that's what we should obey. I do not think it's an overly literal interpretation. I think it is a plain reading of the Constitution. Had the further update by the Eagle Group and Labour been less wide-ranging, I would be content that it wouldn't trigger. The Rule 21.2 would not operate. But I think because it's so much more extensive than the original proposal, I think Rule 21.2 does operate. So I would like to sit down at the 2-minute mark, Chair, and allow the monitoring officer to give his determination. And then if I may, Chair, with your discretion, depending on what the monitoring officer says, using my remaining 2 minutes to further oppose the substantive motion. Thank you.
Pass you over to the monitoring officer.
So, Chair, I will remind members about where the origin of some of this comes from. If you look to the preceding page, you will see that in March of last year, Council took a decision. Yeah, so at the beginning of paragraph 1.18 in March 2025, the Council resolved that. And you will see that the first 3 bullet points are almost, if not exactly the same, almost exactly the same as the first 3 bullet points of the amendment. Bullet point C in the original council resolution has been slightly extended to say that they will finish at 5 p.m, which actually is already within the rules in any event. It still currently says, the rules currently say that meetings will end at 5 p.m. The addition that we have here, Chair, is any unfinished member questions or noms must be carried forward automatically and be given priority at the next ordinary meeting. So specifying how a resolution that council has already passed would work.
Thank you. You have your 2 minutes.
Thank you very much, Chair, and my thanks to the monitoring officer. I acknowledge what he's saying, but I still disagree with the interpretation, because I think we should be erring on the side of caution, and I think this is, I would suggest, a novel interpretation. However, that is not to cast aspersions upon the monitoring officer's interpretation. It's just simply one that I do not share. I do not think this is something that we should allow, because I think it has an overly restrictive implication for how we conduct business. We should just oppose it. Thank you, Chair.
Thank you for the 1 minute 13 back. So I'll move on to Councillor Dolphin now.
Thank you very much, Chair. Well, Carers can be very proud of one of its members. It's the first meeting you've chaired here at the council, and it's an unusual one because there's so many recommendations. We're still on item 1 of the day, and we're over 4 hours into the meeting. And I think that says a lot about this council. Since May 23, there's been an amazing amount of disruption. The dramatic AGM of May 23. Since then, few councillors have disrupted this council, and really it's being disrupted today. We're going, is this the best use of our officers' time? Is it the best use of our time today, the way this is being laid out? We're having typographical errors brought up all the time, which could have been done in preparation before today. If you have items that you want to bring up before a meeting, quite entitled to get in touch with the officers and sort it out, instead of standing up and then hoping for a social media storm to come. That's one of the reasons we're here today, because of social media storms in the past. We've all been dragged into it one way or another. Why would anybody with a young person with a worthwhile career in front of them want to be a councillor in Flintshire today? Well, there wouldn't be any point at all, I can assure you, would there? Because they would have to spend time doing this type of thing that we're doing today. And we're not getting, well, we are getting somewhere. We're going through a process, and one by one, they're being ticked off somehow. Not everybody agrees with everything. So openness and transparency, that's something I am. That's something councillors are and people generally are. And this council is more open and transparent than any other one, I would think. It's all on social media. It's live streamed. You can see everything you want. You can pick up on a vote. You can have as many recorded votes as you want. You don't have to go through it all. It's all out there to be seen. And if it's not out there, it'll be put on social media anyway. So it hardly really matters. The votes are what they are. I don't see any in this 5-hour shift working business. Councillor Banks, we're not talking about 5-hour working meetings here. All the meeting, and then it's at a chair's discretion. It'll go on until an appropriate time that meetings are finished. It's just common sense. And if councillors can't use common sense, we're in real trouble, aren't we? Because we're supposed to be representing the people out there. So there's nothing about 5-hour shifts being brought up. I was working more than 5-hour shifts when I was in the Navy when I was 16. So don't give me any of this nonsense about 5-hour shifts. And Councillor Pearce over there, he's done all sorts of shifts, probably at Airbus, as I did. You're in work for 6, you're going home, late at night, that sort of thing. So a lot of us are old, grey-haired, and we can spend time doing this type of thing this afternoon. I don't want to. I've got other things I could be doing, but we need to move on, get through these recommendations and sort out the rest of the business, or we will be dragged back for another meeting under some clause A, item 6 of page 27 somewhere. So I would urge that we move on. Thank you, Chairman.
Thank you very much, Councillor Dolphin. Councillor Creese.
Thank you, Chair. I've got to compliment the erudite speakers that have gone before me, and I don't think I have the skills and the talent to speak in the way that they have. But I'm going to speak from a very personal perspective. The disingenuous point of view that I'm only voting to work a 5-hour shift can be negated entirely by the fact that 21 minutes past 6, the Chief Monitoring Officer sent me an email that I sat down and read. I then went to my printer and printed the documentation out, ran through it, and was really quite uncertain about some of the things. So at 20 past 9 last night, I put to one side, I had a glass of bells, and I went to bed. I got up at 6 o'clock this morning, and I sat down in front of my printed papers in preparation for the meeting, and I read them, and I read them again. And then I arrived in this building at 10 to 9 this morning and convened a meeting with my group that started at 10 past 9. We finished at 10 past 10. I entered this room at 20 past 10, and the meeting was convinced at 10:30. This meeting will continue until everybody agrees the business is concluded. It needs to be concluded. Putting forward the disingenuous view as a matter of fact that I'm working a 5-hour shift and voting to keep a 5-hour shift is simply wrong. And it's being done deliberately. It's been done purposefully, and it's been done for the point of view of social media clicks. And I object extremely to that point of view, because I know Councillor Ibbotson did time yesterday and last evening and this morning preparing. You don't do it off the cuff in 5 hours here, Councillor. You prepare, you have notes, you've done your research. So to say that you do 5 hours is a lie. To say I do 5 hours is a lie as well.
Thank you. So, Councillor Johnson's been waiting patiently as well. Apologies for the delay. Thank you. Have you already spoken?
The original.
No, we leave it then. That's okay. Okay. Thank you. So the next speaker will be Chris Bithell.
Thank you, Chair. Well, as I see it, there's an attempt here today to come back to some sort of sanity in relation to meetings of this council. We've all seen what's happened. We've all lived through it, and we've all despaired at times with it. I mean, the longer times that we allocate, that will be used up needlessly in many respects and quite inappropriately. And to suggest that we all want to get off for an early tea or whatever is again completely erroneous and quite misleading. Most of us here will be going from this meeting today to another meeting tonight of the town council or a town council subcommittee, a governor's meeting or whatever. You know, and our work does not stop really at 5 o'clock at any time. It goes on, as has been said, and we'll be deep into papers and so on, agendas for another meeting. It's completely erroneous to suggest that. I feared this particular whole process, to be quite frank, Chair, because I could see individuals of this particular council, who we all know, who will simply use this as a time wasters charter. And again, many of the meetings, as we've already seen, many of the questions put down are simple, straightforward questions, which most of us here get an answer to by picking up a phone, asking an officer directly, or sending an email to that officer and getting an answer directly. And that's the way we deal with things. And that's, as has been proved, again from a question, I think, which was pushed a while ago by Councillor Richard Jones, is the way to do it in terms of saving time, money, and officer time and money, scarce resources, which this council doesn't have. But we can all ask the questions and put them down here, every one of us. And can you imagine the size of the agenda? If we all posed our questions on a county council agenda, we'd be here not for 5 hours, we'd not be here for 5 days, we'd be here for 5 weeks. And of course that would suit certain people because they see that as being their duty and function. Because frankly, they haven't got much better to do. That's what it comes down to. And most of us are not in that position really. We need to get through the business, we need to get through vital business, which is important, and we need to reach decisions, not just drag things out as some kind of debating exercise, which some people enjoy, but serve no useful purpose. So again, this particular motion before us today is to bring back some sanity and some decorum and some straightforward direction to our meetings. Thank you, Chair.
Thank you. Thank you. And the next speaker is Carol Ellis. Thank you.
Thank you very much. Personally, I thought that 13 and 14 should have actually been put together because the 45 minutes for the break could have been incorporated within this. But what sort of message are we sending out to the public that we want to have a 5 to 5.5 hour meeting and we want to restrict the questions and notices of motion? And I agree with Councillor who says there's a lot of work that goes on behind the 5 hours, the early morning starts. It's the same for officers, they'll be travelling, members will be travelling. And I appreciate that, but it's the same in any walk of life, isn't it? If you've got a nurse who's doing a 12-hour shift in the hospital, she's going to have to travel there. And I know it's a long day, and sometimes it feels like there is no progress being made. I feel the frustration. But the message going out to the public is that we're only going to sit here for 5 hours, because why are we so special that we only can stay for 5 hours when the nurse I've just referred to is 12 hours? I'm sitting down in a nice climate controlled room when it's a hot day outside. You know, we should be here, in my opinion, until we complete the business. And it's down to us all to make sure that we actually apply to the business. If there's notices of motion, it could be really important on really important issues. And then if they're passed over to the next meeting, and that can carry on passing over. That, to me, is not what we're here for. We should be discussing important issues and not wasting time. I'm all for restricting to 5 minutes or even 2 minutes 30, perhaps, I don't know. But I think that, you know, it's what we're putting out to the public, how we appear by saying, no, we need only to do 5 hours and we've got to have 45 minutes lunch break in between that as well. Oh, and we've got to start and we've got to finish by 5 p.m. I don't want to send that message out to people I represent. I'm prepared to sit here till the business is complete. And I think an awful lot of people are. Let's start earlier in the morning. Let's have 20 minutes for lunch. But let's just get the business done. That's what I think we should be doing. It's very frustrating for the public perception of us that we just want to be here for 5 hours. That's not my view anyway, that I want to be here for 5 hours. I want to get the business done. Thank you, Chair.
Thank you, Councillor Ellis. Now, this subject has been heavily debated, so I now intend to go to the vote on this substantive. I know, I'm very sorry, but a lot of people have their hand up, so No, enough. Sorry, apologies, but we need to move on at a pace. So do apologise, but there we are. So we now oh yes, you all have the floor for your point of order.
Mr. Chairman, I have previously drawn attention to 21.2. I now draw attention to 21.1, which allows council procedure rules to be suspended if it's not conducive to the business of the council. And so we could perhaps get around this by suspending procedural 21.2. There is unfortunately within 21.1 the clause that 21.2 specifically may not be suspended. It is considered that no matter how convenient it might be, no matter how unintended consequences may mount, 21.2 cannot be suspended. It cannot be ignored. Even if we all unanimously agree that it should be, we can't do that. I would therefore encourage you again to reflect, Mr. Chairman, on whether or not this vote should proceed or whether it should be deferred to the next meeting. The plain wording of the clause of the standing orders is crystal clear that it must be deferred.
Thank you. This has been asked, to my knowledge, twice and answered twice by our governing monitoring officer, and I, as the chair, am prepared to accept that information and that advice, and we will go to the vote. Thank you very much indeed. Over to you, monitoring officer.
Thank you, Chair. So this is now recommendation 13, as it was moved by Councillor Johnson. So it is at the bottom of paragraph 1.18, I think it is within the report, so that people are clear as to what they are on what they are being asked to vote. And so, Chair, start with Councillor Banks. Councillor Banks. For. Councillor Bibby. For. Councillor Bithell.
For.
Councillor Brockley.
Against.
Councillor Claydon.
O'Brien, for.
Councillor Coggins Cogan.
Against.
Councillor Collett.
For.
Councillor Crease.
For.
Councillor Rob Davis.
For.
Councillor Ron Davis.
For.
Councillor Chris Dolphin. Councillor Eastwood.
For.
Councillor Ellis.
Against.
Councillor Evans. For. Councillor G. Councillor Hadfield Jones. Councillor David Healy.
For.
Councillor Gladys Healy.
For.
Councillor Hodge.
Against.
Councillor Hughes. For. Councillor Ibbotson.
Against.
Councillor Paul Johnson.
For.
Councillor Christine Jones.
For.
Councillor Richard Jones.
For.
Councillor Lister.
Against.
Yes. Councillor Richard Lloyd. Councillor Mackey.
Against.
Councillor Madison.
For.
Councillor Marshall.
O'Brien, for.
Councillor Mullin.
For.
Councillor Owen. Councillor Palmer. He's gone, isn't he? Yeah, sorry. Councillor Pearce. Councillor Priest. Councillor Richardson.
Against.
Councillor Rose.
Against.
Councillor Solkeld. Against. Councillor Swash.
Against.
Councillor Thomas. Councillor Turton.
Against.
Councillor Wakeham.
Against.
Councillor Wren.
For.
And Councillor Coppell.
Against.
So that's 23 for and 19 against, Chair.
This has been accepted.
That's approved, yeah.
So this is now, so the results are, as you said,
That change has been made. Chair.
that change has now been made and approved. Councillor Johnson.
Thank you, Chair. Could I reiterate my point that I made earlier on today about the timings of these meetings? I'd just like to have it on record that the last vote that was taken in this chamber was at 4 minutes past 2. It is now an hour later. I would also invite the residents of Flintshire to go and watch the last hour's meeting and feel that's how good a debate it was and whether it was a good use of their councillors' time. But my main question is that, assuming that the next issues are going to both take a similar amount of time, that does take us to at least a 5 o'clock finish, and I suspect the other issues are going to be just as contentious. We then also have the notice of motion, which again, on the patterns of today's meeting, possibly another hour again. And then we also have the political balance, which may be less or whatever. But my schematics for that are going to be at least a 6:30 finish if we carry on the same projection. So I would like your consideration during the next break, which I'm assuming is going to be coming fairly shortly, as to how we proceed and what the timings should be on that. The only thing I would go and say, and being very clear about this, is that political balance, if you go and read the Constitution and the purposes of the full council meeting, that is actually down there as one of the duties that we go and have. Thank you.
Thank you, Councillor Johnson. So the intention is to do one more item and then we'll break shortly for a refreshment stroke comfort break, and we'll take it from there. Thank you.
4 o'clock.
Councillor Ibbotson, yes.
Mr. Chairman, I find myself agreeing with Councillor Johnson. He makes a very important point about political balance. I therefore move a procedural motion to vary the order of business such that we take political balance now, given what Councillor Johnson says. I think Councillor Johnson is entirely right, and so I propose variation in the order of business.
Councillor Pearce, you have the floor.
I'd just like to point out that Councillor Johnson stood up and repeated what he said some time ago about trying to estimate the finish of this meeting and to suggest break times. I think you gave the answer previous, Chairman, that you have noted that. So I think Councillor Johnson is taking up unnecessary time that he is trying to deal with by moving us forward. Thank you, Chair.
Thank you for that. In regards to varying the agenda item, we are in the middle of a process, and I think it's my personal view is that it's inappropriate to change the process when we're in the middle of it. I understand the importance of other political balance events and how important they are, but nevertheless, I do believe that we have a process working. Call it whatever you'd like, but it does seem to. We are making progress, and I don't wish to derail that by changing tack with a different sort of head of steam. So we will continue on for a while. Thank you.
Thank you, Chair. Sorry, we were just having a discussion about the order in which to take speakers.
Thank you. Thank you.
Currently, Chair, within the Constitution, there are no limits or constraints on the questions that members can submit. There is a proposal from the committee that, as we have rules in relation to the sorts of questions that members of the public can submit, similar rules be imposed in relation to councillors, with the noted difference that members of the public would not be given and cannot submit questions in relation to items that are either exempt or confidential information, whereas, of course, councillors, you can go into part 2, which, to give it its technical term, is after the exclusion of the press and public. So councillors would be able to request confidential information, but we'd have to go into part 2 to answer that part of the question that requires the disclosure of exempt information. So, Chair, there's a number of different views in relation to this. 3 different groups submitted views. Arguing against, arguing for additions, and arguing for something that looks like a replacement, or two different groups arguing for different additions, and one arguing against the principle in the first place. Chair, we have been taking them in order. Flintshire People's Voice were the first to get all of their amendments in, or their suggested comments in, which is why we've been taking them first, because they're listed in. We're listing these in the order in which they've been taken. Now, I just saw Councillor Ibbotson saying he didn't want to speak first again. He's prepared to let somebody else speak first for occasion.
Oh, I think it's a good idea, don't you? So we'll let somebody else speak first. Agreed or not?
Yes, Mr. Chairman, with your discretion, given that we're arguing against, until amendments have been taken, we don't know what we're arguing against or for. So I'd suggest, I know it's been a while since I last spoke, But if people can bear to go without my voice a little longer, I'd suggest that you call on the Liberal Democrats and Labour first.
Point well made, and indeed, yes, ringing in my ears. So indeed, so what we'll do, we'll call upon the Liberal Democrats group to make their comment.
Chair, along with the lines of what Councillor Ibbotson has said, I think it would make more sense for the Labour and/or Eagle group to go first, because they've proposed something which I think squarely falls under a brand new innovation which has not been considered to the by the committee. So I'd like us to try and knock that out first, and then we can go back to more sensible proposals. Thank you, Chair.
So, Councillor Johnson, could you make your comments on this particular point, please?
I shall be very brief, Chair. We have, I believe, a bit of a Wild West when it comes to asking questions at full council. And that's the key point here. It's at full council. So there's nothing about stopping members from asking questions, which Councillor Bitter was alluding to there. Members are still going to be asking questions to cabinet members. They can still have questions to chief officers. They can ask questions at scrutiny. All we're looking at here is, again, trying to refocus what the function and the purposes of full council are. Now, looking at this, it's non-discriminatory, because every political group, whether you're a group of 27 or a group of 4, get the same number of questions. Non-aligned members get the questions. It's about trying to bring questions which are multiple points down to one question, a single question. It's about ensuring that within the time we go and get that questions are taken in, you know, as an order, which is not by in the order of submission or taken or given to the monitoring officer. So when cabinet members respond, and I can be critical about this as well, sometimes their responses are very, very long and they are read out. Far better if they can give you an answer in about 200 words, and then that written, a longer response is required. It can then be provided to everybody. You know, sometimes I watch these meetings, and as cabinet members are giving their responses, people start glazing over. Let's have it written down. And then subsequent to that, supplementary questions. Again, I've sat down here and I've listened to supplementary questions as if I was listening to Jack and Order. They are so long. They need to be questions. That's the word. Questions, not statements, not sound bites. Questions. So the questions, supplementary questions of about 100 words without multiple parts, trying to make sure that there's some form, some organisation to the way we go and ask questions in committee. It's not restricting the numbers of questions that you can ask, because as I said, you can ask them at lots of other different places. It's just the ones that we go and have at full cabinet, sorry, at full council, and that we don't spend huge amounts of time going through questions which could be asked just as effectively anywhere else. And as I've noticed, whenever you get a response from somebody and you want to make sure people know about it, you go to your Facebook page and you go and put it on there. Fine. So very, very simply, that's what we need to go and do. Thank you.
So on that basis then, you're proposing what you've written down on this particular event on this in terms of the further update? Do you have a seconder for that? Councillor Eastwood. So you were the first up there, Councillor Ibbotson.
Thank you, Mr. Chairman. The question about whether this is, to quote the monitoring officer, de novo, I think is absolutely crystal clear, because this isn't some minor tweak to what the committee said. The committee did consider this and actively chose to reject these type of restrictions. And, you know, Councillor Hodge, who was chairing that committee at the time, will be able to back me up on this. The committee actively recommended against this. So to say that this is somehow the recommendation of the committee or relevant to it, when the committee actively decided not to reject this, I think would make a mockery of procedural 21(2). So this absolutely must be adjourned. On the substantive issues here under discussion, I'm minded, you know, I sit in this meeting, you hear a lot of people say a lot of things, but one contribution from a member earlier today particularly sticks out in my mind when we're talking about things that the committee rejected when they tried to get it through before. A member said earlier, this is getting like Argentina. We don't like the result, so we'll have a moan again. It was the leader of the council who said that. He didn't like the result he got at the Constitution Committee, so he's having a moan again. I think on this issue, he and his group ought to take his own advice and withdraw this ill-conceived proposal. Now, I want to talk about a couple of the specifics of this too. And in particular, allow me to start with the restriction in the total number of questions. This is, frankly, a joke.
Yes, Councillor Cogan, you have the floor for your point. What is your point of order, by the way?
It's 21.2. My apologies to Councillor Ibbotson, but it does say that when it's, if we want this rule to operate, and I urge the monitoring officer to accept that the rule is operating now, we continue without further discussion. I didn't want Councillor Ibbotson's comments to possibly prejudice the decision, because by going into discussion, then it may mean that the rule won't operate. This was rejected by the Constitution Committee. It is entirely novel. It must be deferred to the next meeting. Thank you, Chair.
Monitoring officer, over to you for a comment on that statement. Or is it the same comment as in the previous statements?
So, Chair, again, we've got an amendment of a recommendation, haven't we? Because as well as imposing criteria that would need to be satisfied in order for members to move a question, there would be a limit on the number of questions that would be moved. And there is, as well as a limit on the number of questions, there's a limit on the length of those questions, and a limit on the length of the answers. Councillor Ibbotson, I think it was, he's correct though, that limits were suggested and rejected by the committee during consideration. That there was a discussion, there was a specific vote about limiting the number, and it was rejected. And you were probably there, Chair. I'm telling you something you already know.
But again, from the point of view of whether this is considered as new, untouched, unspoken about, from my sort of almost basic knowledge of things, constitutional, this is something, albeit rejected, clearly rejected at some point, had been part of a discussion. And therefore, am I right in saying that therefore, as it's been part of the discussion, albeit rejected, it's therefore not new, it's not a fresh thing? And that's a question to them, not to you. It's or you. It's a question to the monitoring officer.
Well, Chair,
be quiet.
Chair, some of that is a question of fact, isn't it? And you know, in these circumstances, those judgments fall to you rather than to me. In terms of trying to give you advice, I think I probably can only repeat the advice I'd given previously. What we're doing is this is an addition to proposals that are coming forward from the group. Whether you think it takes it too far away from that which was recommended by the committee, I can't really say.
No, but I mean, the point to my argument is because it is discussed, therefore, because this 21.2 seems to be things out of the blue, didn't know about, it's all a bit clueless. Whereas this has been
debated,
discussed.
yes.
But my question is does the key word recommendations from the subcommittee, or is it just anything that was discussed by that said subcommittee?
It just talks about unless recommended by committee. When proposed and seconded, will stand adjourned.
Okay.
And of course,
Please do carry on.
this isn't a motion. It is an amendment to a motion as well. The wording of 21.2 is specific about motions, which is, I think, probably where I say, looking for something new. That's why it's a motion rather than, it's an amendment to a motion rather than something new. That's, I think, is probably where I'm saying that's the purpose of 21.2. That's why it talks about a motion rather than an amendment.
Before we do the point of order, Councillor Creese has been waiting patiently. Thank you.
Thank you, Chair. This may not go down too well with some of my colleagues, but this is a contentious issue. It's an issue I think that merits more discussion. And I personally favour in principle the kind of structure that's been put forward. However, it's too much of a radical change to decide at this moment in time. And I would be more comfortable if more committee time was given over to a more detailed debate on the implications going forward of the proposals. So I would be very much in support of deferring this.
If you rule, Chair, that this is covered by 21.2, it's up to you.
Okay.
Because it stands moved and seconded and then is deferred. Chair, there was some discussion about whether or not this is a motion or an amendment. This is an amendment because, of course, at the beginning of the meeting, Councillor Bibby moved the recommendations, and this is an amendment to a recommendation from the committee. Everything we have been debating this afternoon is recommendations. So, Chair, if you're satisfied about 21.2, then it stands adjourned, and we don't debate it any further.
I think there's enough unclarity with this point to push this off to another time when we can think about this more clearly, more carefully. I do accept the fact there are some finer points of constitutional legalities, which at this point in time and this time of the day would be difficult and therefore probably not appropriate and also probably not the right answer for the people of Flintshire. On that point, this issue will be pushed off to another time and will be debated properly and fully by the proper people. It is also 25 and a bit minutes past 3, and I think it's a long time that we had a short break for, I suggest, 10 minutes, if that's appropriate with everybody. And we'll be back at 25:02. Please be prompt. Thank you.
Rise, please, for the Chair of Flintshire County Council. So, Chair, that was a recommendation 15. We're now on to recommendation 17, Chair, which was about allowing, at the point where cabinet member isn't present in relation to answer a question that's been posed to them, either by a member of the public or by a councillor, that they can nominate somebody else to answer the question. The other groups have indicated they support, and I think the Liberal Democrats wish to move an amendment, Chair.
Very good. So that being the case, Councillor Cockins-Croggan, can you have the floor?
Thank you very much, Chair. I would suggest this is under Rule 13.6. It flows naturally from the recommendations that have been made, so therefore Rule 21.2 does not operate. We are simply saying that the let's hold up. What are we simply saying? Oh yeah, it would be up to the person that sets the question whether they want the cabinet member to answer it or if they're happy with a substitute answering it. We feel that, you know, obviously at the moment, a major point of contention with our contention with the council's policy is the closure of 4 schools across Flintshire. When we set questions, it is of paramount importance that the cabinet member for education answers them. We wouldn't be satisfied if the cabinet member for street scene answered the questions, because a follow-up question supplementary, although we don't normally supply our supplementaries in advance, as is the custom seemingly. So we would suggest that that's just a courtesy really to the question setter, and therefore flows naturally from the recommendations made by the Constitution Committee. Thank you, Chair.
Thank you. Do you have a seconder for that? Sorry, I couldn't resist. It was a bit of levity at this point would probably be a good thing.
If I may, Chair, as this is Councillor Hadfield-Jones's first meeting, on his behalf, I'm giving him he will probably reserve his right to, if he's seconding, reserve his right to speak later on. I imagine that's what he wanted to do, just in case he wants to speak. Thank you, Chair.
Thank you very much. We have a proposer, we have a seconder. Do we have any speakers on this subject? Councillor Eastwood, thank you.
Diolch, Cadeirydd. Can I just say that I do agree with the FPV's suggestion to replace can with must. In relation to putting a time limit on when to receive a written response from the responsible cabinet member, I am just concerned that without knowing why that cabinet member is not available, then it's a bit, they could be in hospital, they could have a bereavement, they could be suffering a long-term illness, we don't know. And I think that the 5 working days or any limit in relation to when a written submission, written response is required would be unfair and potentially unworkable. It's also the sometimes technical questions are asked of the cabinet member requiring support from the portfolio team. And again, without knowing what the resource available within that team is, then how do you determine when's a reasonable response time for them? So I have got concerns in relation to that element of this alternative proposal.
Thank you, Councillor Eastwood. Any other speakers? Councillor Pearce.
Yes, thank you, Chair. I think recommendation 17, I think we have the word absent missing. I think it should say it is recommended that if the cabinet member is absent, to whom a question is directed, they can either nominate another cabinet member. Could we add that? I think that rather than another cabinet member sort of speaking, you know, perhaps their own comments, that to make it clear that the cabinet member has prepared a statement for the other member to read out, and you make it clear that you've received a statement from the cabinet member who cannot be here today. That would make it clear that one, the reason I put the word absent in, because you wouldn't want the cabinet member sitting there and thinking, oh, I don't want to deal with this, can you deal with it for me? I think it's only if the member is present, the member should answer. If the member is absent, which isn't in the recommendation, and I'm saying that it should be, then it's passed over to another member, but reads a prepared statement rather than tries to answer the question as if it was directed to them. Thank you, Chair.
Thank you very much, Councillor Pearce. Councillor Ibbotson.
Thank you. And perhaps in replying to the Liberal Democrats amendment, I might be able to obviate the need for us to speak later on the substantive. Our concern is that if a cabinet member is going to be absent, they must ensure that somebody else is able to answer if the questioner wishes to. I think the Liberal Democrat amendment would achieve that. And so if this is passed, then I think we would withdraw our objection to this section. I do think that it should remain the choice of the person asking the question. I think that the Liberal Democrat amendment is very sensible in that regard. In terms of the deadline, I do think that it is important that we set deadlines for responses to questions and indeed responses to supplementary questions when asked. I know that my colleague, Councillor Sam Swash, asked a question on notice, which the cabinet member obviously had the requisite notice for, asked this question, was promised an answer in writing, and it took more than 6 months to answer, which is, well, I am lost for words, Mr. Chairman. I'm not quite sure that's happened in this chamber before, but I am. Ludicrous, perhaps, but I'm not quite sure that does it justice. So I do think it's important that we do set a time limit in here. Nonetheless, the points raised by Councillor Eastwood are serious and merit serious consideration. I would hope that we in this chamber today can give our commitments on behalf of our groups that whatever is written in the Constitution regarding deadlines in such extenuating personal circumstances, we would all be willing to, you know, ignore the breach on that. I mean, I'm certainly prepared to give that commitment on behalf of Flintshire People's Voice. Nobody is going to be banging down the doors if somebody's had a bereavement or is seriously ill. You know, we can all agree tolerance and respect on that. Equally, I would imagine that in that circumstance, the leader of the council would reach out to the questioner or the questioner's group and say, look, you know, as the leader, I can pick this up in the interval if you don't want to wait for this person to get back. And again, you know, if that's something the leader can pick up, I'm sure people will be glad of the faster response. If they think, well, no, I'd rather have it from the cabinet member who is the specialist, I'm sure that they'd be prepared to wait. So I, in supporting the amendment written here, I am very prepared to make that commitment that should such extenuating circumstances arrive, we would not seek to enforce that. And I think that good faith agreement between members and between groups is important to rebuild some of the trust across this chamber, which has been lost in recent months. So I hope that that will be accepted in good faith, and I hope that certainly as far as we're concerned, that addresses Councillor Eastwood's concerns, which, as I say, are very valid. So that, in respect of that, Mr. Chairman, I think that summarises everything. The one thing that I would disagree with is with Councillor Coggins-Cogan's assertion that this wouldn't trigger Procedure Rule 21.2. I would hold that it does, but I suspect that on this one, you might feel that the monitoring officer's advice is perhaps more clear-cut than on the previous one. I shall make the point for the sake of making the point, but I fear I may on this one be onto a losing battle.
Correct. Right. So, Councillor Palmer, online.
Yeah, thank you, Chair. I have an issue with the word absent. The word absent implies something else. It implies that you can't be bothered sometimes, and unavailable covers that. Because if you're unavailable, you're unavailable for a lot of reasons. If you're absent, sometimes you're just absent. So I think the word absent shouldn't be used. Unavailable is adequate.
Thank you, Councillor Palmer. Councillor David Mackey.
Thank you, Chair. Just for clarity, I wanted to just let you know that the issues that we've raised, Councillor Pearce has actually included in his submission. Thank you.
Thank you. Before we get to the vote, Councillor Coggins-Cogan.
Thank you, Chair. Taking on board the comments that Councillor Eastwood has made, I'd be very happy if Councillor Eastwood or someone wanted to recommend an amendment to what we've suggested, and I imagine would accept that as an alteration. Perhaps something like the time limit would be, instead of something like 5 working days, could be, before the time of the next council ordinary meeting, something like that. If something like that were proposed, I'm sure my seconder and I would accept it as an alteration.
So, in terms of wordsmithing, as soon as reasonably practicable, that would suit.
My only concern, Chair, is that although we haven't experienced a 6-month delay, there have been times when it has gone on quite a long time and it hasn't been terribly helpful. So it would be useful if we had, I don't mind if it's a longer period of time, but it would be useful to have a time by which we can expect a response. I imagine that would also give certainty to the cabinet member as well, that they know that they have X amount of time to deal with it and it doesn't get lost. As I said, my group, we're very receptive to making this as consensual as we can.
Okay, so therefore, as a suggestion, before the next council meeting is due, would that be acceptable? Councillor Eastwood?
The next ordinary
meeting, rather.
Could be under if possible, because I'm just thinking in case it goes beyond, or they might need to just ask somebody else to respond on their behalf. If possible, we would allow for that, wouldn't it?
Understood. So
I'm happy with the next scheduled meeting, and that's reasonable.
Councillor Jones.
Okay.
So, Councillor Jones, you had your hand raised. Okay. So there is a right of reply, is it not?
No.
No.
Right
Okay.
of reply sits with Councillor Bibby.
Indeed, so there isn't a right of reply. So that means we're now going to go to the vote on the Liberal Democrat, it's hard to say at this time of the day, the Liberal Democrat amendment with the additional words that we've just discussed.
Which are before the next ordinary meeting of council.
Right. So are we clear?
Because that's what the Liberal Democrats were prepared to accept. I appreciate that others may have wished for further words, but the Liberal Democrats were prepared to accept before the next ordinary meeting of council.
Right. So that being the case, it's been thoroughly discussed and a very healthy discussion, I think, to the benefit of all. So we will now go to this recorded vote on this subject. Thank you.
So, Councillor Banks. For. Okay, thank you. Councillor Bibby. For. Councillor Bithell. For. Councillor Brockley.
For.
Councillor Gladen.
O'Brien, for.
Councillor Coggins-Cogan. For. Councillor Collett. For. Councillor Crease had to leave. Councillor Rob Davis.
For.
Councillor Ron Davis.
For.
Councillor Dolphin, Chris Dolphin. Councillor Eastwood.
4.
Councillor Ellis.
4.
Councillor Evans. 4. I'm sensing the way this is going to go. Is anybody going to vote against, or shall I just put yes for everybody? Save time. Oh. Yes for everybody.
Yes, because to be speedy, this is a good one, isn't it, really? This is an easy one.
Yeah.
So we'll just say yes.
Everybody's in favour.
Happy
It's carried,
days.
Chair.
Councillor
Councillor
Pearce.
Yeah, I just wanted to check that the word absent had been included or not, which will help decide.
Very good. So that's passed unanimously.
Yeah.
We'll move on to the next subject. Gosh, we're on a roll now. Right.
We are, Chair. Still got a few to go yet.
Absolutely.
So number 18, motion to remove the leader.
Excuse me, Chair.
So we currently have a procedure for removal of the leader. What was being added is the text that's underlined within in 11.6 on the page, which is to add the words, you can't move a motion more than once, except in the case where, and then we've got little h, the notice of motion is signed by a number of councillors, which is at least equivalent to 50% of the total number of councillors on council. I think everybody agreed with that, subject to clarification, and then the Labour Group Chair indicated that they would like to see 50% at 51%.
Okay.
So the people who who disagreed with it, Chair, are Labour.
Right. So, Councillor Johnson, would you like to make a representation?
Thank you, Chair. It's very, very simple. Going from that 50 to 51%. It is we do not feel that it is the Chair we put in that position of giving a casting vote. It's as simple as that. If you had 30-30 either side and the Chair has to go and do it, we think that it should be a majority of those of the councillors without the casting vote. That's it.
Thank you, Councillor Johnson. Councillor Pearce.
Yes, for once I'm agreeing with Labour. I also thought that 51% is just over half. But if you say had a committee of 8 and you had 50%, that's 4 and 4. You haven't got a majority there. If you had 51%, that would give you 4.08, which really is neither here nor there. So perhaps we could add it's 51% rounded up. Yep. So if we get to 4.08, which is, you might argue, well, hang on, we can't do that. So it's 51%, and the figure is then rounded up, which would give you the majority. Yeah.
Thank you. No discussions on the floor, please. Thank you. But they are useful and they are appreciated. However, just can it a bit. Councillor Palmer, you got your hand up.
Yeah, thanks, Chair. You moved on. My hand was up far before you started the next item. We didn't vote for the word absent. We voted for the Liberals amendment, not the reform amendment. There was no mention of that word. We voted for the Liberals amendment, not the reform amendment. That was not mentioned.
That's accepted, Chair.
Chair, the Liberals amendment included the word is the cabinet member is unavailable. So the sense of what Councillor Pearce was looking for.
Oh, we accepted that, Chair.
Yeah,
you did accept that indeed. David Mackey, Councillor Mackey, you had your hand.
Thank you, Chair. I think that the current wording of the third part of this is that there can only be this can only be moved once in a rolling 12-month period. And it does, in fact, this is a change of 6 months to 6 months. I just wanted to make that clear because it wasn't mentioned previously. Thank you.
Thank you, Councillor Mackey. Once again, you are correct. Well done. Indeed. So you're actually almost a sort of sub-constitutional expert guru person. Be careful, Councillor Ibbotson. You might be being caught. Who knows? And interesting, that takes us on to yourself. So Councillor Ibbotson, floor is yours, sir.
Thank you, Mr. Chairman. I welcome the contributions from the Labour and Reform groups suggesting a slightly different figure on this, but I fear that there may have been a little misunderstanding as to the effect of what we're talking about here. The chair is not put in the place of having a casting vote in a scenario where 50% of members exactly have signed, which, ignoring for a moment the implausibility of that on a council with 67, because this is about whether the motion is moved or not about the total votes cast for that. So this only impacts whether the motion is moved. And if there is 50%, then the motion is movable. If it's less than 50%, the motion cannot be moved. So the chair doesn't get a vote on whether the motion is moved or not, besides potentially being one of those members to sign the motion or one of those not. It is simply about whether the motion is moved. There is no casting vote on whether something is moved. The issue with 51% is we potentially wind up in a scenario where 50.8% of the membership of the council support removing the leader. So more than half do, but more than the arbitrary higher threshold of 51 don't. And where there is a majority to remove the leader, because the leader has been up to some misdeeds, clearly they should be removed. That's an important safeguard. If a majority think, yeah, you out, then yeah, you out. And so, 50% ensures that there is at least an evens chance of a motion passing. It is the higher threshold than the 25%, so as not to result in endless votes to remove the leader, but nonetheless reflects the seriousness that if there is a majority for removing the leader, or at the very least a good chance of it, given that not all those who signed the motion might be present on the day, not all those who oppose the motion might be present on the day. That is for groups to ensure that their members turn up. But where there is a strong chance that the leader being removed, it is important that that be possible. So 51% creates this scenario where a majority might support removal, but that not get us over the line. So it really ought to be 50%. I know we're only arguing about 1% here, and it sounds very, very minuscule, but there is an important principle difference here. So I would hope that Labour might consider withdrawing that suggestion, their suggestion on that basis. I appreciate that it's made from a well-meaning point of view, but I think in the circumstances it's best that we stick with the recommendations of the Constitution and Democratic Services Committee as presented to us, because otherwise we risk creating a potentially bizarre situation.
So,
sorry, Chair, if I don't want to delay things. If I can just add, I've been sitting here with my calculator doing maths. I'm not just looking at my phone.
Sure.
33.5 councillors is 50%. 34 councillors is 50.7%. So that's slightly more than half the number of councillors. You would need under 50, if it were 51% threshold, you would need 35. 50% would equate to 34.
Hello. Thank you. Councillor Wren.
May I suggest 50% plus one member?
That would get us back to 35, Chair.
Indeed. So,
because you can't have 33.5 councillors. Well, we can.
Probably can, yes.
But nobody's going to volunteer to be the half.
Oh, quite a time. So we're getting close to a vote thing now. So what I'm going to do is, there's obviously a discussion to be had from, and Councillor Johnson, you put this forward, this 51%. Is there any leeway in this? I know it's a bit of a haggling negotiational piece, but there seems to be an awful lot of movement for 50. What do you think?
It's still got to be over 50%. I think that's it. So is the leeway? No, I don't. No. Oh, sorry. Is the leeway, I remind you that, is the leeway, no, I think we're going to stick with the 51%. I do appreciate the issue there, but these are important issues we're talking about.
Councillor Coggins, and then that's the last debate before we go to a vote on it. Thank you.
Thank you very much, Chair. Just to reiterate, I do understand what Councillor Johnson is saying. However, and I was guilty, I think, of the same misunderstanding when I read it. This is not the vote. The 50% is not the vote. This is merely to get it on the table for us to vote. So I think a 50% threshold, I think, is adequate. And then we're talking about a separate, the vote for it would be a simple majority. But a 50% of councillors, I think that is a high enough threshold, and it does effectively give the administration a veto on whether this could be even tabled. So I would, through the chair, ask if Councillor Johnson would consider it, because it just makes sense. We're only talking, this is the initial stage of tabling the motion, nothing more than that. So I would ask the Deputy Leader of the Council to reconsider. Thank you, Chair.
Thank you, Councillor Johnson. Any last views?
Thank you. I will accept the 50%. But,
Thank you for the collaboration on both parts there. Very good. So,
sorry, folks. Don't take it. Go through with that.
right. So that being the case, then it's a technique. You're not going to spoil this, are you now?
No, don't ask.
Really? I'm just going to put this to a vote now because, oh, okay. Fair enough.
With respect, Mr. Chairman, in the papers, there is a request from Flintshire People's Voice for a change on this too, that we pass something else with it that wouldn't be in the Constitution, but would be a statement of policy. Given that we have put it in good time, and indeed before the amendment proposed by Labour, I wonder whether you might consider allowing us to move that additionally, given that we put it in. So we're not proposing including this within the wording of the Constitution, but we would like to move as an additional statement of policy as we do this, that the decision in the AGM is to appoint the leader and is therefore not impacted by these changes, which has been confirmed in officer advice. We would just like to append that as a statement of policy. So an additional resolution of the council that this does not affect that. It doesn't need to go in the Constitution. It doesn't require any wording. It definitely doesn't trigger 21.2 because it's not a constitutional change. But we would like to append that.
Chair, we can include that within the record of decisions.
Indeed. So it's clear, and my apologies for not bringing that forward. So I got too excited about going quick. But it's, but indeed, because what you're saying is indeed is actually it's part of a recordable discussion that you've had to clarify, and that's what we're here to be clear and transparent. So yes, indeed, that can happen, and therefore that would be part and parcel of this, the vote, which we do need a vote, sadly, on this particular thing, which is actually the original proposal, which would have gone green effectively with all of this discussion. So, do we still wish to have a recorded vote, or can we just say yes? Or is anybody against the idea of this concept? Anybody? Anybody online against the idea of this concept that's been discussed to date? I know this is a bit short-circuiting, but it is what it is.
We record everybody's vote for it.
So therefore, this is passed as it is. Thank you very much for those particular contributions, and we'll move on to the next point. Thank you.
That was recommendation 18, Chair. The next one is recommendation 19. This was about incapacity of the chair. We've got no provision around incapacity of the chair. We have provision around incapacity of the leader. This was an attempt to find something equivalent to for incapacity of the chair. So you'll see that with the best of intentions, we don't appear to have quite hit the nail on the head, Chair, because there were quite a few comments in relation to this. I think the first disagreeing with that with the Labour group.
Thank you very much. So that being the case, Councillor Paul Johnson, can you present your comments?
Thank you, Chair. I think there are times when we need to have very strong regulations. There are other times, though, when we have to have duty of care and some common humanity in the way we do things. And I think this is an issue for common humanity. We're looking here at people who may have medical health issues. We're then asking a group of non-experts to go and judge upon that. This can be very difficult, not just for the individual involved, but for their family, their partners. And I would like to refer this back to the Constitution Committee, because thinking about it, we have members who are young, who go and sit, like Councillor, the ever young Councillor Buckley. We have members like Councillor Coppell there, perennially young, but we also make sure that when we elect people, it's a reward, it's a recognition of the service they're given for this council. And to suddenly go and say, we don't think you are capable of this, is disrespectful. And I would not like to go to someone and go and say, whether it's my mother, my father, or whatever, I'm going to turn around and say, you're not capable to do this job. Who decides? There are other ways. Politics is about how you go and treat human beings. And I do not feel that these proposals here, especially the idea that we go and hold a special meeting to ratify that decision, I think I would like this referred back. Thank you.
Thank you. So you would wish that to go with the other item that we discussed before, to be referred to the Democratic Community Constitution, CDLC. That's your proposal, Councillor Jones. So you're seconding that. So we have a proposal on the floor, which has been seconded. Point of order or something nice? No. Okay, so that's fine. So that means we can now open the floor for discussion. So, Councillor Ibbotson, the floor is yours.
Thank you, and I appreciate the remarks made by Councillor Johnson, and I don't for one moment underestimate the good faith in which they are made. The issue is that whilst this council and whilst the named individuals are not medical experts, nobody is asking them to be. They are experts in the procedural role of the chair and whether or not that is being fulfilled. The role of the chair is significant. The chair needs to be able to seal documents for the council. Without the chair being able to carry out that role, the business of the council and the council's ability to get on with the job is liable to be impacted. There is then the question of, well, what if that happens? We're into potentially delays whilst meetings are called or scheduled meetings come up. We're into motions to remove the chair, which are going to be just as bad, which is effectively the current procedure. And we're into a situation wherein instead of this being done in discussion, it ends up being done necessarily in a confrontational manner. There is, as I say, very clear reasons behind what Councillor Johnson has said, and I don't underestimate these. But this is the recommendation of Constitution Committee, and it was this one perhaps more than any other that wasn't particularly controversial that took up the most time. Because whilst this one wasn't acrimonious like some of those on questions and motions were, this one was the subject of a hell of a lot of mature discussion. And the monitoring officer's reaction, I think, there confirms it all. It was litigated at huge length. Sending it back there when the committee has reached a settlement is not going to change anything. We got to that position after agonising over this. And that's the issue. I mean, if we look at the rationale in the papers, there's a suggestion that if the chair is not fulfilling their duties in real life, it would be sorted out internally in a group. That's not practical. I mean, you know, if any of us had a member in any of our groups who was becoming incapable, at what point do you bring that up with them internally within a group and say, you need to resign as chair? Or we need to table a motion to remove you? Relying on groups to do that is just not practical, especially in a tight council where the chair is called on very frequently to cast deciding votes. No group is going to give up that power willingly. And so I can't agree that there is a better way to resolve this. We either accept that things will be resolved in a worse manner than this, and I appreciate and I agree this is not a perfect solution, but the other options are worse. We either leave it unresolved or we resolve it in a worse manner, and leaving it unresolved is not a responsible thing for us to do. Resolving it in a worse manner is not a responsible thing for us to do. So if in referring it back to Constitution Committee, anybody here, and I mean this as a genuine plea, anybody here can stand up and say, yes, but consider this way that hasn't already been considered by this committee, then I will enthusiastically vote to send it back. But unless anybody's sending it back for something else to be considered, unless anybody else has any better ideas, this is what's on the table, and it is better than what we've got at the moment. And so, before sending it back, at least give that committee some steer as to what you want it to consider that it hasn't already. Because this was not come up with on a whim. This was, I think, 3 meetings worth of discussion this one went to, and none of those discussions briefed, to say the least. So don't just send it back to, oh yeah, it's tough, we don't want to make this decision today. If you are going to send it back with some new idea the committee hasn't considered.
Thank you. So anybody want to speak on that? Councillor Jones.
Yeah, thank you, Chair. No, I understand what Councillor Bits is saying, but I think we've got to have a bit of empathy here, as well as an assurance that the people who are actually doing the assessing are able to do that in a constructive way. So my view would be, in line with what Councillor Robertson has said, but also in line with what Councillor Johnson said, is to refer it back, but to give perhaps occupational health or HR an input into that assessment, which would seem logical, because no other person that's going to do that ability assessment is a health professional, and I think we need that. I also think that we should remove the second bullet point, because it would be really, really embarrassing to be calling a special meeting to do that. I think there's a much better way, a more human way to do that than actually that bullet point suggests. So I think it just needs a bit more. It's very practical. It's something that I understand why it got there, but I think it needs a bit more empathy and a bit more thought about who and how the ability of that person has been assessed.
Thank you. And the last speaker on that is Councillor Coppins-Coyne.
There you go. Thank you very much, Chair. My group opposes this, and I understand the reasons for it. However, the mechanism proposed here, I think, is fundamentally flawed. The issue I have is that I do not believe the vice chair should have a role in deciding the chair's incapacity. I think that creates a natural conflict of interest. I am entirely sympathetic to what Flintshire People's Voice want to achieve. I think it makes sense, but I think this should be referred back to the Constitution and Democratic Services Committee, where it can be considered. My group has proposed A to G. However, I'm not going to propose those now, because I think that's something I will take to the committee. I would just advocate, though, that this is about the chair fulfilling the functions of chair. This is not about a medical diagnosis. This is not that. So I would vehemently oppose any suggestion that we get occupational health or another sort of medical practitioner in here. This is about whether they can fulfill the role. We all know that there are people in this room who maybe me, I might be a perfectly good councillor. I could be horrendous as chair of the council. I'm glad that the chair agrees. We have some consensus in the room finally. We accept people have different strengths, and sometimes the skill set is not best displayed in the role of a chair. That's what we're talking about, and sort of a temporary incapacity. So my group fully support this being referred to the Constitution Democratic Services Committee. Thank you, Chair.
So now we have obviously inputs from various groups. We've got the proposal, which is to send this back to this Democratic Committee, and that's now to be voted upon. So we'll have to do this, as we said before, by name calling, and so to speak, calling names, roll calling, and so I'll take that back, and I'll pass you over to the monitoring officer. Thank you.
Okay, so it's a proposed deferral, Chair. So voting for would see this deferred back to CNDSC, and voting against would leave us with the situation where we have to consider adopting it or making an amendment this afternoon. So, Councillor Banks.
For.
Councillor Bibby. For. Councillor Bithell.
For.
Councillor Brockley. Was that for? Against. Okay, thank you. Councillor Claydon.
A blind for.
Councillor Coggins-Cogan.
For.
Councillor Collett.
For.
Councillor Crease has got to leave. Councillor Rob Davis.
For.
Councillor Ron Davis.
For.
Councillor Chris Dolphin. Councillor Rosetta Dolphin has left. Councillor Eastwood.
For.
Councillor Ellis.
For.
Councillor David Evans.
For.
Councillor G. Councillor Hadfield Jones. Councillor David Healy.
For.
Councillor Gladys Healy.
For.
Councillor Hodge.
For.
Councillor David Hughes. For. Councillor Ibbotson. Councillor Paul Johnson. Councillor Christine Jones.
For.
Councillor Richard Jones.
For.
Councillor Lister.
For.
Councillor Lloyd. Councillor Mackey.
For.
Councillor Madison.
For.
Councillor Marshall.
Obliged for.
Councillor Mullin.
For.
Councillor Owen. Councillor Palmer.
Where's he gone?
For, but don't forget Councillor McKeown.
Oh, Councillor McEwen, sorry.
Thanks, Gareth. For.
Thank you. Councillor Pearce. Councillor Priest. Councillor Richardson.
Councillor Richardson.
For. Yeah, okay. For some reason, even though you come off mute, we couldn't hear you then, but I saw you say for, so thank you.
Yeah, it's definitely for. Thank you.
Oh, there you go. Suddenly found your voice. Councillor Rose.
Against.
Councillor Salkeld. Councillor Swash.
Against.
Councillor Thomas. Councillor Turton.
For.
Councillor Wakelam. For. Councillor Wren. For. And yourself, Councillor Coppell.
For.
So that is 37 for and 6 against, Chair. So it stands referred.
So this subject will be referred to the next meeting of the Constitutional Democratic Committee. Thank you very much. So we'll move on to the next item.
So that is a blue. It was 21. I don't think we agreed it at the outset because there is some dissension, Chair, about whether a notice of motion should include the name of the mover. As I said earlier, it can't include we can't insist on a seconder, wouldn't want to, should it include the name of the mover, Chair. And whilst originally this was an objection from the Liberal Democrat, rather reluctantly, Councillor Coggins-Cogan said he'd go with accepting the name of the mover, and it was actually the Flintshire People's Voice that didn't want to see the name of the mover included, Chair.
So you're in agreement?
Yeah.
As remarkable as that may seem, Chair, I am.
I didn't say agreeable, I just said an agreement. So, Councillor Ibbotson, what do you have to say?
I think that the Liberal Democrats made an utterly convincing case before retreating from it. Far be it from me to accuse them of doing so in a typical manner with the Liberal Democrats. It's all right, I didn't mention the coalition word. The point made in point A at the top of page, we don't have page numbers, but the top of the page that everybody knows that I'm talking about here, unnecessary barrier to a valid motion being accepted, any evidence of harm or confusion arising from current procedure, that relates in the first instance to requiring both the mover and the seconder, which is what this recommendation actually is. Notwithstanding the monitoring officer's advice, the motion as moved says the mover and the seconder. There is then the point B, which says that it's better that members read motions without predisposal or predetermination. Now, as I said at the start, Flintshire People's Voice are proud to stick our names to what we propose. We are quite keen that people know that when we're standing up for the residents of Flintshire, it's us that are doing it. But there are motions that come before this council which are perhaps more nuanced than the normal run-of-the-mill ones. Where calm a consideration without prejudice as to who they're coming from does make sense. And as I say, having been uncharitable to the Liberal Democrats earlier in my contribution, I shall now attempt to redeem myself with them by again referring to the medical cannabis motion that they brought. And I must commend them on that, because what could have been quite a circus became one of, I think, absolute consensus and unanimity in this chamber. It is perhaps the shining example that proves the rule that this council is normally a circus. It is worth noting that mature, informed consideration in advance can be harder to achieve when people's initial opinion on reading a motion is coloured by who is proposing it. And I think we can all be sanguine about our own prejudices here. We don't try and cover them up very much in the rest of the debate, so let's not pretend now there's some people in this chamber who don't like each other very much, and that's fine. But we should nonetheless strive to be better than that. And I think that the points that the Liberal Democrats have made here are worthy of serious consideration. And so I do think that this is worth a vote. And as I said at the start, I say this as a member of a party that does put our names on our things. I don't so much say this for us as for who it might be in the chamber next. I do think that a good point has been made here. It deserves that mature consideration that I've been talking about, and again, to give them credit, the Liberal Democrats have. And I do think that we should vote to leave this as it is. And we can all agree between ourselves that best practice is to do this by and large, that we should all strive to do it second to two. But where there are circumstances where somebody thinks probably not on this one, fine, leave it up to that discretion. I don't see why we need a hard and fast rule. I can see the appeal of it, don't get me wrong, but I don't really see the need. And given there is a strong counter argument here, and there isn't really an overwhelming case to do it, let's just leave it as it is.
Thank you, Councillor Ibsen. Councillor Johnson.
Thank you, Chair. I'm a great believer in accountability. Now, it's very, very simple. My argument is that, oh, I just remembered something. The notice of motion that's coming forward at the end, that requires every member of the planning committee to go and say how they voted by roll call. They've got to be accountable. Now, as a member of the planning committee, if I've got to be accountable for making controversial decisions, what is the argument against you saying, I've got a controversial motion, but I don't want to be known for it, please have my name. Same process, except the same process on your motion must exist for what we've got here. Quite simply, it's accountable. If you put a motion forward, you're accountable for it. Full stop. You want that happening in the notice of motion in the planning committee, accountability, full stop. That's what happened to this. So I'm suggesting we keep the same proposal. The proposer for a motion has their name on that motion. Thank you.
Thank you, Councillor Johnson. It's actually to the point, because this is the proposer, correct me if I'm wrong, now it's getting late in the day, is indeed that we either stay as we are, yeah, effectively, or we go along with the Liberal Democrat option, which is to take the names off. Is that correct? Or have I got the wrong way around?
We actually have no format at the moment, Chair.
We've just got a discussion.
This was a suggestion, and you will recall the start of this process was us asking members what changes they wanted to see. So this is a suggestion from somebody on the floor that they wanted to see a name, the name of the mover and the seconder. So it's a recommendation from committee. If we vote against it, we stay with current practice. If we vote for it, we impose an obligation for the mover to put their name on.
So do we have a mover and a seconder for the? Of course, so please do speak.
Thank you very much, Chair. I can't hope to match the passion that we just had from the Deputy Leader of the Council. I do find myself sort of arguing against my sort of recent conversations. I mean, I sort of withdrew our sort of opposition in the hope of finding consensus. I mean, I have to say, being a Liberal, my natural inclination is that we should have fewer obligations and not more. The reason why I think it's better, that Councillor Johnson's main thrust is accountability. There is still accountability when we vote. There is still accountability when it's tabled. We're talking about when the document, when the notice of motion is in the report pack, when the agenda is issued. It's at that point it won't have the name of the proposer on it. To be tabled in this chamber, that's when we find out, well, usually before, but that's when someone proposes it. That's the accountability there. So I think the accountability argument is a bit of a fig leaf, really, because we do have that accountability. I think there is great merit in, as Councillor Ibbotson has said, to the shock of many in this chamber, there are some personalities in this chamber that don't particularly like the other people in this chamber. And I think sometimes it is helpful to read a notice of motion, not know who it's from, and to form your own opinion without bias. There was a notice of motion I can remember recently that had no name on it, and it forced you to read it thoroughly. You didn't just look at the end and think, oh, well, it's actually them, so we won't bother, or it's them, so we'll just support it. You did have to read it properly, which is obviously what everyone in my group does all the time anyway. But I do think there is genuine merit in there not being the name on it. You have to read it with an open mind. I'm not in favour of creating unnecessary barriers to our notices of motion. I think we should be proud of the way that we are seemingly quite liberal in accepting our notices of motions here. We are a democratic institution. We long may that continue. Yes, so I'm not convinced by Councillor Johnson's argument. Yeah, I've got myself into a bit of a bind here, Chair, I'm afraid. So, I mean, I just think we shouldn't go along with this. Anyway, thank you, Chair.
Thank you. Councillor Dolphin.
Yeah, thank you. It's nice and short. Openness and transparency. This isn't a secret society. Be open with the public and be open with the rest of us. It's quite simple. It's not even worth the debate. Openness and transparency. It's as simple as that. Thank you.
Thank you. Councillor Bithell.
Yes, Chair. You know, if a member is strongly confident and supportive of a particular notion of the motion that he or she is putting before the council, surely to goodness they got the confidence to put their own name to it as a mover and a seconder, surely. You know, I can see nothing wrong with that. And to be fair, you know, our notice of motion that's come before this council, regardless of where it's come from, if there's strong support here, people will support it. Full stop, you know. And again, I just think this is a ridiculous particular requirement that no name should be attached whatsoever to it. People will come to an opinion and will either support or oppose a particular notice of motion on the pure argument for that particular proposal, regardless of who's putting that particular notice of motion on. Thank you, Chair.
Thank you, sir. Councillor Ellis, sorry.
Thank you, Chair. Personally, I think you should put your name forward if you're putting the notice of motion, because at the end of the day, it's got to go then to the monitoring officer for clarification that you've done the correct wording and you haven't said anything that's totally out of line. So the monitoring officer and Steve will probably see that notice of motion, so they will be aware of it. So if they're aware of it, why shouldn't everyone else be aware of it? And I do feel personally that if you are putting a notice of motion, you should be proud to do that. You should actually feel empowered by what you're actually saying. And my notice of motion was 100% supported. And I don't believe 100% of the council particularly like me.
We'll look at it.
But it shouldn't be about that, should it? It should be about what my notice of motion was and the content of it. And therefore, the content of it was agreed by everyone, so it got 100% support, despite whether there were people who liked me or disliked me. On that day, they took the notice of motion. They did it. They looked beyond its Carol Ellis. It was the notice of motion. And I would actually say, I don't really think that you should have a seconder neither. You really should be able just to do it yourself, for the people who are non-aligned, having the inconvenience of having to find a seconder, or sometimes the seconder doesn't speak up. That happened with me. The seconder to my notice of motion didn't speak up, and luckily I had someone else who actually seconded that on the day. Yeah, be proud of what you say, though.
Well done. Thank you for that. Interesting point. Now,
so the chair was just asking me whether we had a proposal to accept the original recommendation. Technically, that is what is on the table, but Chair, the original recommendation can't stand because it says mover and seconder. So we have to take seconder out. We've been there once, we lost. We have to take the and seconder out. Now, Councillor Bibby was the original mover, so I'm looking to Councillor Bibby whether he'd take that on board as an alteration. Yeah, thank you. Chair, what we would be voting on is to require the mover of a notice of motion to specify their name.
go on. A point of order takes precedence, as I'm told.
For the sake of completeness, the seconder of the original motion should be asked too. I say this because this could be important in future and we ought to set good precedents, especially when discussing the Constitution. So if the seconder of the motion is also happy, we can proceed.
Councillor Madison, are you happy that we just ask for the name of the mover rather than the mover and the seconder?
That's a yes. Yes? Agreed. Thank you very much. on that basis, then we do know what we're voting for, which is as described, basically. So we'll go to our recorded vote.
Councillor Banks. For. Councillor Bibby. For. Councillor Bithell.
For.
Councillor Brockley.
Against.
Okay, so cheers. Time lags.
Councillor Claydon.
Blind. For.
Councillor Coggins-Cogan.
For.
Councillor Collett.
For.
Councillor Crease has gone. Councillor Rob Davis.
For.
Councillor Ron Davis.
For.
Councillor Chris Toplin. Councillor Eastwood.
For.
Councillor Ellis.
For.
Councillor David Evans. For. Councillor G. Councillor Hadfield Jones. For. Councillor David Healy.
For.
Councillor Gladys Healy.
For.
Councillor Hodge.
For.
Councillor David Hughes.
For.
Councillor Ibbotson.
Yes.
Councillor Paul Johnson.
For.
Councillor Christine Jones.
For.
Councillor Richard Jones.
For.
Councillor Lister.
For.
Oh, bear with me. So, thank you, Councillor Lister. Councillor Simon Jones.
For.
Thank you. Councillor Richard Lloyd.
For.
Councillor Mackey.
For.
Councillor Madison.
For.
Councillor Marshall.
Obliged. For.
Councillor McEwen.
For.
Councillor Mullin.
For.
Councillor Owen. Councillor Palmer.
For, but don't forget Rosetta. She's back on.
Oh, Councillor Rosetta's back. Oh, I do apologise, Rosetta.
That's fine. I'm for.
Okay, thank you. So, Councillor Pearce. Councillor Priest. Councillor Richardson.
For.
Councillor Rose.
Against.
Councillor Solkeld.
For.
Councillor Swash.
Against.
Councillor Thomas. Councillor Turton. Councillor Turton. We still got Councillor Anne Turton gone? Not there at the moment then. So Councillor Wakelam. For. Councillor Bren. For. And Councillor Coppell.
For.
So that's 38 for and 6 against, Chair. So that is carried.
So this motion is carried. Thank you very much indeed. So we move on to what probably will be one of the trickier ones.
Recommendation 24, Chair.
24.
So, in relation to this, Chair, it was discussion about putting some limits on notices of motion. Now, Chair, in relation to this, I have already apologised to Councillor Johnson. The Labour group gave me some proposals in relation to this, and when I circulated the paper last night, I neglected to include them. I got most of them. I'm afraid I neglected to move those. I circulated those round by email earlier today. So apologies, members, just to make sure that everybody is, as I said earlier, on the same page. There are a set of additional proposals from the Labour group in relation to that. So, Chair, in terms of, you can see that the proposals, there was a suggestion for a limit of 5 motions with a time limit of 10 minutes for each. you can see the comments in paragraph 1.26. The Labour group had a comment indicating that order of motion should be drawn by lot, but they've since then incorporated that into their later amendments. And you see that there's feedback then from both Flintshire People's Voice and the Liberal Democrats. Again, Chair, this might be one of those ones where it would be better if Labour put their proposals in the way that we did before, and then because I think the other two groups are essentially arguing against the limitations rather than arguing for something different.
Makes sense. Councillor Ibbotson.
Before we proceed with this, given that the proposals circulated late from Labour, which I appreciate might not be their fault, but regardless, it is the fact that they were, and given the restrictions on access to email that members have as a result of the new IT policy, can I request that paper copies be circulated in the chamber to enable members to follow along? I would also perhaps suggest that given that we have now been at this for in excess of 6 hours, and this is likely to be controversial, it might be worth deferring this one to the next meeting such that a more mature discussion can be had than the ones that we tend to have at this time of the day.
Thank you. There is, I do believe we have a head of steam, so I don't think we will continue with this now, because if we leave this, it's just pushing it down the road a bit. And so therefore, and it is important, people have got views on it. The views are clear. I think on the subject of whether this needs to be circulated to the people in the room,
we can get that done.
We can get that done relatively easily. So we'll have a little 2-minute, not a break, but just 2 minutes of stand down or so, whilst staff are circulating the paper copy in case you didn't get it by email. Are the people online, presumably they've got this?
Yes.
So they've had it. Okay, so is there somebody online who's that? Councillor Hodge, you have your hand raised.
Thank you, Chair. I think I'll wait till all the members have actually received the paper copy, please.
Thank you very much indeed. Thank you. So we'll just wait a few moments and then we'll proceed.
Chair, if I may, can we just confirm the email that we're going to be talking about now was the one received at 9:01 this morning?
Thank you. 9:02. Yeah.
That's great. Thank you.
Okay, there.
Thank you very much. Right, so that being the case, you've all had an opportunity, I hope by now, to see this. Thank you very much in the room, everybody. So paper copies have been circulated, and it's not a long page to read. So therefore we can continue on, I believe. So I shall hand you over to the monitor.
So, Chair, I've talked about, I said what I needed to say. I think, Chair, Councillor Johnson to move the.
Indeed. So that being the case, Councillor Johnson, there's a recommendation that the Labour Group have made. Would you like to present it, please?
Thank you. It's a very strange situation that's having had the document and the comments from different groups. Plenty of people's voice, although I didn't quite like the language that was used, made some very, very good points about the right to speak at the debate, the secondary, etc., etc. Debates should have more time given to them than was allocated by the scrutiny committee. That was very, very clear. However, even when you're increasing the time, 5 motions is a lot. So it's very, very simply is to increase the length of time motions can be debated for, but also to reduce the number of motions which come forward, which is not unusual in many, many councils. There are often restrictions in other councils, so we're not exactly talking about the end of Western civilization by this. The key thing I will keep going back to is looking at how we're going to change the constitution. It is about focusing on the business of the council and making sure the time we spend is spent on the things that we have to go and do. Now, those of you who want to have, say, well, let's have as many motions as we can put on there, that creates an issue because sometimes, and I've been noticing it recently, that we've spent more time discussing motions, equal time discussing motions, as we have done the actual business of the council. And I look back to December, and we were looking at the Treasury Management Strategy and Reports. We're looking at the Capital Assets Programme, the Capital Programme. All these things, they're the things that this council has to go and discuss. Now, we've got to keep the balance correct. And I think motions are an essential part of what the council should go and do, but they are not the only part of it. We are not the House of Commons where we sit here discussing motions or acts of parliament or whatever. We are, because at the end of it, a notice of motion, very often it's a recommendation to write a letter to or to do this. So what the key business we go and do are things like reports come to us. The motions are important. They have very, very strong merit. Now let's try to keep clear that when we look at our meetings, that balance exists. So it's not about saying that motions, if they're submitted, are just going to be left off or ignored or whatever. They can be submitted at another time. They go through the same selection process. They'll be selected by ballots rather than the time that they come in. There's nothing in there about emergency motions or urgent issues that can be brought up at council. It's just for the ones that come as part of the ordinary business of council. It's a very simple process, and I know that we're going to take it for another hour or so discussing as part of this. This again is just trying to get the balance right at our meetings. Thank you.
So, Councillor Johnson, are you making are you proposing your amendment?
Proposing, yes, Chair.
Do you have a seconder for it?
Hope so.
Councillor Healy.
Yeah.
Thank you. So now we can open the floor for discussion on that same subject. So before we start, I have. Oops.
Thank you, Brett.
Thank you. So, Councillor Hodge online, you wanted to speak.
Thank you, Chair. I've kept quiet all day since I chaired the consultation previously, listened to all the arguments backwards and forwards with the various recommendations. But I feel this recommendation at the 11th hour shows a total disregard for the whole process. The committee undertook 20 workshops and 4 committees, because I did count them, Gareth, to come to a broad agreement. I chaired those meetings, hopefully in a neutral manner, despite attempts at arm twisting regularly. But recommendation 24, installing the number 5 with regards to the number of motions, without the caveat of restricting them just to opposition groups, I feel is a restriction on democracy, but it was agreed in the committee, so I had to accept it. But reducing the number to 3 shows a total disregard to democracy. So I urge any member with a sense of decency and respect to vote against this recommendation, which is no more than an attempt to obstruct free speech. Thank you.
Thank you, Councillor Hodge. Can I now bring Councillor Sam Swash? Thank you.
Thank you, Chair, and I associate myself wholeheartedly with the comments made by Councillor Hodge. I find this latest amendment to be extraordinary. This council has spent months and months and months on what I believe to be an entirely unnecessary exercise. There have been countless hours of private meetings that the public weren't even allowed to attend. We've had the original report, then further amendments that weren't consulted upon, then more amendments the night before the meeting, and now still further amendments circulated on the morning of the meeting itself. And what is the consistent theme running through every single version? Less scrutiny, less accountability, fewer opportunities for councillors to challenge those in power and bring forward ideas on behalf of the residents they represent. The Labour group originally proposed, in characteristically competent fashion, a limit on motions that plainly contradicted other parts of the Constitution. Now, having presumably been made aware of their own folly, they're desperately trying to amend it yet again, this time reducing the number of motions further still to just 3. 3 motions, that's in a council of 67 members that meets around 10 times a year. We're seriously being asked to believe that limiting each councillor to fewer than half a motion each per year somehow strengthens local democracy. It makes a mockery of local democracy. And of all the people to move the amendment, guess who it is? Councillor Johnson again. Earlier in this meeting, he criticised what he describes as a council that wants to talk and talk and talk. And yet we've spent much of today's meeting listening to Councillor Johnson himself speaking at considerable length, time and time again, as usual. I have genuinely lost count of the number of times he has spoken today. More importantly, he was one of the principal participants in a working group that has spent months talking and talking and talking about these proposals, only to arrive at today's meeting with yet another set of last-minute amendments. Indeed, much to the opprobrium of the chair of the committee and the working group, he would regularly rock up after agreements had already been reached with attempts to amend those agreements. Indeed, he is the deputy leader of the Labour group, the very group that's tabled amendments on the eve of the meeting and then further amendments on the morning itself, some of them unfinished, some littered with grammatical errors, and none of them properly consulted upon. So I won't be taking lectures about other people wasting time. I find them difficult to take seriously. The irony is almost beyond belief, frankly. After months spent debating how to make scrutiny less effective, the Labour group is still basically making it up as it goes along on the morning of the meeting. Frankly, I think this amendment is utterly shameful, and I hope that members reject it.
Thank you, Councillor Swash. Yes, you've raised a point, so therefore, what is it?
21-2, again, Mr. Chairman. 5 to 3 is a serious reduction. We're going down by 40% on the committee's recommendations. This is a material divergence on an issue of vital importance. It is a substantive amendment that disagrees with the recommendations of the committee. The committee went through so many versions of this where the working group would agree, and then again, this would be reopened. And I won't be quite so forthright as perhaps my colleague was, but it was a mockery, this issue. The committee did come to recommendations. What we're now being asked for is not what's recommended by the committee. Under Rule 21.2, it needs to be adjourned, Mr. Chairman. It's the same situation as we had with questions. It is materially different. It's different in the number, it's different in the timings, it's different in the means of selection. Added with the earlier thing regarding carrying over of business, all of this will add up to something that is radically different from what the committee recommended when taken as a whole. The reason we have 21.2 is to stop this kind of stuff being sprung on members at short notice when it's constitutional changes, which change everything about how this council does its business. It has been sprung on us. And why it's come this late, whose fault that is, I don't really mind. I'm not here to apportion blame, but it has come late. We can't properly consider it. We can't think through all of the unintended consequences it might introduce. It needs to be deferred, Mr. Chairman.
Thank you. Before we get into that any further, I'll take some advice from our monitoring officer.
I'm just wondering what I can say that is different to what I have said in relation to this point a number of times this afternoon already. I don't think there is particularly much I can say that is different. It isn't a new proposal, is it, Chair? It's talking about changing the numbers.
My own commentary on that is that whereas I can see it's different from, but it's allied to, it's numbers and time. And numbers and time are what they are. Now, you might disagree with a number 5 or a number 3 or a month or 2 months or a week or a year, but nevertheless, it's not, well, by the way, we'll do it by looking at who's got a bigger pencil or something different. It's not a new methodology. It's the same method. It's the same sort of statements, but different in time. So I personally, I'm not prepared to accept the fact it's a 21.2 21.2 event. So now I'd like to then bring on David Richardson, please, online. Thank you.
Thank you, Chair. Yeah, for me, to bring something through at such a late stage from a group who I think should be pretty well organised and, you know, pretty timely with the way they're administering things. I just thought, I thought it was even a little bit sneaky, if I'm allowed to use that word. Unfortunately, one of the other councillors spoke this morning, and you know, he was up nice and early, sat in front of the laptop or his PC, waiting to see if Gareth or somebody else sent an email through, so he could, you know, print it off and be organised. Not all councillors have the option. Oh, I was up before 6. I was out the house before 7. By the time I sat down for this meeting, I'd already done half a shift's work. So that's one point, you know, the lateness of the changes. But the actual issue itself, to go from 5 to 3, you know, you've almost halved it. Who and how would those 3 get picked? You know, would it be the same groups getting theirs through every month or whatever? In the interest of fairness, I think in the interest of fairness, I think if somebody suggested that if it was to be limited, would it not be more beneficial to limit it to 1 per group, one motion of notice per group, rather than selecting people not to have their motion of notice not heard? Thank you.
Thank you, Chair. The next speaker will be David Cookins-Cogan.
Thank you very much, Chair. For whatever reason, the lateness of this coming through, I do not think it's appropriate that we're considering it now, Chair, because I think this is a material difference. You disagree with that assessment, and that is your discretion. I wonder whether the Chair would be amenable for a recommendation that it's referred to the Constitution and Democratic Services under Rule 13.6A. This is such a restriction on members' rights. It's particularly harsh on opposition members, Chair, because the members of the administration, obviously, they can get their business through by working through the cabinet and working with officers. on the opposition benches, we don't have that same working relationship with officers. So this is our main function, is how we get we are able to draw attention to matters that we believe are important. As was mentioned earlier on, this council, I think, was the first council in Wales to pass a motion protecting the rights of medicinal users, and we should be very proud of that. I'm not sure how we would feel if instead that wasn't drawn that day, and instead we debated something frivolous or entirely party political. I think this is a bad step. I also think unintended consequences. There are other mechanisms in the Constitution which allow for motions to be debated at other meetings. What we will do is just have more meetings. That's what will happen. We won't have fewer motions. We will just have the same number of motions, but with more meetings. So I would urge members to reject the proposal, because it's just not workable. It's not going to achieve what they think it's going to achieve. If we're determined to get a notice of motion discussed and draw attention to an issue, we will just make the council meet and discuss it. It's not what we want to do, because all it does is irritate everyone coming into the chamber that have had to come on for an extra meeting. It is far better that we have the current system than we have this unreasonable and disproportionate restriction on freedom of political speech. There's been no discernible harm. Councillor Johnson, who introduced it, simply said, well, because we're talking too much and we're not doing the core business of the council. I suggest he needs to read the council's constitution again. This is part of our core business. It is not just moving reports about the budget and about council tax setting. We are all, whether we are independent or of a political party, we're all to a nature, a political beast. We want to say things, we want to do the best for our communities. Part of that is using every available lever that we can use. By just restricting it when there's no harm has been identified is wrong. And I say again, it's not going to solve the issue. We will just have more meetings, and that will be a bigger imposition on officer time and a bigger imposition on members' times as well. So I would urge everyone to reject this, or at the very least, under 16.3, refer it to the Constitution Committee so it can be discussed thoroughly. I mean, if it had been the original amendment that was in the papers, which is demonstrably worse, I wouldn't be able to argue as convincingly that that goes to the Constitution Committee, because it is in these papers. But this has been circulated at 9 AM this morning, 90 minutes before the meeting started. I don't think that is reasonable to give this the proper weight and consideration it needs. So I would urge members to refer it to the committee so it can be considered properly. Thank you, Chair.
Thank you, Councillor Dolphin.
Thank you. The email with this came in 2 minutes past 9 this morning. Everybody here has had a full working day to consider this before we started discussing it. Full working day. Plenty of time to have a look at it. I had plenty of time. It's not a long email. It probably takes a minute to read. There's a lot in there to take in, but we've had a full working day to look at this and consider it. And the reasons for it are in here, in the document we had before, really, aren't they, if we think about it? The silly and unworkable limit, that was on the earlier one. There was feedback from the FPV. And then you have 5 minutes, you would have to speak for 15 minutes on the original motion before you even got to any debate. That's why what's written down in this is unworkable, and I think everybody agrees with that. So we come to one that is workable. Yes, there's 2 less motions, 3. Until about 3 years ago, maybe 4 years ago, 3.5 years ago, a rare beast was a notice of motion. You hardly got one because it was something a bit special. You didn't get numerous notices of motions and 23 questions on a meeting. And that's why we're here today discussing everything we've been discussing earlier and this. Because, yes, not workable was mentioned, but it's not workable now. And that's why we're discussing all this today. We're trying to get something sorted out that is workable and that we can go along with. Flexibility and versatility. Our workforce is that flexible and versatile. And these councillors and we need to be flexible and versatile as well. And so today we're going to prove it by going along to recommendation 24 and having 3 motions that basically you can debate for half an hour each, which is a vast improvement on 5 motions and 10 minutes. Because what's the point of that? None. May as well go in the bin. So we'll go with recommendation 24, half an hour to discuss 3 motions. And then no doubt we'll come back at another meeting when something else is proposed. But for now, this is what we need to go with. Go with this, be sensible, and let's proceed. Thank you.
Thank you. Councillor Healy, thank you.
Thank you very much to Councillor Johnson and to Councillor Dolphin for what he's just said, because I think this is a perfectly sensible route forward. I think this is a responsible amendment to be put forward, one that is perfectly legitimate to be brought to the sovereign body of our council, and one which isn't a negation of the original recommendation, otherwise the monitoring officer would have commented on that. So it's an entirely appropriate amendment. And for the reasons that Councillor Dolphin has said, it is, I would suggest, strongly recommended that members of this chamber do vote for it. Yes, Councillor Dolphin commented about how in the past there's been few notices of motion. But I think in recent years, this particular right to bring forward a notice of motion has been frankly abused, and that we have had meetings that have been overlong, and that we've had lengthy debates about issues that we didn't really need to debate. I want to put to bed once and for all this idea that councillors do a 5-hour day. Quite frankly, the phone can ring over a matter at any time of the day or night, and that we are not doing a 5-hour day. The fact that we are here for a long period of time, often listening to speeches that are showboating or whatever, in order to get a press statement or to get a social media click, the fact that we're here tied up means that we're not able to do the job that we really need to be doing for our representatives, our constituents. Now, I've got a list, a caseload of so many issues, and I dare say everyone has, waiting for them. Can't deal with them at the moment, but I want to deal with them, because this, being in a meeting, is only a fraction of our work. And so I want to put to bed this perception that if we do happen to go at 5 o'clock, and it's now approaching 5:15, that we have stopped work, because that is actually when we can start to do some of the real work for our constituents that we can't do at the moment. Thank you.
Thank you, Councillor Healy. Now, there's been a huge amount of debate on this subject, and obviously I understand that from a point of view of workload, work pressures, time spent, restrictions of rights of people to speak, restrictions of opinions, restricting the ability of elected members to represent their people in a proper way, in a proper fashion. We've heard quite a lot. And so I think we need to get to a voting position, and I'm going to ask Alistair Ibbotson to be the last speaker, followed by Carol Ellis, who is nearly the last speaker.
Thank you, Mr. Chairman. I would first of all like to just address some of the timings in this new proposal, because clearly there's been an acceptance that the first attempt of 5 motions in 27 seconds or whatever it was perhaps a little over optimistic. So now we've got to 3 motions in 90 minutes, or 1 every half an hour. Now, that's 5 minutes for the proposer and 5 minutes for the seconder. Voting and the chair calling people to speak takes time. If somebody wishes to propose an amendment to that motion, then that is 5 minutes for the person who wishes to propose an amendment and 5 minutes for their seconder, 5 minutes for right of summing up, voting, and then obviously the proposer of the original motion would also get 5 minutes if the amendment falls, certainly, and possibly if it's a minor one, even if it succeeds, on the original substantive. So that in itself is in excess of 30 minutes. In other words, if this is passed as is, amendments to notices of motion will no longer be possible because there will not be enough allotted time. So every time Flintshire People's Voice brings a notice of motion from here on in that the coalition benches disapprove of, the favoured tactic of amending it or sending it to some other body or whatever will no longer be available to them. They should think very carefully about what they are about to do. I would also associate myself with the comments made by Councillor Coggins-Cogan that this will lead to simply more meetings. I shall perhaps put it a little more bluntly than he will. You are going to have requisitions up the wazoo. There is no way around it. Now, let me address exactly what the problem seems to be here that's led to this being proposed in the first place. And I must put on record my huge thanks to Councillor Dolphin for saying the quiet part out loud. Notices of motion were once a rare beast on this council, but since then we've got some councillors who actually have ideas for how to improve this county and improve the lives of people of Flintshire. We have got on this council current and former 28 Labour councillors. Since the start of this council term, up until, and I must admit my figures are slightly out of date, the 17th of March this year, they've moved and seconded, so if they both moved and seconded, they get double points for this, 10 times. Flintshire People's Voice, a group with less than a quarter of the membership, has done 43, more than 4 times more. Bang for buck, we are 16 times better value for the people of Flintshire than the Labour group. Now, perhaps I'm being unfair. Perhaps we should consider the coalition as a whole. Well, I have bad news there because the independent score is even worse. The people who this is going to cut off are the only people who have ideas about how to change this council for the better. They don't have ideas, and that is why they are trying to shut us up, because it makes them look bad. Now, 3 motions chosen at random by lot. I suspect if this passes, we're going to have a lot of motions in from the Labour group in the next couple of weeks. We're going to have this council resolves that it likes fluffy duck bunnies. This council thinks that Wednesday follows Tuesday. This council thinks the leader's doing a wonderful job. They will fill up with bogus motions.
Councillor Ibbotson, your passion is recognised, but please, I've got other people queuing up to speak. You've spoken passionately and with some, I've lost the words what it is with, but it's with lots and lots of passion. And what I'm saying is enough now. So what I would like to do, thank you very much, is to bring Councillor Carol Ellis. You might well have a minute, but to be quite frank, I'm just... He's moved it. Possibly not, but it's a good idea though, isn't it, really? But it's... you've got a minute.
Thank you, Mr. Chairman. Now, I will second Councillor Coggins-Cogan's proposal, but I would urge you to, as I've said already, rule this out of order on 21.2. It will lead to a lot of unintended consequences. It will lead to the coalition or whoever succeeds them filling this up with rubbish motions. It will lead to extra requisitions. they should be very careful what they wish for, because requisitions are not the only tools available. This is a travesty. If they want to look back at the motions that we have proposed and point out which, about funding to schools, about public transport, about all manner of things, about cutting waste at this council, shouldn't have taken place. And Mr. Chairman, that clock excludes 20 seconds of my time. They should be willing to say what they think shouldn't have been tabled, when theirs, typically, the ones that they have had, do not use the powers of this council.
Councillor Ibbotson, thank you very much indeed. So, apologies, Councillor Ellis, but it's your turn to speak, and you are the last speaker on this. Thank you very much indeed.
Thank you very much, Chair. I also believe that this amendment should go back to the committee. C, where it actually says that the sorry, it was just the background noise there, just was a little bit off-putting. So C, where it mentions, then lots are drawn to decide which 3 will go forward to the meeting and to set the order of which they will be considered in. So who would be drawing the lots and making that decision? Then when we go on to D, and it says motions not selected for inclusion at the meeting can, at the request of the proposer, be submitted to the next council meeting. These would go through the same selection process as outlined in A through to C above. So you could actually have a notice of motion which could never get heard, because you could actually never be chosen. If you're an unlucky person and you don't get included in the draw, if you're not lucky at bingo and that type of thing, and there are some of us who are not very lucky in raffles and stuff like that, you could actually never get your notice of motion heard for months and months and months. Where is that democratic? I can't see that. This definitely needs to go back, and it needs to be looked at again with a more fair process. I can understand the will to reduce the number of notices of motion and having a time limit. I can understand that to a certain extent, but the way they are chosen and the fairness that is involved is not, in this amendment, reflected, in my opinion.
Thank you, Councillor Ellis. Thank you. Now, so in terms of debate on the original proposal presented by Councillor Johnson, that's the end of the speaking part. And
Chair,
so,
could I raise a point of order, please? Sorry to interrupt.
Councillor Richardson, you can raise a point of order, yes.
Thank you very much. It's regarding a statement that was made that I believe is not true by a previous councillor. The previous councillor said that everybody has had a full working day to read and digest and think about what we're talking about now. So for one, I don't walk around the business where I work with my laptop in my pocket. It's not allowed. The first time I opened my laptop was to join the meeting today. At 9 o'clock this morning, if that's when the email was sent, people, I would imagine, depending where they live, to make good time to get to T. Dewi Sands are already on the way.
Councillor Richardson,
So,
this is not a point of order. This is, I don't know what it is. Sorry,
yeah,
Richard.
My point of order is, I'd been reading off, if you just let me finish, it'll take 30 seconds. So I'd been reading off the yellow, green and blue sheet all day. It was only when, as chair, you stopped the meeting, correct me if I'm wrong, Chair, you stopped the meeting to distribute the latest email where the numbers moved from 5 to 3 and to give the people online time to go in their emails and find the right part. So if people have had all day, that they've known about it all day, why did you have to make a 2-minute break to distribute the latest paperwork? Thank you.
Thank you, Councillor Richardson, thanks for your point there. So now we will now go to the vote. And obviously, as usual, it's a recorded vote. I shall hand over to the monitoring officer to carry that out. Thank you.
Thank you, Chair. Despite a number of attempts to move other things or suggest other things, we are voting on the proposed amendment from Councillor Johnson. Chair?
Yes, Councillor Whitson, what is your point of order?
A procedural motion was moved by Councillor Coggins Cogan to refer this to the Constitution and Democratic Services Committee. It was validly moved. It has been validly seconded. We should vote on that.
It's probably having a very long day.
Wait one, as they say.
So, Chair, no, it's not a closure motion. So, no, it's not debated. It is a motion that can be moved without notice, but it's not a closure motion. No, we had an amendment from Councillor Johnson. You can only have one either motion or amendment on the table at the time. So we have the motion from Councillor Bibby on the table. We have the amendment from Councillor Johnson. Now, there are closure motions that can be moved that would supervene an amendment, but this is not one of them, is my point. Motions without notice are different to closure motions. Motions without notice are under Rule 12. Motions which may be moved during a debate, when 13.10, when a motion is debate, no other motion may be moved except the following procedural motions. It's not one of those procedural motions. It isn't a closure motion, which are what we call the closure motions. It's not a closure motion, I'm afraid. So we have the amendment, and with respect, it wasn't a validly moved referral. It would have to wait until the outcome of this amendment before it can be moved as a further amendment.
So, that being the case, we'll go back to the voting process. Thank you.
So, we are voting on the proposal from Councillor Johnson that there should be 3 notices of motion, an hour and a half to debate them, and so on and so forth, Chair. Councillor Banks. For. Councillor Bibby. For. Councillor Bithell.
For.
Councillor Brockley.
Against.
Thank you. Councillor Claydon.
Applying for.
Councillor Coggins Cogan.
For democracy and against this terrible amendment.
Councillor Collett.
So against that.
For. Against. I'm recording that as a vote against. Councillor Collett was for. Councillor Crease has left. Councillor Rob Davis.
For.
Councillor Ron Davis.
For.
Councillor Chris Dolphin. For. Councillor Rosetta Dolphin.
For.
Councillor Eastwood.
For.
Councillor Ellis.
Against.
Councillor David Evans. For. Councillor G. Councillor Hadfield Jones. Councillor David Healy.
For.
Councillor Gladys Healy.
For.
Councillor Hodge.
Against.
Councillor Dave Hughes.
For.
Councillor Ibbotson.
Against.
Councillor Paul Johnson.
For.
Councillor Christine Jones.
For.
Councillor Richard Jones.
For.
Councillor Lister.
Against.
Councillor Lloyd.
For.
Councillor Mackey.
Against.
Councillor Madison.
For.
Councillor Marshall.
Applied for.
Councillor McEwen.
Against.
Councillor Mullin.
For.
Councillor Owen. Councillor Palmer.
Yeah.
Still got Ted. Oh,
Ted Palmer online.
sorry, Simon, I realised I've missed you as well. I'll come back to you.
No, I can't see Councillor Palmer, Gareth.
Okay, so we've lost Councillor Palmer. Councillor Jones, though. Simon Jones has rejoined us. I do apologise, Councillor Jones.
4.
Thank you. Councillor Pearce. Gone. Councillor Priest. At least getting quicker, Chair. Councillor Richardson.
Against.
Councillor Rose.
Against.
Councillor Salkeld.
Against.
Councillor Swash.
Against.
Councillor Thomas. Gone. Okay. Councillor Turton. We still got Ant online.
No, he's not here.
Councillor Wakelam has gone as well. Councillor Wren.
Against.
And yourself, Chair. So that is 22. Oh no, 23 for Chair and 17 against. So that is now the substantive motion, Chair.
So now we have the proposal put forward by Councillor Johnson as a substantive motion. So now we have to have a look there.
We have the substantive motion. Yes, Chair. Councillor Ibbotson is indicated to speak.
Councillor Ibbotson, you have the floor.
Thank you, Mr. Chairman. Before I move the same procedural motion as we attempted to a moment ago, I would like to just take a moment of reflection and reflect on the fact and congratulate this council for, I think, breaking a record today that we can all be proud of. I think I am right in saying that this is the first time that we have ever continued up to 5:30 without a closure motion for the meeting, without the coalition moving an attempt to end the meeting. It's just a shame it's on the one time when they're trying to ban motions in question.
Councillor Ibbotson, is there a point to your conversation, please? You need to get to a point. What is the point here?
I move, Mr. Chairman, that this be referred to the Constitution and Democratic Services Committee. It is frankly daft that we are making changes to the Constitution for which could not possibly be more on the fly. We have heard some members try and say that there's been time for mature consideration of this because we've had all day. For those of us who have been sat here paying attention to the matters under discussion throughout the meeting, engaging with the comments made by other people rather than looking at emails, we haven't. Some of us take the debate seriously, not just when we're getting up and speaking, but when others are too. I think it is frankly reprehensible to suggest that there's been all day to consider this. Clearly, the Constitution is only meant to be amended when there has been scope for mature consideration. And Rule 21.2 makes clear that that should be weeks, if not months of consideration. Instead, we've got hours if you include all the time we've spent discussing the other items. If you don't, minutes. It does the residents of this county a disservice. It does this council a disservice. To pass this now as the substantive would be to bring this council into disrepute. And as I say, there are unintended consequences that will result from this. I'm not going to enumerate them all. As I think it was Napoleon said, never interrupt your enemy when he's making a mistake. I'm already breaking that rule by suggesting that this be referred to Constitution and Democratic Services Committee. But they clearly haven't thought this through. To the extent that I have been able to, I can identify a number of flaws that perhaps they ought to think about too. But I am sure there are things that I've missed because I haven't had a chance to since this was sent out. It would be a dereliction of all our duty to proceed with this as is. It must be referred. Thank you.
Thank you. So you've made a proposal. Do we have a seconder for that, Councillor Cogan? So we have a seconder. Now, people are entitled to speak to that.
Yeah.
Councillor Jones.
Yeah, it's ludicrous that they're making this point that there's so many changes of significance. The changes are 5 to a 3 and 50 to a 90, it is all the same. So when they're saying significantly different, it is not significantly different at all. That's what the Constitution Committee came up with. We've changed numbers. That's it. Nothing else. And Councillor Cohen, you can laugh as much as you want, which is your right, but you're also wrong. So this is exactly the same recommendation it came from with the changes I've said. And to be perfectly honest, it is not a disregard of democracy. This is a management of time. That's what this is. We're managing time in the best way we possibly can. It is not good. It's not good management of time to have officers sitting around here for hours and hours and hours when they can't do their day job. They're listening to you and me. That is not good use of officer time. I can't do my job when I'm standing here. My job is out there, which I get to, by the way, 8:15 every morning. And I usually leave here at 6, and you can time me, because that's what I do. I do my job when I'm in that office, but I can't do it here. So you take time away from cabinet members, you take time away from officers, you take time away from other members. It's not right. It's just not right. We need to manage the time better, and this is a way of doing it.
Thank you. Councillor Priest.
Long debates today, and a lot of people have had their says on it. I do believe this is part of our job. I do believe this is part of our role, and it's part of our core things that we should be doing is debating, not having it as an add-on and almost an inconvenience. It's not an inconvenience. This is putting forward motions that could, from what's being suggested, so we're looking at 30 in a year. There's 10 meetings, that's 30. And a lottery, if there's any more. Now, we could be flooded on the first meeting with over 30 motions from a group, which would then bulk up the system and stop any additional ones going forward. Now, some of these motions that have been put forward over the last 12 months or last 2 years have been urgent motions. They've been time sensitive. And what we're looking at doing is stifling debate, stifling things that are pressing, that needs to go either a letter from us to the Senate or whatever, because they are affecting residents now, not in 6 months' time, not in 12 months' time, which is what this can do. I'm 100% behind moving this back to Constitution. We need to be thinking about this properly, not politically, in groups, etc. This needs to be put forward. You know, there's been good motions been put forward by all groups. You know, the WASPI was put through. We've had prostate cancer ones put through. We've had some fantastic ones. I put through one to do with the pensioners' fuel poverty. Now they have gone through. They have gone through to where they should go. This will stifle it if we're not careful. And I'm seeing here where it said, oh, we never used to have many. Well, that's bad. That isn't what we should be doing. We should be bringing these attention. This is part of our job, not an add-on. This is our role. Our meetings here are very, very important. It's part of democracy. We can't have them as add-ons, an inconvenience. They're not an inconvenience. This is part of our job, our role. Yes, we see residents. Yes, we go out to residents, but this is our role, not an inconvenience. And we do not want to stifle debate. Thank you, Chair.
Thank you, Councillor Priest. And again, a highly emotional debate point. We've had now debate on this. No, we've had now debate on this very strong debate, actually, fair and strong and robust debate on both sides of this argument. So there's a proposal on the table to send this back to our Democratic Committee, and therefore we will put that to the vote. Thank you.
Councillor Banks. Against. Councillor Bibby.
Against.
Councillor Biffle.
Against.
Councillor Broccoli.
For.
Councillor Claydon.
Against.
Councillor Coggins Cogan.
For.
Councillor Collett.
Against.
Councillor Crease has gone. Councillor Rob Davis.
Against.
Councillor Ron Davis.
Against.
Councillor Chris Dolphin.
Against.
Councillor Rosetta Dolphin.
Against.
Councillor Eastwood.
Against.
Councillor Ellis.
For.
Councillor Evans.
Against.
Councillor G. Councillor Hadfield Jones. Councillor David Healy.
Against.
Councillor Gladys Healy.
Against.
Councillor Hodge. Not online. We've lost.
No, he's gone, Gareth.
Yeah, thank you, Nick. We've lost Captain. Councillor David Hughes. Councillor Ibbotson. Councillor Paul Johnson. Councillor Christine Jones.
Against.
Councillor Richard Jones.
Against.
Councillor Simon Jones.
Against.
Councillor Lister.
For.
Councillor Lloyd. Councillor Mackey.
For.
Councillor Madison.
Against.
Councillor Marshall.
An Erpin. Against.
Any commentary going on in the background, Chair? All right. Councillor Mullin.
Against.
Councillor Owen. For. Okay, Councillor. We've lost Councillor Palmer, haven't we? I think.
Yes, we have.
Yeah, we have lost Councillor Palmer.
We've got Councillor McEwen now, Gareth.
Oh, sorry, Ryan. Councillor McEwen.
Gareth, I'm going to abstain. I got kicked out, so I missed most of the debate, so I'll abstain, please.
Okay, thank you. Very fair. Councillor Pearce has had to leave. Councillor Priest. Councillor Richardson.
For.
Councillor Rose.
For.
Councillor Solkeld. Councillor Swash.
For.
Councillor Thomas has had to go. Ant Turton. Has he gone?
Yeah,
Lost.
he's gone. Yeah.
Definitely lost Councillor Turton. We've lost Councillor Wakelam. Councillor Wren. For. And yourself. Councillor
Against.
Coppell. So that's 23 against and 15 for. So it is and remains the substantive motion, Chair. Are there any other amendments?
So there we are. This remains substantive. So are there any other amendments to consider? Councillor Ibbotson.
Thank you, Mr. Chairman. I wonder whether, given that this proposal is being taken forward against the strong advice of myself and my group, we might consider spelling out in the wording of it exactly what it would mean, because otherwise we're liable to get to a situation of some confusion. I mentioned earlier the issue around tabling amendments. I think that we should probably be pretty clear that tabling amendments is now explicitly banned if we're going to do this, because otherwise the first motion will simply run over. I'm also perhaps wondering why motions on school funding, which the Cabinet refused to put in place, why passport from Welsh Government rather, why motions on matters of serious concern in relation to planning and in relation to planning enforcement, water meters for park homes, the way in which this council conducts its processes for park homes, school transport, 3 weekly bin collections, should all be restricted.
Councillor, sorry to interrupt you there, Councillor.
What is the point of, sorry, what is the amendment that Councillor Ibbotson is trying to put forward? I haven't heard one.
Councillor Ibbotson, I'm interested to know that because I believe, correct if I'm wrong, because you probably will anyway, that you've spoken on the substantive debate. We think you have.
I have spoken in relation to an amendment when it was the amendment. I have yet to move. You're counting that? of sorts, I think is the operative word there. But regardless, I shall move that we insert, in light of the new rules being passed, all amendments to notice of motions should be prevented in the interest of keeping to the time limits set by the administration in this section of the Constitution.
So therefore, thank
So,
you for that.
but
So,
can we just have the wording of that again?
yes, can we have that in detail, please?
All amendments to notice of motion shall be prohibited in the interest of keeping to the time limits set by the administration in this section of the Constitution.
Is there a second?
So on that, I'm assuming there is a second for this. Councillor Priest, thank you very much. So therefore, I'll open the floor to sensible debate. A point of order. Go on then.
Thank you, Chair. Under 13.2, I'd like to have that in writing, please, because I didn't quite hear it as it's been relayed. So section 13.2 says we can have that in writing. I'd like it in writing, please, Chair.
I shall be happy, Mr. Chairman, to provide it to the monitoring officer or the Democratic Services manager as you instruct, who can then circulate it in writing. I'd ask for a moment because the new restrictions on email mean that it takes some time to get onto. So I wonder whether we might have a 10-minute adjournment to allow for that.
I think that's we have no choice actually, because ultimately, if there's a requirement to have it circulated in writing, which it is, therefore you need to provide it in writing, which you must do. Therefore, it takes time to do that. So there's no logical debate which suggests you can't. So we're going to break for 10 minutes.
I can.
Chair, can I suggest something highly unusual? It's called handwriting. Perhaps, Councillor Lewis, we could write it out by hand. We could photocopy, pass it over. No break needed. Thank you.
Could that be accommodated, Councillor Ibbotson? Could that be accommodated?
Mr. Chairman, it's for the meeting, and so those members online might wish to have it in writing too.
Fair point. So what we can do is scan it, send it.
Yeah, apologies to interrupt, but I think I've got the wording down if you'd be happy for me to email it to all members.
Thank you.
Thank you very much indeed. That's highly appreciated.
That would
Okay, I'll do that now.
Right. So what we we are going to adjourn till 6 o'clock. And by which time information would have been on your email machines or in front of your face to read, and then we will reconvene at that point. Thank you.
All rise, please. The Chair of Flintshire County Council.
Thank you.
So, Chair, we have the amendment moved by Councillor Ibbotson, which has been reduced into writing by Nicola and circulated. I'm trying to think whether it was seconded by Councillor Bruce.
Indeed. So we've all had a chance to see and read that document. So it's properly put out there for a debate, and so therefore I open the floor for said debate. Any speakers? No speakers.
No.
That being the case, then
we go to the vote, Chair.
So we can go to the vote for this particular amendment as been provided to you this afternoon.
So this is 4 is to adopt Councillor Ibbotson's amendment, against is to reject it. Councillor Banks. We lost him.
Lost him.
Right. Okay. Councillor Bibby.
Against.
Councillor Bithell.
Against.
Councillor Broccoli.
Against.
Councillor Claydon.
Against.
Councillor Coggins-Cogan.
Against.
Councillor Collis.
Against.
Councillor Priest is gone. Councillor Rob Davis.
Against.
Councillor Ron Davis.
Against.
Councillor Christolfin. Councillor Rosetta Dolphin.
Against.
Councillor Eastwood.
Against.
Councillor Ellis.
Against.
Councillor Evans. Against. Councillor G.
Against.
Councillor Hadfield Jones. Councillor David Healy.
Against.
Councillor Gladys Healy.
Against.
Councillor Hodges gone. Councillor David Hughes.
Against.
Councillor Ibbotson.
Against.
Councillor Paul Johnson.
Against.
Councillor Christine Jones.
Against.
Councillor Richard Jones.
Against.
Councillor Simon Jones.
Against.
Councillor Lister.
Against.
Councillor Lloyd. Councillor Mackey has left. Councillor Madison.
Against.
Councillor Marshall.
Another bin. Against.
Councillor Mullin.
Against.
Councillor Owen. Councillor Palmer. We lost Ted, haven't we?
Yeah.
Councillor Pears has gone as well. Councillor Priest. Why are we here, Chair? Councillor David Richardson.
Against.
Councillor Rose.
Against.
Councillor Solkeld. Councillor Swash.
Against.
Councillor Thomas has gone. Councillor Turton has gone. Councillor Wren.
Against.
And yourself, Chair.
Are attempting to be just against.
It's unanimous, Chair. That's rejected.
Someone explain the purpose of that particular
Well, to wait-
exercise, apart from wasting time, which is what most of the day has been about.
Councillor, thank you, Councillor Bithell. Councillor G, you have your hand up.
Can I put an amendment in, please, to point F? So this section will be disapplied after a year until it is reviewed by the Constitution and Democratic Services Committee.
Can you just be more clear where we're doing this? And what you said, just all I heard was F.
Point F on this email.
Oh,
Just the wording.
Yeah.
Do you have a seconder for it?
Just the wording.
Just the wording.
Yes,
So that is the motion that
annually.
that the the provision be suspended after 12 months until it is reviewed by the C&DSE.
And you've seconded that.
I have to like to speak.
You do. That's right. Just speak for a second.
He can speak on another amendment. In the, yeah.
Yeah. So this indeed is a new amendment, so you do have the right to speak.
Oh, sorry.
Thank you very much, Mr. Chairman. This amendment will seek to undo some of the damage that this administration is doing to this section after a year. It means that whoever comes next after this will, unless they choose to just carry it on, automatically lose this power pending review. Given that the current administration, by the admission of quite a few of their own councillors in private conversations and indeed publicly in this chamber, I think concede that they are unlikely to be in administration next time. They surely don't want to leave these, I think the Liberal Democrats would call them Henry VIII powers. I would call them an enabling act for the next administration. This sunset at least tries to undo the damage done by this administration to our constitution. So should we accept this amendment or should we reject it? Well, the reason to reject it would be that a majority of councillors in this chamber are extremely confident that they will be in administration next time, and when they are, would like to avoid that scrutiny then as well. I think that that would be a foolish assumption for any of us to make. To prejudge the voters like that, to take them for granted in next May's election, would be frankly reprehensible. The reasons not to proceed with this as is and to accept the amendment are, by contrast, legion. If the administration is hell-bent on sabotaging the right of the opposition to table notices of motion, they could at the very least, in the interests of their own self-interest and preservation, ensure that this is available to them in opposition. So I ask myself, will they accept, and by they I mean of course Councillor Bibby and Councillor Madison, this common sense suggestion? I think that the wording that they've included themselves, that this be reviewed annually, suggests that they might be open to it. I hope that they are. It perhaps doesn't inspire confidence in their motives if they are, but I would hope that they are nonetheless. But as it stands, point F, where it left unamended, where this amendment to fall, does not include any suggestion of who it should be who does the reviewing. So given that council has made this decision, the assumption would be that one of the first items of business of the new council in July next year should be having this argument again. What a great way to start the next 5 years, everyone. Well done. So I think it makes sense that this be referred to Constitution and Democratic Services Committee rather than be a surprise gift for our successors on the dark side of May 2027. I don't think they'll thank us. So I would encourage colleagues, first of all, Councillors Bibby and Madison, to accept this good faith suggestion from Flintshire People's Voice. It seems like the very least that the administration could do, given that they're setting fire to everything else, to leave one little bucket of sand in the building. But if it won't be accepted, I encourage all members across this chamber to cast their votes for it. Because the idea that we are just going to set fire to this forever is a terrifying one. And I use the term set fire, I've used it a few times today. But this, the removal of opposition's rights, including through the what we've seen already with the idea of whipping declarations on license and abolition of subs on licensing committee, removal of councillors' rights, and indeed in some cases potentially votes, the clamping down on motions, the clamping down on questions. This is Flintshire's Reichstag fire moment. Now the question is, who is on which side? Fortunately, the votes have all been recorded today, so I think that that's pretty clear in the public's mind.
Thank you, Councillor Ibbotson. Now, Councillor Bithell, would you like to speak?
Yeah, Chair, I mean, the very fact that in F, it states that the process will be reviewed annually covers the point, really. It will be discussed. It's not a forever. This might not work out, or it may not work out the way we hoped or meant or understood, but they will be reviewed in 12 months' time, and that's included within the motion. So what's the problem? Move to the vote, Chair, please.
Thank you, Councillor. Councillor Healy.
Thank you, sir. Could the monitoring officer clarify if this amendment is actually a negation of what is on the discussion, on the table for discussion, please?
I don't think it is, Chair. It's an amplification of what was in paragraph F already. So it doesn't look, given that paragraph F already says that we'll review it annually, it would be very difficult to say that it was a negation.
You have a point of order?
Sorry, Mr. Chairman, I think I heard a voice from the back saying, never mind the point of order. Given that we're discussing the Constitution, I think some members ought to familiarise themselves with it. My point of order is that after an amendment... I'm sorry, Mr. Chairman, I can't hear myself over the shouting. It appears that I have some quiet and respect. Thank you. Oh, no, there it goes again. Mr. Chairman, an amendment has been moved and seconded. It is right and proper that the mover of the original motion and the seconder be asked whether they accept it. I hope that they will. But I would suggest before we move on to the wider debate amongst members, and I'm sure that the enthusiastic contributions from the back of the room, given how enthusiastically they seem to be shouting over me, that it will be accepted.
And Councillor.
Indeed. So, Councillor Bibby and Councillor Madison, do you accept this modification? No, you don't. You consider it covered?
Yes, so yes, consider it covered.
Therefore, are there any more speakers on this subject?
Well, that's up to you, Chair. You've got a closure motion that's been moved. If you think the matter has been debated sufficiently, you go and put the closure motion to the vote. If you don't, Chair, you invite further speakers.
Fair enough. So that being the case, you did. I did actually. I did. So, Councillor Coggins, I did your work, but just before you spoke, you did alert me to your requirement to speak. So please speak.
Thank you very much, Chair. As the monitoring officer has said, it's just this amendment is simply an amplification of what is already in the substantive motion. It just refines who makes the review, so we don't have to come back here. It can go through the Constitution Committee. It makes perfect sense. It doesn't negatively affect the substantive motion. It just adds more clarification of who is going to review it. I don't see any reason why it can't be accepted. It makes perfect sense. It flows from the original substantive motion, so I hope members will support it, because I think otherwise they will just look churlish and a bit silly if they don't support a sensible amendment like this. Thank you, Chair.
So we actually have to put, you have to put the closure motion to the vote.
Indeed. So a closure motion has been made from Councillor Bithell, is that correct? So that we will put that to the vote then.
So yes, Chair, the closure motion has been moved and seconded, Chair.
So indeed. So now we can put that to the vote. So can we do this by a show of hands, considering the time? Oh, that's a hand. Thank you. Which way are you voting?
Thank you, Mr. Chairman. I move that the vote be recorded. If members wish to set fire to the Constitution without even a full debate and move closure motions, then they deserve to have to put their names to it. I move that the vote be recorded. As we previously said, we can have all the standing up, or we can just stick to what we said, all votes recorded.
Have you got 10 people?
1, 2, 3, 4, 5, 6, 7, 8, 9. 1, 2, 3, 4, 5, 6, 7, 8, 9. Oh, Gillian is standing up as well.
So we have 10 votes.
Right then, Chair. So
Right, so it's clear what you're voting for.
this is the closure motion, Chair.
Indeed. So this is the closure motion for this particular part of the day. So
Councillor Banks. Gone. Yeah. Sorry. Councillor Bibby. Councillor Bithell. Councillor Broccoli.
Against.
Councillor Claydon.
For.
Councillor Coggins Cogan.
Against.
Councillor Collett.
For.
Councillor Crease has gone. Councillor Rob Davis.
For.
Councillor Ron Davis.
For.
Councillor Chris Dolphin. Councillor Rosetta Dolphin.
For.
Councillor Eastwood.
For.
Councillor Ellis.
Against.
Councillor Evans.
For.
Councillor G. Councillor Hadfield Jones. Councillor David Healy.
For.
Councillor Gladys Healy.
For.
Councillor Hodge has gone. Councillor David Hughes. Councillor Alistair Ibbotson.
Against.
Councillor Johnson. Councillor Christine Jones.
For.
Councillor Richard Jones.
For.
Councillor Simon Jones.
For, and I had to leave after this vote for work, Chair.
Councillor Lister.
Against.
Councillor Lloyd. Councillor Mackey has gone. Councillor Madison.
For.
Councillor Marshall.
Obliged. For.
Councillor Mullin.
For.
Councillor Owen. Oh, sorry, Councillor McEwen. Been and gone. Councillor Mullin.
For.
Councillor Owen. Councillor Palmer.
Gone.
Gone. Councillor Pears has gone. Councillor Priest. Councillor Priest.
That's you.
Councillor Carolyn Priest.
Carolyn Priest.
Against. I was just saying that Councillor Mullin voted twice.
No, he didn't.
He asked me twice.
Taking it name by name. How can he vote twice? We haven't got 2 Councillor Mullins down on the list. Chair, Councillor Richardson.
Against.
Councillor Rose.
Again.
Thank you. Councillor Solkeld. Councillor Swash.
Against.
Councillor Thomas has gone. Councillor Turton has gone. Councillor Wakelam has gone. Councillor Wren. Against. So, and yourself, Chair.
For.
So that's 23 against and 13. Sorry, that's 23 for and 13 against, Chair. The closure motion is carried.
Right, so closure to the next phase. And
So it's the vote now be put, Chair.
now, if that being the case, this is for the substantive.
This is for the amendment moved by Councillor G, Chair, that amplifying the review procedures.
Indeed. So we now vote on that premise put forward by Councillor G.
Right. Okay. So, so this is for the that the provision be suspended after 12 months until reviewed by Constitution and Democratic Services Committee. Councillor Banks has gone. Councillor Bibby. Councillor Bithell.
Against.
Councillor Broccoli.
For.
Councillor Claydon.
Against.
Councillor Coggins Cogan.
For.
Councillor Collett.
Against.
Councillor Crease has gone. Councillor Rob Davis.
Against.
Councillor Ron Davis,
Against.
Councillor Chris Dolphin, Councillor Rosetta Dolphin,
Against.
Councillor Eastwood,
Against.
Councillor Carol Ellis,
For.
David Evans,
Against.
Councillor Chrissy G, Councillor Hadfield Jones, Councillor David Healy,
Against.
Councillor Gladys Healy,
Against.
Councillor Ian Hodge has gone, Councillor David Hughes, Councillor Ibbotson,
For.
Councillor Paul Johnson,
Against.
Councillor Christine Jones,
Against.
Councillor Richard Jones,
Against.
Councillor Simon Jones indicated he was leaving. Have you actually gone, Simon? He has.
Sounds like so.
He has, Gareth.
Councillor Lister,
For.
Councillor Lloyd, Councillor Mackey has gone, hasn't he? Councillor Madison,
Against.
Councillor Marshall,
Anything. Against.
Councillor Mullin,
Against.
Councillor Owen, Councillor Palmer has gone, Councillor Pears has gone, Councillor Priest,
For.
Councillor Richardson,
For.
Councillor Rose,
For.
Councillor Solkeld, Councillor Swash,
For.
Councillor Thomas has gone, Councillor Turton has gone, Councillor Wakelam has gone, Councillor Wren. Abstain. And yourself, Chair.
Against.
So that is 21 against, 12 for, and 2 abstentions, Chair. So that is lost.
Right.
Are there any further amendments, Chair?
Any more amendments for this? So net.
Chairman, you've got this hand raised before.
Yes, you have the instruction.
Chair.
Let's keep it civil, please. So is that, who's that, Councillor Broccoli? So Councillor Broccoli, your hand was up. Thank
Yes,
you.
thank you very much, Chair. I would like to move that the debate be adjourned as so many of our councillors have gone home, although all of FPV are still here. I don't think it's appropriate to change the constitution with so few of our members present. Thank you.
So Councillor Brockhurst has may propose this. Is there a seconder for that?
Councillor Ibbotson, Chair.
Councillor Ibbotson has seconded this. So Councillor Biffle, would you like to say
Chair,
something?
people have argued in this meeting, including the people behind this the latest episode now. They've argued that we stay here until the business is completed. They've actually charged others here of going home before the business is over.
Indeed, there will
and
be a
putting
point.
in
There
the
will be a
hour.
point of order when I give it to you.
It's a complete contradiction of what they've argued for.
Thank you,
And
Councillor
shows you
Biffle.
how bizarre and how ridiculous this whole episode is.
I know.
And it's been organised by the puppet master himself, and we know it.
Councillor Biffle, thank you very much. Now, Councillor Ibbotson, thank you.
Mr. Chairman, Councillor Broccoli has moved a closure motion. They are to be put without debate. Councillor Bithell then started speaking anyway, not on a point of order, but to debate the closure motion. When I then raised a legitimate point of order, Councillor Bithell continued speaking and refused to yield, as would be proper. I would note that members of the administration quite frequently interrupt me with points of orders that aren't points of order, and despite that lack of courtesy, I yield to them. It is wrong for Councillor Bithell not to show the same courtesy when he is explicitly ask, Mr. Chairman, that you take the closure motion without further debate, as is right and proper. But before you do, I would ask that you ask Councillor Bithell to withdraw his remarks because he didn't have the right to make them and he was discourteous in failing to yield to the point of order. So I would ask that you call on Councillor Bithell to withdraw his remarks.
Councillor Biffle, you were outspoken at that point in time, and I would ask you to withdraw these comments.
Chair.
Thank you very much indeed. Very kind of you. So now we have a closure motion.
We
been seconded and proposed and seconded.
Yeah. Just This, Chair, is to adjourn the debate.
In its entirety.
It wasn't to move to the next item, Chair. It was to adjourn the debate. So, which would mean that we bring an end to this meeting.
And that's without debate.
Just adjourn the debate on that item.
Is it?
If I might explain, Mr. Chairman.
There are two different things, Chair, to adjourn a meeting and to adjourn a debate. Now, quite why we have that when we have also to move to the next item of business, I'm not quite sure, and it's too damn late to start thinking about it, Chair. So, Chair, this is just to move
from this particular point.
To move from this item to PB, Chair.
Point of order.
What is your point of order?
To be clear about what has been moved here for the public watching,
That's not the point of order.
There is a dispute over what is written in the Constitution here regarding what has been moved. To adjourn the debate, means that we'll pick it up next week.
That's not a point of order, sit there.
We're going to take a vote on it anyway. It doesn't matter. We're going to take a vote on it.
Thank you, Councillor Ibbotson.
It is that we will move to the next item of business, which is that we will adjourn the debate on this. We will come.
Councillor Ibbotson, that is enough. That is enough, actually, enough.
We will come back to this item. We would have to come back. We will move to the next item of business. We will have to come back to this item of business at a future meeting. There. So, are we going to do this on show of hands, or are we going to do this by recorded vote, Chair?
If we could do this by a show of hands, unless nobody objects, then, because it's a simple thing to know, can we do it by show of hands? Right, let's go.
Okay, Chair. So, all those in favour.
So all those in favour, please show. In the room. Online.
1, 2, 3, 4, 5. And online was 1, 2, 3, 4, 5. So that's 10 in favour.
Against?
Right. 1, 3, 5, 6, 13, 15, 17, 19, 21, 22, 24.
And for completeness, any abstentions? One, Carol Ellis. So therefore, this step is.
We carry on with this debate.
We'll carry on.
So, Chair, are there any more amendments to recommendation? I think we're still on recommendation 24.
Oh, yeah. Indeed. So, any more amendments to recommendation 24? So we can vote for this. So we shall put this to the vote.
So this is to vote for the amendment moved by Councillor Johnson. Yes. Sorry, Chair, just trying to record it on the top. That's any recorded vote. I'm worried about my colleagues' ability to correctly differentiate between which recorded vote we've had. We've had a lot just on this one, let alone on the others, Chair.
I'm quite the expert on these now.
So, this is voting on the amendment moved by Councillor Johnson in regards to notices of motion. Councillor Banks has gone. Councillor Bibby. Councillor Bithell.
For.
Councillor Brockley.
Against.
Councillor Claydon.
For.
Councillor Coffins Cogan.
Against.
Councillor Pollitt.
For.
Councillor Crease has gone. Councillor Rob Davis.
For.
Councillor Ron Davis.
For.
Councillor Chris Dolphin.
For.
Councillor Rosetta Dolphin.
For.
Councillor Eastwood.
For.
Councillor Ellis.
Against.
Councillor Evans. For. Councillor G. Councillor Hadfield Jones. Councillor David Healy.
For.
Councillor Gladys Healy.
For.
Councillor Hodge has gone. Councillor David Hughes.
For.
Councillor Ibbotson.
Against.
Councillor Paul Johnson.
For.
Councillor Christine Jones.
For.
Councillor Richard Jones.
For.
Councillor Lister.
Against.
Councillor Lloyd. Councillor Mackey. He's gone, hasn't he? Councillor Madison.
For.
Councillor Marshall.
Obliged. For.
Councillor Mullin.
For.
Councillor Owen. Oh, Councillor Palmer.
For.
Councillor Pears has gone. Councillor Priest.
Against.
Councillor Richardson.
Against.
Councillor Rose.
Against.
Councillor Salkeld. Councillor Swash.
Against.
Councillor Thomas has gone. Councillor Turton has left. Councillor Wakelam has left. Councillor Wren.
Abstain.
And yourself, Councillor Cox.
For.
So that's 22 for, Chair, 12 against and 2 abstentions.
So this is,
The amendment is carried.
the amendment is carried. So that being the case, we move to our final recommendation.
No, I don't think it is, Chair.
No, just wishful thinking.
Wishful thinking, Chair, I'm afraid. It's recommendation 26.
Sick.
Oh
no.
No, we didn't get agreement, Chair, around recommendation 26, I don't think. It was a blue. There was the possibility of compromise. We discussed it earlier, and my recollection is that we didn't approve it.
Okay. So therefore we need to discuss it.
Because we were trying to clarify that the rule would not apply to those actually, that the rule would only apply to those actually invited or called to address the committee. And I think the sticking point came because the words decision makers as decision maker wanted to be added, and there was no agreement to that, Chair. So, Chair, that was Councillor Ibbotson who was suggesting that.
So, Councillor Ibbotson, are you ready to pick up the baton?
Yes,
Does it-
absolutely, Mr. Chairman. It is my absolute delight to still be doing this at whatever time it is. Now, let me set out what we're talking about here. Where people attend as a decision maker, it should be possible to hold them to account. When they have made a decision or are going to make a decision on an issue and they are present, whether they have been invited or not, they should be subject to questions. The rationale for this is that if we don't include this, by explicitly excluding a group of people from being asked questions who thus far have been available for it, we get into a situation where an administration, either this one or a future one, and I have thus far caveated my remark by saying, I'm sure this administration wouldn't, but at this point in the evening, I'm no longer convinced of that, could essentially refuse to send people without, and refuse to have people available to ask questions when they are the decision maker, without going down a formal process of summons to committees, which is loads of extra work for no good outcome. It's extra work for chairs, it's extra work for cabinet, and it's extra work predominantly for democratic services. It also means that every single committee is going to have a standing item where we say, and who do we want to summons to the next meeting? And given that the agendas often include items which aren't on the forward work programme because they turn up at late notice or they're moved backwards or forwards or whatever, there's basically going to have to be blanket summonses issued to all plausible decision makers, which means a lot of cabinet members being summoned to things which they would otherwise would not have to attend. It would be a complete waste of everybody's time, which at present isn't an issue. We are introducing the issue. This amendment simply seeks to remove that potential problem. Now, will it be accepted by the mover and seconder of the motion? I honestly, with this one, it should be utterly uncontroversial. I can't think why they wouldn't. I'm sure they'll come up with some reason, and I'm really looking forward to hearing that one. But I wonder if they do refuse, as they did last time, whether they might at least dignify us with an explanation as to why they're refusing, because it isn't particularly helpful to say, "Oh no, we're not taking that on board," but not saying why. I think that if we're not making simple common sense changes, then we really ought to be given reasons for that. And so I would ask that members show that courtesy to the meeting. And I move the amendment.
So seconded, Chair.
So do we have a second for that?
Councillor Priest, Chair.
Councillor Priest, you're seconding. So, thank you very much indeed. Councillor Bibby, you put your hand up there, or not? Richard Jones did.
He did. Could you just repeat what he's going to suggest as the, because the actual document itself here just recommends that what is written for scrutiny will be replicated on other committees. And the proposal is there clearly just to replicate what is already in 9.7 to the other committees, isn't it? So is that what he's suggesting?
So, Councillor Robertson, there's been a question in terms of clarificational point there for you.
Yes or no?
Thank you very much, Mr. Chairman. It's very hard to answer that, because the issue that we've got is that we don't have language for this. So we don't actually know what we're voting on, in common with a lot of these. There's this bit at the bottom that says that provided that blah, 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 the Labour, the Independents and the Eagle groups will agree. But that language is yet to be formulated, presumably. So we can't see it. So we can't easily just say, oh yeah, insert these words here. So it would have to be into that verbiage, a general sentiment that, oh yeah, provided that decision makers who are related to a decision ought to attend and ought to be available for questions. And can't just sit there observing and refuse to take part when they are the decision maker in relation to an issue under discussion by the committee. I appreciate where Councillor Jones is coming from, asking for a particular form of words, and were I in his shoes, I'd be minded to do the same. It's just very difficult, given that we're being asked to approve changes to the Constitution without the language of those changes that are being moved in front of us.
Mr. Richard Jones, Councillor Richard Jones.
Yeah, thank you. So I'm just reading from the papers very clearly. It's recommended that section 9.7 questions at the Overview and Scrutiny Committee be replicated as the process for dealing with questions at other committees. So I don't see what the problem is. I mean, I'm assuming that everybody's happy to do that with other committees. And whatever's written in the scrutiny at 9.7 would be replicated on other committees. It's as simple as that. And if that's is what Councillor is suggesting, then I've got no problem with that.
Councillor Bibby.
Accept that as an amendment.
Fair go. That's excellent. Accepted.
Councillor Madison.
And Councillor Madison, you accept the same thing? Accepted. So, that being the case then, can we do an all in favour for that, as it's been mutually agreed by?
It's constitutional change. So recommendation 20.
You haven't spoken yet, so unless you're going to, you have spoken prior, so presumably you want to clarify that.
Yeah, the question I was asking, just make sure that if the monitoring officer does have the wording for 9.7, just so we can hear it, maybe that would be useful. I'm assuming that he might have it at his hand. And if it replicates what he's saying in the response there at the very bottom, then I think that would be that's what we're voting on.
So for absolute clarity, that's acceptable, I believe. Just bear with 1 second. Thank you.
There's two 9.7s. Sure.
It isn't section 9.7, it's rule 9.7 in part 4. So, questions at overview and scrutiny committee, where a person attends before an overview and scrutiny committee for the purpose of answering questions, the chair may allow the person to make an opening statement. Members of the committee will each be permitted to ask questions of any person attending the committee for the purpose of answering questions. The order, number and duration of questioning by members of the committee shall be determined by the chair of the meeting, and a person attending the committee for the purpose of answering questions will be expected to normally give an oral answer or to nominate someone else to present, someone else present to answer on that person's behalf. And then there is a couple of notes about where the answer would involve the disclosure of exempt information. You need to consider going into excluding the press and public, and somebody is eligible to decline to answer where that would be permissible in court. So that was the wording that was being suggested to be added into or being extended to all committees. So currently it says 9.7 questions at overview and scrutiny committee. We would presumably just reword that to say questions at all committees.
That seems perfectly adequate to myself, and if the other people are, that's an amendment. If that's an amendment to agree, I'm happy with that.
Good. So therefore we can vote on that now.
Yeah, and this is a recorded vote. Is there anybody who wants to vote against that? No. So there we go, Chair.
And there's nobody online as well. At the same point.
That's carried then.
Just for
Chair.
clarity.
And
Thank you. We have one remaining point then.
Well, we've got 2 points, Chair, haven't we? Because there is something to be moved by the independent group that needs to then stand adjourned.
Okay.
It's a formality, Chair, but we'll need to do it at some point. And then we also have the final recommendation, Chair, recommendation 27, which is, this was a discussion about holding a secret ballot. And the recommendation from the committee was that the threshold for holding a secret ballot should be increased to 50% from the current level, which I think is only something like 25%. Well, it's slightly different. The current threshold for holding a secret ballot in county is 20 members. What percentage that is of 67, I'm not quite sure. Roughly 1/3. Slightly less than 1/3. At committees or subcommittees, the threshold for a secret ballot is 1/4 of the membership of the committee. And the intention was to raise that in the interests of openness. So that's the proposal, Chair, that it goes from 20 at full council to 34. And that it be whatever half the number is of the committee. Varies, of course, by the type of committees. Chair,
does it not matter at this
point? Well, Labour indicated that they do not support the recommendation suggesting 51%, Chair. So
right, we'll move to the Labour group. So that being the case, thank you. So, Councillor Johnson, could you?
Thank you.
Comment,
Thank you,
please?
Chair. It's getting late. It's a very, very simple one. Again, as explained earlier, a secret ballots. The threshold is 50% of all those members. We do not feel it is appropriate for the chair to have the casting vote on it. So it's quite simply to make sure that there is no casting vote upon it. Arguments that you won't go and move into a secret session we find quite peculiar. So that's 351%. No casting vote from the chair. You should be put in that position to go and do it yourself. On the program that may well go and take it yourself.
Thank you. We need just some more speakers on the same thing. Was he going to make that?
Is there a seconder for that amendment?
So, Richard Jones, are you seconding that? Well, let's do the seconding bit first. so to speak. It is very late in the day. It's not, at least it's not third. So, and then we can have a chat. So, fire away. You're seconding.
Yeah, the question was, I've never known a secret ballot ever to take place in the council or any council I've been in, town and community or this one. Can I ask what is the purpose and why should we need it?
Chair, Schedule 12 of the Local Government Act specifies that methods of voting are to be members present in the room and show of hands. That was amended when we moved to remote voting, but essentially what we talk about is a show of hands and being the method of taking a vote unless some other method is invoked, such as a recorded vote or a secret ballot. They're not common.
Chair, when would you need a secret ballot? That's all I'm asking.
Well, that's as varied as the people that might request it, Chair, because it's open to any member to request it at any point in time, provided they've got sufficient support. I think they've typically been used in the past around voting on chairmanships and things like that, where people didn't necessarily want to be perceived to be critical of a person in public.
Okay.
But no, Chair, I can't remember. I've been here 14 years, and I don't think I've seen one in the 14 years that I've been here.
Okay, so what we've got then is a situation. You'll be there in a minute, Councillor Bitton. Hello. Thank you. Nearly there. I haven't quite finished yet. So what we're saying is this is a piece of constitutional legislation, one would say, whereby there's a little perceived need, as we can see today, and even tomorrow. Who knows? But it sits there, sitting there. And so as we're dredging everything up and looking at things under a very bright light, it's probably it is an opportune time to sort it, fix it, if it needs sorting and fixing. And on that premise, I'll hand over now to Councillor Ibbotson, who'd like to speak on the subject, no doubt.
Thank you. Yet again, we have a misunderstanding over the idea of 50% or 51%, and ignoring the issue with 51% being more than half. We come back to this idea of a chair's casting vote. There isn't a casting vote at the moment. If 20 people put their hands up, that's a ballot. In the same way as if 10 do, that's a recorded vote. If only 10 people stand for a recorded vote rather than 10, the chair doesn't get a casting vote on whether it happens or not. It happens because there's 10, it doesn't if there are 9. It's that simple. The number for ballot at the moment is 20. This would raise that threshold. And it's a proposal from Flintshire People's Voice because we think that the threshold for balloting should be higher than it is at the moment. We can argue about the exact threshold. 50% seems sensible because that, in effect, in this council means more than 50%. But the idea that there's chairs casting votes on this betrays a lack of understanding of what is actually under discussion, which causes me severe anxiety over the understanding that members have had whilst voting on other things. And you know, it's the same few people throughout this meeting on both sides of the chamber who've been standing up and speaking the most. I know that members will be pretty sick of my voice by this point. But we've also had a lot of amendments because at no point have we suggested adding anything into the Constitution that isn't there already. We've suggested commentary to go with things. We've suggested rejecting some changes. But we're having amendments posed on the fly by people who are betraying a lack of understanding of what they're actually amending as it is and what their amendments mean. I'm really, really concerned about this, Mr. Chairman. I think that some people need to go away from this meeting and reflect very carefully on their understanding of the Constitution and their actions in relation to voting to amend it without a full understanding of the document itself.
Thanks for your analysis there, Councillor Ibbotson. Point noted. I must do that. So we've got other people to speak. Sean Bibby, please.
Just to accept Councillor Johnson's amendment as part of the substantial.
Thank you. Councillor Jones?
Yes, I accept.
Councillor Madison, you need to accept the same thing.
I do, thank you.
Thank you. Councillor Ibbotson, yes?
Forgive me, Mr. Chairman, whilst
It's a point of order, by the way.
Yes, it is.
Oh, sure, it would.
Forgive me, Mr. Chairman, whilst I get the relevant section of the Constitution up, because I know that you're keen to have reference to specific numbers. But the acceptance of an alteration by a proposer and seconder must be done with the consent of the meeting. The consent of the meeting might be deemed if nobody objects, but if somebody does object, then presumably there needs to be a vote to determine whether or not it is with the consent of the wider meeting. I would suggest, therefore, that this does need to go to the vote.
Just if it helps, Chair, it's 13(7)(b). A member may alter a motion which she has moved without notice with the consent of both the meeting and the seconder. The meeting's consent will be signified without discussion, so it just takes a single person to say no, and then that means there is no consent and you'd have to go to a vote. I did hear a no, by the way.
So that being the case, then we'll have to go to a vote to agree this.
Yeah, I mean, because even if it's still a motion, Chair, we would have to go to the vote in any event. It just means we have to vote twice
Yes.
because it's an amendment. And I've got one recorded vote sheet left, Chair.
Well, have you got?
I don't know whether my colleagues have any more in the wings, but so this is recommendation 27. It is an amendment, and it is that the threshold for secret ballots be 51%.
So are we all clear on what we're voting for? Well, I'm voting for Christmas lamb and turkey, so.
All right. Okay.
As long as can be that
We've still got a yes or a no on it.
We've still got to take a vote.
Yeah, so what we'll be doing then is taking one vote, as I understand. Point of order, yes.
When Councillor Johnson said that, he didn't have his microphone on. I think I managed to catch the gist, but members online won't know what they're now voting on. So I wonder whether he might be able to repeat it with his microphone on for the benefit of those members online.
Thank you. If you could just repeat that for us, Councillor Johnson, to the troops.
I am serene, I am calm. I think it is very, very important that staff welfare is our priority. They've been here for a long time listening to a lot of conversations, which I'm sure they will go back and merrily tell their children when they get home the wonderful day they've gone and had. So in the interests of everyone's welfare, I would like to, I'm just going to withdraw it. Simple as that. And if Councillor Madison and Councillor Bibby are prepared to accept my humble withdrawal, I'll be very grateful.
Thank you, Councillor Johnson. It's very difficult to hear you sometimes. Just like to comment because you seem a very low voice, but just a comment. So,
So, Chair, we're going to go to the vote on recommendation 27. As on the papers, the threshold for a secret ballot will be 50% because Councillor Johnson has withdrawn the suggestion it should be 51.
So,
Councillor Banks, welcome back.
Oh, he's back.
I'm back. 4.
Councillor Bibby. Is everybody going to vote for this? Anybody going to vote against this? There we go, Chair. I'll just tick all the boxes. So there we go. That one is carried then.
Councillor Richardson.
Councillor Richardson, you have some comments?
Sorry, yeah, I'll vote against, please.
Yep, thank you.
Sure.
So that is passed as it is.
So, and adjourn something that is subject to 21.2. Yay! And
are you sure?
I am quite sure. There we are, Chair. We got there in the end, didn't we? So it's subject to 21.2. So, Chair, if Councillor Jones could move that, then
please, thank you. Thank you,
move on.
Councillor Jones, thank you.
Yeah, Chair, I'd just like to move the item that I think has been passed around to all members, either electronically or on paper. This refers to the chair of committee meetings. So I'd like to move this item, understanding that actually it will be adjourned under 21.2 to the next available meeting. Thank you.
Green. So by definition, that has to happen.
So there's agreement or not, Chair?
Indeed, seconded or not, it has to go there, so it's going.
Yeah.
Thank you, Councillor Jones. Thank you.
That brings us on to political balance, Chair.
Yes.
So, Chair, political balance. There are going to be further changes to the membership of the Reform UK group. They notified me this morning. I haven't had a chance to reflect it. So this political balance will have to be redone in September. On that basis, Chair, we managed with political balance quite quickly, do you think?
I'm really hoping for this to happen, that indeed, because again, we will be looking at this in September time when the situation could alter again, who knows? So what we're looking for now is a rapid resolution of political balance debate. You, sir.
Just to ask the monitoring officer, has a group leader requested this political balance?
Has a group leader requested that the political balance be reviewed today? Yes.
So can we take the political balance to the vote?
I think it was yourself, Councillor. I'm looking at you, Councillor.
When? I did it. That was before, but you made the announcement that we were actually saying there was one less in our group. But now you've just said that that isn't the case.
So we've had a number of moves, haven't we?
Yeah. Sorry, Chair, I didn't stand up.
See it, Councillor.
Chair, we can't hear any of this online.
Sorry, my fault.
Sorry. We had all those moves. I had understood Councillor Ellis wanted a review of political balance. If she doesn't, Chair, then the requirement to do political balance as soon as reasonably practical is after a request from a group leader, after a change and a request from a group leader. If we don't have a request from a group leader, then we can just move on and we can do the notice of motion.
Move on for me. I can't. To be honest, but there you go. I won't argue with you, Gareth.
So, Councillor Lloyd.
Thank you, Chair. Thank you. Can I move that this item of political balance is brought back to the September meeting? Lots of movements going on. Yeah. People changing groups. We can't see the point of discussing it today. So I propose we bring it back to the September meeting.
Seconded. Do you second that?
We have a transit group.
Sorry, Chair, it was Councillor Brown, who isn't here, and so others would not be aware.
Accept your apology, Gareth.
Chair, when I apologise to you, I apologise to the meeting. I am talking to the meeting as a whole because I am talking through the chair as I am required. But yes, I will also apologise to Councillor Ellis. It wasn't Councillor Ellis. It has been a very long day, Councillor Ellis. I've been in work since 8 o'clock this morning.
You had me feeling I was actually going mad then at one point.
I do apologise. I'm not trying to gaslight you.
That I didn't recall.
I'm not trying to gaslight Councillor Ellis, Chair.
So we have a vote. Thank you.
But it was Councillor Brown.
Councillor Brown.
From somewhere, Chair.
So we now have a proposal to move this item to September and seconded.
I don't think we can, Chair. We've had a request we have to do.
Okay, so
Chair, I'll move the PB.
Right, do you have a seconder for that? So we have a seconder to move the PB, and now we'll open the floor. Councillor Ibbott.
Thank you, Mr. Chairman. We had on, I think, 3 or 4 political balances ago, a discussion about how officer political balances are prepared, and we were told that they follow a rigorous process to ensure that they are completely fair to all groups and that seats are allocated in line with a strict priority, and that the allocation in particular of seats on the planning committee was simply a product of that and not a political decision. And we were informed that the reason why the independent group had same number of seats despite having a higher entitlement to seats was a result of that. And so I deeply regret to draw members' attention to the political balance version 2 on page 25 of today's agenda pack. And I draw members' attention, first of all, to the Flintshire People's Voice column and the number of planning seats. Now, members will see that we have an entitlement to 1.54 seats on planning, and we have been allocated 2. So we have an over-allocation there of 1.52 seats, and we have an over-allocation of 0.48 seats. Fine, makes perfect sense. Now, I invite members to move their eyes slightly rightward on the planning committee to the Reform UK column. Reform UK have an entitlement to 2.03 seats on the planning committee, but they have been allocated 1. That is an unlawful allocation. Yeah. It is more than 1 seat out. So the idea that this is scrupulously done, I think, is somewhat, well, I shan't say anything further, but I am concerned that the allocation that we have got today is simply not legal and balanced. It disadvantages Reform UK on the planning committee when it over-advantages Flintshire People's Voice in terms of number of seats on that committee. By rights, they must take one of our seats. I invite somebody to come up with some maths to do something else, but that is the reality. They're entitled to that seat, and they should need to take it. And so, and obviously in return, we would receive something from them, and they may wish to suggest what that something would be. I won't prejudice or pretend to speak for them. But this proposal that we have got is not legal and balanced. We have been here before, I might add, and it concerns me deeply that something so important we have this kind of error in.
Councillor Ibbotson, are you contending that this is an element of bad faith on behalf of the council?
I said no such thing, Mr. Chairman.
You did, but I was asking just for clarification or point of view. So the answer is no. Thank you. Councillor Johnson.
Thank you, Chair. So let's be clear. There are a lot of political movements between groups the past couple of months. And I don't think anybody here will actually turn around and say, it's going to be stopping like that, because it isn't. There's still a lot of shaking out going on. We can sit here for as long as we want discussing this document, or we can be realistic and say, discuss it in September when we are clear about what the actual numbers are going to be. Yeah. It is as simple as that. Yeah. And then Councillor Ibbotson can decide that his committee, his group, may actually go and take the place on the planning committee they are so desperate to do. So I look forward to that coming forward as well. But my proposal, Chair, is that this is deferred until September because there is no urgency to go and take it at the moment. Thank you.
Everybody could vote for it without veto, Chair, or yes, it could be deferred.
Indeed. So,
Chair, I drafted it, so I do apologise for getting them for missing that. It's quite correct. Should be at least 2 there, and we would be reducing the reforms entitlement elsewhere and passing something else to the Flintshire People's Voice.
Indeed. So,
or reducing
the small mistakes made, apologised for. We can fix this by deferment to the September meeting. That's been proposed, as I understand, seconded. So I'd like to bring to a discussion And your point, and you'd like to say something on that, because it's now a proposal with a seconder, and you have the right to speak on it.
I'm not quite sure that deferral to September is legal, given that it needs to be resolved as soon as practicable, and that this is now the second meeting that we've had since some of these moves happened. If the business cannot be concluded today, then it is for the chair to set a follow-on meeting within the defined timescales to conclude the business of today. So that would be a continuation of this meeting rather than defer it to the dark depths of the autumn. I think that if we are going to do this, we need to do it properly. So if somebody's proposing to close the meeting now, then this business would be continued at the next, at a later date to be set by the chair.
Thank you. So,
I'm conscious, Chair, the look of glazed faces and the blank faces staring at me, Chair. People may not have followed that, and I appreciate that people haven't had the chance to talk about it. So, Reform would have 2 on planning, the FPV would have 1, Reform would have 1 on constitution, FPV would have 2.
Councillor Johnson.
Thank you. Just as a matter of clarification, I really appreciate the hard work of the monitoring officer at such a late hour, recalculate the interests so that FPV can serve on the planning committee. I am sure, given their past position, they're going to say now, fantastic, we're going to have that training in August and we're there at the September planning meeting because you, Gareth, the monitoring officer, made those changes for us. And I look forward to the answer being silence. Why is that, I wonder? Is it games? Who knows? Thank you.
Before we do a point of order, I'd just like to say something myself. I'm trying to focus the end point of this meeting on the last knockings of what we need to decide, which may cover your point of order, I hope. And indeed, what we're saying is we did have a slightly defective political balance, which has been corrected. It's been corrected in a simple terms of just altering a couple of positions, which are, I hope, because it's clear to me, and I'm not the brightest knife of the drawer, but it's clear enough that I can understand what the end position is. So, given the fact that we all understand what the end position is, because it really only affects a couple of groups, really, therefore, we could now take a vote to accept this as it is. Now, the ongoing consequences of having these new seats and new facilities is up to those particular people in those particular political groups, stroke parties, stroke whatever you want to call yourselves. So that's fine to me. So I think we can progress ahead with voting for this today, now, to move it on. So, Richard Lloyd.
Yeah. Yes, can I move that, please, with the changes that Gareth has made, please?
Second.
You're going to say something now?
Yes, Mr. Chairman, I was raising a point of order. Councillor Johnson seemed to be suggesting that other members should interrupt him when speaking, which of course is not on. He then made inferences from about other members' failure to breach the rules as he wanted them to for theatrical advantage. I think that was quite improper of him, and I hope that he will withdraw those remarks. It is not appropriate for councillors to seek to encourage others to breach rules of procedure and then to chastise them when they don't.
Thank you.
Thank you, Chair. I will offer the apology, and I'm sure that Councillor Ibbotson would also like to apologise to me for suggesting that I was introducing an enabling act, which was brought in by the Nazis in 1933.
Okay.
So,
Indeed, this conversation is now, in my opinion, ceased. I mean, in terms of, we're all grown-up folks here, and enough apology have been bandied around the room to satisfy a lot of people. So now we have a proposer, we have a seconder to get this political balance over the line, and I'm bringing this to the vote now. Can we do this by show of hands, do we think? Everybody, anybody, everybody, people online? So people in favour of the political balance as amended by our monitoring officer, please show now. So everybody in the room.
Certainly carried, Chair.
On the line.
It is, Chair.
And it is. There we are. So that's political balance approved until the next time it's reviewed, which would be next.
Notice the motion, Chair.
Now,
Councillor
nearly
Swash has
there.
noticed the motion.
We have Councillor Swash. Are you
Still there, Chair?
still there?
Hanging in.
Good man. Right. So it's your go now. So it's notice the motion to be presented by yourself, sir. Floor's yours.
Thank you very much, Chair. I think we would all agree that planning decisions are amongst the most important decisions that this council makes. They can change our communities for generations. Because of that, it isn't enough that planning decisions are lawful. They and all of the decisions surrounding them must also seen to be fair, transparent and accountable. Public confidence in the entire planning system relies upon that. As is made clear in the wording of the motion, this is not about any planning application per se. It is about ensuring that the processes surrounding planning are as open as they reasonably can be. And over the recent months, a number of concerns have arisen. Why was roll call voting at planning committee discontinued? Who authorised that decision? Under what authority was it made? Was it considered through proper constitutional processes? When and where was the decision communicated to members of this council and to the public? I don't think those are unreasonable questions. I don't think they're difficult questions to answer, or they shouldn't be. They're questions about how this council conducts its business, and I don't believe they should remain unanswered. Members should not be expected to take it on trust that everything was done correctly without those questions first being examined openly. Likewise, concerns have been raised recently about discussions relating to planning matters taking place in privately held meetings following planning committee, and also through the planning strategy group, a body whose meetings are not open to the public and whose agendas, reports and minutes are not routinely published. Understandably, these things combined give off a perception to residents that important planning matters are increasingly being discussed behind closed doors. And as I said earlier, perception really matters when it comes to planning. And that's why this motion, it doesn't prejudge any of the answers. It doesn't say that any procedure has been breached. It doesn't say that any decision was improper. It just asks that the Constitution and Democratic Services Committee review these matters, establish the facts, report back to us at full council, and consider whether any changes can be made to improve transparency. If everything has been done correctly, then that report should reassure both us as members and the public. And if improvements can be made, then we should obviously make them. Either way, it benefits everybody. So ultimately, it's a pretty straightforward choice in front of members today on this motion. We can agree that these legitimate questions should be examined openly, the facts established, and any necessary improvements made. Or we can vote against the motion, in which case those questions will remain unanswered, no report will be produced, and residents will inevitably draw their own conclusions as to why this council was unwilling to review these matters. Thank you, Chair.
Thank you, Councillor Swash. So, presumably you're seconding this. Good. So, excellent. So we have a proposer and a seconder. So it's now open. We'll open the floor for debate. Councillor Jones.
Yeah, thank you, Chair. It's fairly unnecessary to resolve as the 3 bullet points show, and I'll give the reasons why. So, actually, I entirely agree with Councillor Swash that the planning decisions can have a significant and lasting impact on Flintshire communities, and that the process must be transparent, which it is. I would go further and suggest that decisions must also be consistent. Prior to COVID, roll call voting did not routinely take place at the planning committee. And as with other committees, this was introduced as an emergency measure when meetings took place exclusively online in order to assist the chair of the planning committee and the council's legal officer. when counting votes in a pressurised and unfamiliar environment. All of the committees of the council have since reverted to standard voting, with recorded voting undertaken only when formal propositions to do so have been made and carried. It was agreed by members at the June's meeting of planning that, in line with all of the committees, planning committee would revert to the pre-COVID arrangements. All the council's planning committees meetings are recorded anyway. This means that Flintshire communities can see how members of the planning committee vote by viewing the recordings. This matter was discussed at the June meeting of the Planning Strategy Group. Planning strategy is described in paragraph 6.5.5 of the Constitution as a working group, which makes recommendations on a range of planning related issues towards benefiting and making improvements to the planning process, such as reviewing performance, considering the implications of appeal decisions, identifying training requirements to the Council, Cabinet, Environment Scrutiny Committees, Constitution and Democratic Services, Planning Committee, or to the Chief Officer, Place and Growth. So PSG, Planning Strategy Group, is not a committee of the Council. It has no delegated decision-making powers. It cannot determine planning applications. It cannot make decisions which are binding upon the Planning Committee. It acts purely in an advisory capacity, and consequently is not subject to the same statutory access to information requirements that apply to formal committees exercising council functions. The council receives between 1,000 and 1,200 planning applications each year, and around 97% of these are determined by our highly trained planning officers under the council's agreed scheme of delegation. This high percentage is because the majority of planning applications received by the council are relatively minor, non-contentious, and the delegated process is the most timely and efficient way of determining them. Applications of a certain size and nature fall outside the agreed scheme of delegation and are automatically referred to the Planning Committee for determination. In addition, it is important to note that members have a right to call any application to the Planning Committee for determination. Quite rightly and appropriately, discussions regularly take place with applicants, agents and developers in order to improve proposals and secure schemes which can be permitted in accordance with the long-standing presumption in favour of sustainable development. Similarly, discussions take place with applicants, agents and developers, and indeed elected members with regard to the appeals process, particularly to agree areas of common ground and to agree technical matters such as conditions and legal agreements in the event that the appointed inspector is minded to allow an appeal. These meetings are not recorded beyond an officer file note. All planning decisions made by the council are supported by either a delegated report or a committee report which explains the rationale behind the officer's recommendations. These can be all viewed online. As Cabinet member and a former member of the Planning Committee, I fully agree that councillors should be encouraged to exercise their independent judgment when determining planning applications. However, it is equally important that members give appropriate weight to the advice of the council's planning officers and technical consultees and understand the risks, including the financial risks to the council of not following that advice. It is also very important to note that the role of the Planning Committee is to make decisions for the benefit of the county as a whole rather than just for the ward in which they sit. In summary, I entirely agree with Councillor Swash's assertion that transparency in the planning system and associated decision making is very important to give the general public confidence and assurance. However, members will appreciate that the planning system often involves difficult and controversial decision making, which can lead to sections of the community feeling disappointed because an outcome was not of their particular liking. Unfortunately, this is unavoidable, and I am entirely satisfied that the current planning arrangements meet our statutory duties, provide transparency in the way that decisions are reached, and also stands up to external scrutiny. And those are the reasons why I don't believe this notice of motion requires any action. Thank you.
Thank you. It's very timely. So, further speakers on this subject? Councillor Lloyd.
Thank you very much, Chairman. Thank you. Council Procedure Rule 15 of Flintshire County Council's Constitution for all committees states the standard method of voting is by a show of hands. Recorded votes can be requested by 25% of committee members present if they request it. It's ironic that these This notice of motion has come from the leader of a group which refuses to take up their 2 allocated places on the planning committee as per the previous political balance. The reason for this notice of motion is not about being open and transparent. It's because a recorded vote is often used as a political weapon to discredit councillors and create defamation of their characters by posting their names on social media when applications go against what either the local member or the residents would have liked. I've experienced this personally and been wrongly accused of obtaining brown envelopes, backhanders by residents, which were very upsetting for myself and my family. I've also been accused of being corrupt by residents on that social media page. If anyone can provide me with any proof of these accusations, I would love to see them. Previously, before COVID, all voting of planning committee was by a show of hands. Recorded voting was only introduced due to COVID when all meetings were held online. It's a shame that the press don't want to have heard both sides of a story before publishing comments they have seen on one council's social media, which they assume are accurate when they are often not. Perhaps the press need to watch the video recording of the meeting instead. I've taken the liberty to check on other councils' way of voting. Cheshire Planning Committee, vote by a show of hands. Wrexham Council, vote by a show of hands. Gwynedd Council Planning Committee, vote by a show of hands, unless a recorded vote is requested, of course. Anglesey Planning Committee votes by a show of hands. Conway Planning Committee, vote by a show of hands. Denbighshire Planning Committee uses electronic voting system in the chamber and by a show of hands if that electronic system fails. I urge members to vote against this notice of motion. We don't need it, as the facility is already in place for the committee to ask for a recorded vote when 25% of those present on the committee request it. Thank you very much, Chair.
Thank you. Councillor Biffle.
Yes, thank you, Chair. The planning committees are open to the public and indeed open to non-members of the committee who can attend. And again, there's a cross-section really of political parties under the political balance arrangements whereby all parties are represented on the planning committee. That is subject to them actually accepting the places and taking up those places which are attributed to them. So, you know, it is open and transparent. And again, we're online too. People who are not present or can't attend the meeting can watch the actual meeting online. And, you know, as members, we're there in the position where we have to show our vote so people can see how we vote. Without having a recorded vote, it's obvious and can be seen by everyone. So there's nothing here underhand or not transparent and open. It is perfectly open and transparent. And again, you know, some of these comments, I think, are really being made by someone who has refused to sit on the planning committee, although entitled to a seat if they want to take it. And again, have little knowledge then, in my view, of the whole process of the planning, and not only little knowledge, but no understanding really of the situation either. And we have been encouraging them to actually take up the position so they are enlightened to a certain extent as to what is involved in the planning committee. Now, being a councillor involves one having to make difficult decisions at times, very difficult decisions at times, but it is part and parcel of our role. Somebody has to do it, and these decisions have to be made. And planning puts you on the spot. Over the years, I've known people in my own group who've come on planning very enthusiastically and have gone off it very quickly because basically they don't like being put in that owner's position whereby you have to upset people. It's a difficult decision because, again, the applicant, if the planning application is passed, is very happy. But you can bet your life there'll be 2, 3, 4, even 300 people who are opposed to that particular application. And again, we're quite used to that. But again, as I've said many times, and I repeat, the planning committee isn't a popularity committee. We have to make decisions based on pure planning factors, not on how much we are liked for it or how much people will pat us on the head and say, well done, thank you very much. We have to make those decisions, and we have to make them in accordance with planning policies and principles. Now, again, sometimes, that's very difficult for us, but nevertheless has to be done. I've sat in this committee meeting here with people behind us paying behind us for our blood to be quite frank, because we actually saying things in that meeting which has to be said and is in accord with our planning policies, and they obviously oppose that. And again, we need to know where this particular notice of motion is coming from here today, because it's by somebody, a local member, who opposed a particular allocation of land in his ward. Well, welcome to our world, Chairman. That's all I can say, because again, you have to have land on which to build houses. You know, again, many people here, I'm sure Councillor Swash himself, pays lip service to the need of housing. And we've got housing lists here to prove it. People want to purchase houses, people want to rent houses under social rent. And the only way that we can achieve it is through the planning system and Section 106s. So basically, we are required again by Welsh Government to make provision for the future population of our particular area. And that includes our children, grandchildren, and so on and so forth. But in order to desire or to get to the actual end game, namely getting more houses for people to live in, it does require us having to allocate land and actually vote for that land to be developed. Now, I think I've said before, I think we had about 7,000 applications for consideration of pieces of land to develop on as a planning strategy group. And we had to go through them all with officers and test them according to the tests that we laid down as what would be a suitable site for development. And as a consequence of that, we whittled those 7,000 application sites down to 10. And again, that's something important to remember. It's a difficult decision. Now, yes, the developments in my area, it didn't go down very well. I didn't particularly take great delight in voting for that. Neither did Dave Healy and Gladys Healy and other members here who had land allocations within their particular ward or their area. But it's necessary. In order to build houses, you need land, and you need land which has been carefully considered and put forward as preferred sites for that development. And that's how hard it is. Okay, so, you know, I'm certainly opposed to this particular application because there's no relationship to the realities of life, Chair.
Thank you, Councillor. Councillor Coggins-Coggin.
Thank you very much, Chair. The preceding item, which was the changes to the Constitution, we heard time and again from the administration how it was all about transparency and openness. It appears that we've now switched to there being, when we're discussing this notice of motion, that there can be such things as too much transparency. It's very best, you know, we don't look into this and we don't look into that. Best to keep decisions behind closed doors. The Deputy Leader of the Council agreed with the mover of this motion that the process must be transparent, but again, not too transparent. Best just to keep decisions behind closed doors. I'm at a loss how we reconcile that. We've also heard about the publishing of recorded votes leads to defamation. Just so members in this chamber know, the truth is a complete defence to defamation. That there is no defamation if you have acted in a certain way. You can't claim to have been defamed if the activity you be sorry, it's been a long day. Sorry, Chair. I mean, I'm going to listen to my better judgment because whilst I would absolutely adore to discuss Councillor Bithel's, by his own comments, little knowledge, it is an open goal too wide for me to take on right now. It seems perfectly sensible to me. I don't understand what the issue is. It will get referred to a committee to have a look at. If there's no issue, it will come back with a clean bill of health. If there are improvements to be made, those improvements will be recommended. It looks overly defensive, the fact that the administration are saying, no, there's too much transparency. It makes no sense. Why not let that review happen and find that there is no problem whatsoever? Surely that's the most transparent and would be a complete vindication of what the administration is trying to prove. Instead, we have this defensive and illogical proposition that there is such a thing as too much openness. I can only comment on my own personal experience when I attended the planning strategy group. I was not made to feel welcome, Chair. When I walked in, I was told that when I asked where to sit. I was told that I couldn't. Then I was told I'd have to apply to the chair to go and to be allowed to stay there. Fortunately, the Democratic Services Manager, as the knight on a white steed, came in and said I was allowed to be there, which is very kind of him. But if it hadn't been for him, the officers in the room were all for kicking me out. I have absolutely no idea why, as a councillor, I was not welcome in that room when they are making policy decisions that affect planning decisions. I do agree with Councillor Bithell that we need land for houses. I may have misread this notice of motion. I don't think anywhere in it said that we shouldn't have land for houses. I think it's talking about making the process transparent. So I mean, it's a glorious straw man argument he's constructed, but I think we're a little bit too early for bonfire night. Thank you, Chair.
Thank you. Can I now bring Councillor Healy?
Thank you, sir. I'm opposed to this motion, and I'll explain why. I think society has become much more adversarial than previously used to be the case. And in addition to that, misinformation online has become prolific. And this, in addition to the fact that people in various areas, in all areas, get extremely hot under the collar, almost foaming at the mouth, if there is a planning application near where they live. And I think this situation puts members of the planning authority who have a legal responsibility to do their job in a position where reprisals and intimidation can take place. I think it puts them at risk. And we've seen nationally how politicians and a former politician have been murdered because of the change in the nature of society. I'm not going into, but I think several people will understand why society has changed and it's become much more adversarial. Can I give you an example of the misinformation that is possible with regard to a housing case? There is a development on a former Spectrum site at Kevin Bay where houses are going up. And online, the comment was made, Flintshire County Council intends to house migrants there. To my knowledge, there was absolutely no truth in that assertion, but it nevertheless inflamed opinion, with people jumping in and saying, we're being invaded. And so it went on like that. Who is the councillor for that ward? And people were asking questions like that. Now, when you've got an environment like that, where there is misinformation and there is people are wound up and antagonistic and adversarial, much more than was previously the case, then I think we've got to say that settling this issue in planning by a show of hands rather than a roll call is entirely appropriate, particularly as people get hold of the list of how people have voted and put it online, especially so that those who have voted for housing in that particular area can be intimidated. Why else would they want to do that? And that is what we want to avoid. So if one committee in this council where settling it by a show of hands is sufficient, it is planning.
Thank you, Councillor Healy. Very good. Councillor Ibbotson.
Thank you, Mr. Chairman. Here we go again. Let me first address my concerns over something said by the Deputy Leader earlier in this debate when he said that changes had been made at the June planning meeting. The June planning meeting was cancelled according to the council's meetings calendar. The minutes approved in July include reference to a discussion at the May meeting, a discussion, I might add, for which there are no papers publicly available, and the minutes say, in their entirety on this section, the service manager development explained that a change to proposals was being made whereby any recommendation would be moved and seconded after the report had been presented and after any other speakers had delivered their comments, and that there had been an opportunity for the committee to debate the officer recommendation. So that is the service manager explained, not the committee determined. And it doesn't say anything about voting. So did the committee decide this? When? It wasn't in June, and the minutes say it hasn't happened. So when we talk about secret, there we go. There is the issue of, intimidation. I won't have anybody decry intimidation and threats or try to tell me about those, because, you know, I'm sure everybody in this chamber has been on the receiving end of similar. It is a risk in this line of work, and it's one that we all consciously accept because we believe that we're achieving something positive. However, earlier in this meeting, the other deputy leader said that we all ought to be proud of what we do. We all ought to take accountability. He was very, very animated when he said it, but now that seems not to apply. The question is, given that we've just changed the ballot rules, will we start having ballots at planning committee? And so it'll all be done in secret. Nothing to stop them now. So this change has taken place without any minutes of it having happened, on a date when planning committee didn't seem to meet, and without any resolution of the council. The minutes clearly say when something was resolved by the committee, there is no resolved on that section. Now, the council's procedure rules say planning can set its own procedures. Planning clearly had set its own procedures because those procedures were procedures. They have been changed, and without that decision being made by the committee. It is not delegated to Planning Strategy Group. Planning Strategy Group, which I might add, and Councillor Coggins-Cogan has commented about how he was made to feel about as welcome as a fart in an astronaut suit there. The rest of us haven't even been invited. We don't know when these meetings are taking place. Ordinary members aren't told. We've asked. We haven't been told. We've been told that any member can attend by the chair of planning committee, but we've not been told when they are. So to say, oh no, this is all open and transparent is, frankly, for the birds. Now, I'm not going to go into detail about what Councillor Bithell said, because I think that Councillor Coggins-Cogan has already seen to that quite thoroughly. And I thank him for sparing me the hassle of having to do it. But I will mention that Councillor Healy described residents who object to planning applications as, and I quote, foaming at the mouth. I don't think that that is appropriate for us to talk about our residents like that in respect of planning decisions, or indeed anything else, quite frankly. But it is of a piece with something his party colleagues said about the crap from Mancott residents. And so when he described objections, or when another colleague from the coalition announced quite happily that they hadn't read the objections, these kind of statements are what brings the council into disrepute. And then to make decisions in secret adds to that. Now, let me just sum up by first of all noting that I will be asking for a recorded vote at the end of this. And secondly, I think that it is vitally important that when planning decisions are made, we do it in a clear way. But this motion is about seeing whether there is any there. It is about investigating how changes have been made and whether that was done through a proper process. Nobody has been able to reassure us that it has been. And the minutes that I've read out confirm that. So what do we know? Well, nothing, quite frankly. So why would we not take proper steps to look at that? I move that the vote be recorded, Mr. Chairman.
Thank you very much for that. Obviously, we'll need 10 people to stand up if you want to do that. 1, 2,
We
3,
appear to have 5, Chair.
5. Anybody online?
6, 7.
6, 7.
We've got 7, Chair.
7, that's not enough.
Oh, 8.
8.
No, still not enough, though, Chair.
No. So no recorded vote. And I will bring Councillor Ted Palmer. He's been waving his hands. Sorry. Please, Ted.
Thank you, Chair.
So Ted, you're on.
Yeah, thank you, Chair. First of all, I take exception to the language used by Carla Stillson about a man in a spacesuit. Secondly, I've been on the planning committee virtually most of the time I've been here. I've never had one secret meeting. Never. Never at all. If you want people to be recorded on the planning committee, then everybody should be recorded on every committee. If that's what you're saying, why just the planning? I won't be supporting this.
Thank you, Councillor. Councillor Ellis.
Thank you, Chair. I would support this as a member of the planning committee. I see no harm in having a review of all the situations and all the things mentioned. If there is no issue, well then, like one of the other councillors has said, it can come back to say there are no issue. But I can recall that regarding the roll call, the meeting back, I think it was in May, where the changes were made to the way the voting was recorded, there was no explanation to councillors before the change was made. It just went from normally being roll call to a show of hands. We had an explanation after, because I was one that challenged to ask, well, why? I think Councillor Parkhurst was another councillor on that committee who challenged. But we're just basically asking a question, why is it changed? Why haven't we been notified? Because we weren't notified. So yes, we're told the decision is made in the planning strategy group. But then there's no minutes, is there, or anything to go back on. And when people talk of intimidation, I can hold my hand up and I can say I've been intimidated. My family's been intimidated. My property was burnt. £56,000 worth of damage. Well, was it because I was a member of the planning committee? Maybe. I don't generally fall out with Joe Public in any shape or form. I've got no enemies, as far as I know. The properties near me have a similar hedge. Why was I picked on? Police could never answer that. There was CCTV showing quite plain and quite clear that 2 people actually went alongside the gate with a rag soaked in petrol to light it up at the part where it would set light quickest. But was that because I was on the planning committee? Might well have been, but we don't know, do we? So yeah, people do get intimidated, and I will say it's not on planning. I've been on planning for years and years, and I'm not a mega expert like some councillors who are really into it and very good. But there's been landfill applications on the ward that I represent, very many. So I can actually say I have been intimidated previously as well, with a knock on my door when there were lots of landfill applications, because I was on planning committee or because I spoke out against an application. So I think, you know, people need to realise, I can understand why some people don't want to be on planning, because it is very controversial. And I think that needs to be noted. But therefore, I'll go back to what I was saying. I would support this for those very reasons, so that it is transparent, so that we're not all accused of taking a brown envelope, taking a bung, so that people can actually see what it is we do and that they're open and transparent. Thank you, Chair.
Thank you. Councillor Smith, you've spoken already on this subject, so you won't be speaking. So this is a point of explanation. Is that allowed? That's allowed. And after that, Mr. You wanted to speak, so we just want to get this to a point now. We're getting very close to my bedtime. So it's, because I'm only young. So we'll do a few more speakers. What we'll do is we'll do your points of explanation, Councillor Bithell. Keep them brief if you possibly can, and then we'll move on to one or two others, which will be Councillor Marshall and Councillor Priest. Thank you. And have you spoken on this?
There's a point of clarification on what
Okay,
comments have
so
been made.
let's get Councillor Bithell on the frame. Thank
Yeah,
you.
just one or two corrections. Members of the council can attend PSG meetings. They have got experience of that. They can sit in and listen to the debate and the discussions. Secondly, any recommendations made by PSG has to go to the Overview and Scrutiny Committee and the Cabinet. So there's no secrecy there. They all come out at the end of the day. So I just want to correct that. It's not conducted secretly in that sense. Again, we have not changed the voting procedure. What happened is that every other committee reverted after COVID to the usual system by a show of hands instead of having to go at a kind of recorded vote, a roll call. And for whatever reason, Chair, that didn't happen in planning. It should have done.
Councillor
Because
Bithell,
it's
this
the
has
same
gone
as any
beyond
other
personal
committee
explanation.
in that sense.
Sorry.
Thank you.
Thank you very much indeed. Was that your point of order? Great. Councillor Priest, then Councillor Marshall.
Thank you, Chair. I'm very much in support of this motion. Words come to my mind that we all should remember here. Transparency, accountability, capability of commanding public confidence. Now that's a big thing that we need to remember that we're doing here. The best thing that I've always said to people when I was teaching or whatever is communication. When there's a breakdown of communication, you've lost it. It can be within businesses, within anything that you do. Communication is the forefront of everything that you do. This, where it comes to this transparency, there are issues here that probably need to be reviewed. It's very simple. As somebody who was part of Estin for years and years and years, that's what it's all about. Internal audits. You know, I did audits for stakeholders for the college, and it's all about transparency and seeing what everything is about. And when things are kept behind doors, there are rumours, there are things. And when everything is put in the open, everything is fine because it is written down, it is recorded for everybody to see. Oh, that's what happens. That's the process. That is what happens. When it's behind and everybody can't see what's going on, that's when there's issues. Like there's no dates of publication for the strategy committee. There is no minutes that anybody can see of that meeting. Those are the type of things. Just for clarification, I've been dropping into planning meetings for years, and this is way before COVID, and they were recorded votes. I have never ever, correct me if I'm wrong, this was before COVID. It was, Gareth's telling me I am wrong there. Well, I am wrong. I apologise for that if that's the case. But this is what we've got to do. If we had a review, that would actually clarify that then. So going forward, that's what we need. Just a review of this going forward. And if there is no issues there, there's nothing to hide behind the door or under the carpet or whatever. I'm 100% for this, and I think everybody should vote for it. Otherwise, they will think there is something hidden under the carpet, etc. So please vote for this. Thank you.
Thank you. Councillor Marshall.
Thank you, Chair. If you don't get your information from social media, you're uninformed. If you do get your information from social media, you're misinformed or disinformed. Councillor Davidson there made reference to Gladstone planning application where I said, he says I didn't read any objections. if he takes the time to look at the recording, he'll see that what I said was I didn't read any of the emails, which was about 165 of them. The reason was the single source of truth is on the planning portal. The objections there are recorded, they're redacted, they're available to anybody to see. My recollection is there were 686 objections recorded on there, some with multiples. It's very difficult, and Councillor Livingston should try it for himself. Just do it for yourself. Spend 2 weeks on it, maybe 3, to read them all. So you can go down it. I estimated using spreadsheets that it would take about 13 8-hour days to go through it.
Councillor Marshall, there's a point here, isn't there?
Yeah.
So could we get to it then?
I'm against this this motion, so I
Thank
just
you.
wanted to make that clear.
Very clear.
can
Thank
read
you.
that.
Richard Jones.
Or a point of clarification.
Indeed. So Councillor Jones, you had a point of, you were actually behind the list, so you have a point of clarification.
Thank you, Chair. 2 members at least have said that the planning strategy group makes planning decisions. Councillor Coggins Cole was one, and I think it was alluded to, but yes, he did.
What is this?
He mentioned
What
planning
is this?
decisions. So
What is it?
PSG,
No.
PSG cannot make.
Actually, just
Cannot make
Councillor Jones,
decisions.
Councillor Jones, just please just desist
It's
for a little moment.
clarification,
I
Chair.
ask you to desist, I'll switch you off. Not obviously physically, but that would be a bad thing. But what we're saying is, indeed, you're trying to make a point of personal explanation or clarification.
Clarification on what I said. I said that PSG provided guidance. It does not make decisions, and that's the point. It's a very important point, Chair. All they do is provide guidance to, in certain things like planning performance, DM performance. They'll look at appeal decisions. There is no decision making by PSG committee. It's a work group. It's a PSG planning strategy group. It
So
is
that's
not
the
a
point. That's
committee.
your point of or clarification.
It is not
or
a
explanation.
committee, and it doesn't make decisions. It just provides guidance and commentary.
Thank you. In a
The only
nutshell.
place that decisions are made is the planning committee
In
itself.
a nutshell. Thank you very much.
Thank you.
Montreux, you wanted to make a comment, I believe.
Councillor Jones, your microphone's still on.
Still
Thank
on,
you. Chair, a number of people have made points about planning strategy group and about not being able to see when the meetings are. We have a calendar of meetings. Meetings are on the calendar of meetings. We have mod.gov. They are on there. They are not public. They are available to councillors because it is an internal group. Now, the notice of motion talks about publish, and they are not public. But I do want to stress that they are available to councillors. There are minutes, and if you go and look on mod.gov, you will find the minutes and the meetings and the reports dating back for years. But they are available to councillors and not to members of the public. Now, this notice of motion talks about publish, which is about public. Yeah, but so there is a subtle distinction here that just needs to be recognised, I think.
Thank you. Do you want to have some sort of little tittle-tattle row about things or not? Well, I'll say it a bit more loudly. I assume you're going to say something in contradiction to what somebody else just said, or not? Do it then quickly, please. Thank you.
Thank you, Mr. Chairman, and I shall endeavour to make an explanation, an actual point of personal explanation. Councillor Marshall said that I had accused him of not reading the validly submitted objections. I feel that he has misunderstood me. What I said was, as he said, secondly, in his summing up, that of those on the planning portal, those emails on the planning portal, he didn't read all of them. Now, he said that he estimated it would have taken him 3 weeks. Therefore, he didn't read all of them. He just estimated how long it would take him to. That's what he said consistently. I am happy to clarify for Councillor Marshall when he suggested that I had accused him of, suggested I had wrongly accused him of not reading all the objections before voting, and that this somehow only applied to emails received outside the portal, that I was only quoting his own words and that it is, I think, wrong for him to accuse me of being disingenuous on this.
Thank you very much. Now, what I was, I'm not actually going to be engaged in a conversation or a debate that happened months and months ago. What we've got now is a notice of motion that needs to be finished. And so the last person to speak on this will be Councillor Swash, who originally proposed this. So Councillor Swash, it's hard to say that. Councillor Swash, the floor is yours.
Thank you, Chair. That was certainly an interesting debate. I don't think I'm going to have time in 5 minutes to deal with every laughable straw man that's been erected in response, but I do want to deal with some of the more remarkable contributions. Councillor Richard Jones told the council that the decision to remove roll call voting had been agreed at the June meeting of Planning Committee. Of course, there's just one small problem with that, as was exposed by my colleague Councillor Ibbotson. There wasn't a June meeting of the Planning Committee, it was cancelled. So we've had a speech asking members to reject a motion on the basis of a meeting that never actually took place. You couldn't write it, from the Deputy Leader of the Council no less. If it wasn't so serious, it'd be funny. Indeed, Councillor Jones rather succinctly illustrates why a review such as the one asked for in the motion is so important, because it would establish the facts instead of relying on the incorrect assumptions of poorly briefed cabinet members. Councillor Jones also told members that residents can simply watch the webcast to see how councillors voted, but again, that simply isn't true. The webcast does not show every councillor when votes are taken. Residents cannot reliably determine how every member voted by watching the recording. It tends to only show the chair whose microphone is on, so they cannot see how everybody votes. Again, another untruth. If they could, there would never have been any need for roll call voting in the first place. He then devoted part of his speech to explaining that the Planning Strategy Group isn't a committee when nobody even suggested it was. It was a lengthy answer to a question that nobody asked. Councillor Lloyd then suggested that publishing voting records amounts to defamation of character, which frankly I found extraordinary and offensive. How elected members vote is a matter of public accountability. Democracy doesn't end when we just walk out the chamber. Residents have a right to know how their elected representatives vote. That's not defamation. He also urged members to vote against the motion, yet offered no convincing explanation as to why review of these issues should not take place. So, I mean, I'd simply ask Councillor Lloyd one question. Was he present at the private meeting which took place following a recent meeting of the Planning Committee? Yes or no? If he was, perhaps he could explain to residents why a meeting of that nature should take place behind closed doors, and why asking for those arrangements to be reviewed is apparently so objectionable. If he wasn't, perhaps he should be a little bit more cautious before dismissing concerns that have been raised about transparency, indeed by other councillors who were at that meeting, and I'm pretty sure he was himself. Councillor Bithell told us that the current arrangements are perfectly open and transparent. Again, given that we know now that a private meeting took place after a recent planning committee, I would love to know how that's perfectly open and transparent. How is a body whose meetings are closed and whose agendas and minutes are not routinely published perfectly open and transparent? If that's anyone's definition of transparency, then words have clearly lost all meaning. And Councillor Bithell also questioned my support for house building. And let me be absolutely clear, I support building homes that local people can actually afford in the right places, particularly social housing and genuinely affordable housing. What I do not support is dressing up offensively inadequate levels of so-called affordable housing provided in the LDP that he supported, as if it somehow resolves the housing crisis. And what struck me about the debate isn't what has been said, it's what hasn't. Speaker after speaker has attacked me, they've attacked my motives, they've even attacked, and not for the first time, the residents of Flintshire. But the simple question is, if there's nothing to hide, as members of the coalition have continued to insist there isn't, why are you so petrified of this motion? I wonder. If everything has been done properly, then the review will say so. If the current arrangements are as open and transparent as we're led to believe by the coalition, the review will simply confirm that. So why would you oppose it? Why would you oppose that? It's a simple choice. You can vote to establish the facts, and a hint there is they aren't the facts provided by the Deputy Leader, or you can vote to leave these questions unanswered. To us, to the councillors who weren't in those meetings, to our residents. And if you choose the latter, residents across Flintshire, as I said earlier, will inevitably ask themselves why there was such a determination not to let the facts be examined. As I say, and I'll say again, if there's genuinely nothing to hide, there is absolutely nothing to fear from this motion.
Thank you, Councillor Swash. Thank you very much indeed. I believe the monitoring officer would like to make a comment before we go to the vote.
And apologies for coming in after the Councillor Swash has exercised his right of reply. I'm the monitoring officer. I get rights to see all information. I've got rights to see information on the mod.gov that doesn't apply to every member. So whilst they are published and they're available, I don't think members would be able, you would be able to see when the meetings are on the committee on mod.gov, but you might not be able to see the papers. So apologies for that, Chair.
Thank you very much for the clarification.
And it just reaffirmed, you know, I made the point anyway at the time when I said it, we were talking about differences between internal accessibility and public. And I know that this is a point about public accessibility. But yeah, I've got access. Apparently I've got access that other people don't have because I'm the monitoring officer. But access could be arranged. Yeah.
Okay.
So that people can see those papers.
That could be, so nothing to do with this meeting, but in that sense, but it's so access can be arranged.
Yeah. It doesn't alter the point about public though. Public access.
They can't see it.
That's for this notice of motion, Chair.
Okay, so we've had the last speaker on this, which is Councillor Swash. That was his summing up speech. And now I believe we can go to the vote for this notice of motion. Oh, we have an echo there now. Sorry. Right. So by show of hands, all in favour of the notice of motion.
And then online 10 in favour, Chair.
10 in,
11.
11 in favour.
Late one there, Chair.
That's
11.
including online and in the room.
Yep.
People against this notice of motion.
Okay, that's more than 11.
It's a lot more than 11.
Chair. 1, 2, 4, 6, 8, 10, 12, 14, 16, 17, 18, 19, 20, 21, 22.
Any abstentions anywhere? One. Thank you very much, Councillor. So that means this notice of motion has fallen. Is that clear our business for today?
That is it, Chair.
So the good, we're finished now, unless there's any business.
Mr. Chairman, I would ask that my vote in favour of that motion be specifically minuted. And I believe to avoid an I am Spartacus situation, I can speak for my Flintshire People's Voice colleagues in confirming that we would all like our votes in favour of that motion specifically minuted.
Thank you very much. So that being the case, that concludes this 2 minutes past 8 meeting. So there we go. Thank you very much for your attendance and for your contributions.
All rise, please, for the chair.